Why is Ruff up there?
I have no idea. Where's Jocelyn?
Set his laptop down.
Jocelyn? Oh. Good afternoon. It is Tuesday, March 4th, and we have quite a few bills that we're going to hear. This is the House Judiciary Committee. We're going to begin with the chair of the Health and Government Operations Committee, Delegate Pena-Melnick, who is here with House Bill 1084. We will hear from her, Eric Galley, Larry Polsky. There are a number of people who are favorable with amendments. Well, that's fine. We'll go from there. Totally fine. Off you go for 3 minutes.
And Vice Chair and members of the committee, I'm pleased to present to you House Bill 1084. So House Bill 1084 is a bill that does the following. It actually will require us to fund the MAT program. So you're wondering what is it? MAT programs are a critical tool in our response to the opioid crisis, reducing relapse rates and supporting recovery. We passed a law that requires us to fund it to all the local jurisdictions, all 24 of them. What is the problem that this bill is trying to fix? We haven't funded. And guess what? The local jurisdictions are the ones that are paying it, and we have not, the state have not been paying it. So this bill in front of you is a consensus bill. It took a lot of work to come together and for people to compromise on what everyone is going to do in order to make sure that the local jurisdictions have the money. As you know, people that are incarcerated have opioid problems, right? And when they come out, if you don't address it, the recidivism rate, as you know, in this committee is very high. They end up back in jail. They need the treatment. And this bill does that. And if I may, Sarah Sample will outline the bill's provision and address the fiscal impact. Ms. Bethany Young from the governor's office will discuss the agreed upon amendment, and Special Secretary Keller will highlight the consensus achieved by this legislation. If I may have Ms. Sarah Sample first.
Thank you, the chair, members of the committee, for having me. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support this bill, House Bill 1084. To address the provisions of the bill and the fiscal impact, I'll start by saying that this is establishing a more efficient structure to make sure that the state is able to get into compliance on funding local detention centers for the medication-assisted treatment programs. One of the things that the bill starts out by doing is outlining what the buckets of money are that we can leverage to make sure that this funding is getting through. So you have grants that can be provided by the state. You've got discretionary funds from the Opioid Restitution Fund, and then also any funding appropriated in the state budget. On the state's end, the Maryland Office of Overdose Response is required to reimburse the local detention centers for the program costs locally from the Opioid Restitution Fund, but that is after all local requirements have been met. And so to go through what those local requirements are, a county has to demonstrate an attempt to secure at least one eligible grant for funding of the program. We have to submit all of our total annual itemized costs to the Maryland Office of Overdose Response so that they understand what our programs cost. And then we also have to comply with all of the reporting requirements that are established by MDH and GOCAP and the Maryland Office of Overdose Response. We have to do that by a specified date that is in the bill. And then to clarify the fiscal impacts, this will not have general fund impact because the funds that are going to be paying for this are coming from grant funds or the Opioid Restitution Fund. And we have also confirmed with the agencies, and you'll hear that again today on this panel, that they have confirmed that they are able to comply with the provisions of the bill within their existing budgets. So with that, I'll hand it off to Bethany Young from the Governor's Office of Crime Prevention and Policy. Thank you.
And if I may, Mr. Chairman, I have requested the amendments and they have been submitted to Judiciary. Thank you.
Yes, good afternoon, Chair, Vice Chair, and members of the committee. My name is Bethany Young. I'm the Director of Policy for the Governor's Office of Crime Prevention Policy, or GOCAP. GOCAP advises the governor on criminal justice strategies, coordinates across public safety agencies, and allocates resources statewide to support public safety. I'm here to offer GOCAP's testimony in support of 1084 with amendments. GOCAP's role in this process, as outlined by current law, has been implementation monitor, data collector, and reporter. We've also provided technical assistance and funding to support implementation. I'm going to focus my testimony today on the substantive amendments supported by all agencies, including the Office of Overdose Response, the Department of Health, GOCAP, as well as MACO. First, the bill's current draft eliminates the requirement that jails provide all 3 FDA-approved medications for opioid use disorder. The First Amendment would retain that requirement for all 3 medications. Second, as currently drafted, the bill would allow counties to recoup the entire cost of implementation from the Opioid Restitution Funds, or the ORF. Because other state funding is available for this purpose, and many initiatives do and will rely on the ORF, the Second Amendment requires counties to demonstrate an attempt to access grant funding through GOCAP and MDH before they can access that complete payment through the ORF. This will ensure the ORF can support as many important efforts as possible. Finally, to ensure GOCAP receives the data required under current law in a timely and complete manner, the Third Amendment would withhold 20% of that reimbursement through the ORF until counties comply with, if counties, don't comply with the required reporting by the established deadlines. Providing local correctional facilities the resources necessary to treat opioid use disorder will improve public safety and public health outcomes. GOCAP strongly urges a favorable report with the amendments described today. Thank you.
Thank you, Chair and members of the committee. My name is Emily Keller. I'm Maryland's Special Secretary of Overdose Response, and I'm speaking today in favor of House Bill 1084 with the proposed amendments. At Maryland's Office of Overdose Response, we recognize the vital importance of providing substance use care in local detention centers as required by state statute since the passage of the Opioid Use Disorder Examinations and Treatment Act of 2019, also known as House Bill 116. These services are life-saving for incarcerated individuals who are disproportionately impacted by substance use disorder and are at higher risk for overdose. Since the passage of House Bill 116, Maryland has worked to provide local jurisdictions with financial support through various means to help meet the requirements of House Bill 116. The state currently offers multiple grant opportunities to fund medications for opioid use disorder treatment programs in local detention facilities, including grants from the Governor's Office of Crime Prevention and Policy, the Maryland Department of Health, and our office. Despite this, we recognize that funding these services continues to be challenging for our local partners. House Bill 1084 would enable the state to direct prescription opioid settlement funds to fill the gaps in local efforts to fund substance use services in detention centers. Using settlement funds in this way is both an allowable use under the National Settlement Agreement and a recommendation of the Opioid Restitution Fund Advisory Council. As such, our office would welcome the use of ORF funds in this manner. However, as the ORF administrator, we must be a good steward of these funds on behalf of the public. Not only is it nationally recognized best practice not to supplant other funds with prescription opioid settlements, it's prohibited by state law. This is why we support these amendments to require local jurisdictions to seek at least one source of grant funding through the state prior to receiving ORF funding to expand substance use services for incarcerated individuals. We believe that House Bill 1084, as amended, represents the best possible outcome. We ask for a favorable report.
Mr. Chair, Madam Vice Chair, members of the committee, my name is Larry Polsky. I'm here on behalf of the Maryland Association of County Health Officers in support of HB 1084. I served on the original work group for this bill at the request of then Delegate Eric Barron in 2017. As a board-certified obstetrician, I've personally evaluated and prescribed medication for incarcerated pregnant women with opioid dependence for over a decade. The Maryland Association of County Health Officers agrees with MACO and others that many opioid-related services in detention centers should be funded through the Opioid Restitution Fund. In addition, health officers urge the committee to amend page 3, line 33. Currently, law requires treatment of pregnant women, quote, as soon as practicable, unquote. Optimally, pregnant women should begin medicated-assisted treatment within 24 hours to prevent opioid withdrawal and minimize risks of fetal harm, including preterm labor and fetal death, as recommended by the American College of Obstetricians and Gynecologists. The language in the original law was chosen as a compromise when the potential burdens on detention staff were unknown. We now have close to a decade of experience evaluating and treating pregnant women for opioid use disorders in detention centers. In my rural county, this amounts to 1 to 2 inmates per year. At that rate, even the largest counties or jurisdictions only have 1 to 2 pregnant individuals per month needing medication treatment. Ensuring pregnant women have access to treatment within 24 hours of incarceration should not pose a significant burden to detention facilities. In addition, we are now in an era when any physician or nurse practitioner can initiate 48 to 72 hours of buprenorphine treatment as a bridge to longer-term care with behavioral health providers. This routinely happens in primary care offices and ERs across the state. Medical providers working in detention centers can provide the same bridge care. This would further decrease work for detention center staff since no outside referrals would need to occur until the next regular workday. The Maryland Association of County Health Officers thanks you for your consideration. For changes in the current statute will both ease financial strains on detention facilities and improve the health and safety of pregnant women and their children.
Thank you. Mr. Galley, are you a Me Too?
Yes, me too.
Me Too for Mr. Galley. That's a great lesson all of us should learn, right? All right, well, I'll keep trying. All right, so questions, Delegate Arikan?
Thank you, Mr. Chair. Thank you so much, Madam Chair, for being here. I'm so sorry. I don't know a lot about how Medicaid and Medicare work because I'm not on that committee, but could you just explain to me why do our men and women living on the inside not have coverage through something like that? Why is our treatment not being covered in that?
You get it when you get out.
You're not only eligible when you get
Yes.
out.
And usually, we did pass a bill that allows them to be screened while they're inside, and it allows them to have an ID, a photo ID, when they get out as well.
Okay, so that's a federal law?
Yes.
Okay, all right, thank you.
Thank you, Mr. Chair, and thank you, Madam Chair, for the bill. We worked on this subject for many years. I just have two questions for you. One in particular, I noticed that when someone is released from being incarcerated, they're still eligible to receive the medication under the purview of the Department of Corrections. How long does that continue?
I am not aware of how long that lasts for. I do know for the local detention centers, they typically will send them out with their first prescription, and then they do also have a way of checking to make sure if the prescription is filled, and we had been finding that the prescriptions on the majority of times were fulfilled. But I would also think it's important to pose that question to Director Klein, who's going to be coming up after us.
To who? I couldn't hear you.
Director Klein, who's the Detention Center Director for Anne Arundel County Detention Center.
Okay, sure, thank you. And then the second one is, do you have county by county of how much is already being taken out of their budget to pay for this? Because I know the counties will be certainly supportive of receiving the funds to help in this capacity, but what does
Yes,
it look like that they're doing now?
Yes, I do have that. I don't have it in front of me right now, but I can definitely get that to you. But I can give you a sense that for some of our smaller jurisdictions, it can be anywhere in the range of about $200,000 to $400,000. Some of our larger jurisdictions, though, aren't much higher than that. We've got Prince George's County, and I believe it's Montgomery, no, not Montgomery County, Prince George's County and Anne Arundel County are in the range of about $450,000 to $550,000 annually. But then we have a few others that are a bit higher in the range of $600,000 to $900,000. But we have estimated that this is about $11.4 million annually statewide. So
If I may, on page 5 of the fiscal note, it says that MACO previously advised that the majority of the local correctional facility MAP program costs between $200,000 to $500,000 annually, with the exception of Baltimore County, whose program costs $2.7 million annually. So for a total annually of all of them together of $11.4 million.
Okay.
And the only thing I would add to that is that the number of individuals in your program can fluctuate throughout the year. So even within those estimates that we have by the local jurisdictions, it's driven by how many people are in the program.
Okay, and cancer and kidney treatments, how does that fall into any of these categories? Not this at all, right? But I'm just thinking about medical in general, and you don't have to answer that right now, but I just remember that was one of the questions that came
Yeah,
up.
so this is just for the opioid.
Right.
Right, not health related.
Right, okay. Thank you so much.
You're welcome. Thank you for the question.
Now, with hard-hitting questions for her own chair, Delegate Hill, sitting in Delegate Grammer's seat.
You may have to keep her after this, Mr. Chair. And then you get Delegate Grammer.
You can have grammar? I mean, it's fine. Delegate Hill.
But thank you, Madam Chair, for the bill, Mr. Chair. This is actually a question for Ms. Young. So you talked about the amendments, you talked about the 20%. I just want to be clear, because the bill as written now says that there's a 20% deduction if the reports aren't timely, but that is 20% for every 30 days So are you saying the amendment is just a flat 20%?
So what the amendment does is it ties that 20% also to reporting due to GOCAP. So the bill is currently drafted, I believe, ties that 20% to the reporting due to more, the Office of Overdose Response. The amendment ties GOCAP's reporting in as well.
But it's the same report, so they just have to.
It's different. So I think more will receive like the itemized cost and I think the average days people were on treatment. GOCAP's required reporting is a lot more extensive. I think there are like 17 discrete items that GOCAP has to collect and then report on from each correctional facility that administers this program. So the amendment would tie that 20% reduction also to the reporting due to GOCAP.
And that's also every 30 days is 20%, so
Yes.
60 days is 40% and so forth? Okay, and I guess the final question is, so for 6 years it hasn't worked, and this is such a heavy penalty, is it because the reporting wasn't being done, it wasn't working? Is that why we're coming down so hard on the reporting?
I don't know that the reporting is the reason for implementation challenges. I think what we've heard from the counties is that funding has been the primary challenge. And then, Sarah, do you want to?
Yeah. So I can also offer, because I was the one who originally drafted the bill, that we were putting that in there as a give to make sure that you would get that reporting, otherwise there would be a consequence. Not that it wasn't happening, but just we understood that the state was giving us potentially access to reimbursements where they haven't been coming before, and we wanted to make sure that they felt like they had some teeth to make sure that we're complying as well. So it was more just a negotiating element to make sure that they felt like we were giving something as well.
All right, thank you, thank you.
Elliot Kaufman?
Yes, Madam Chair, it's wonderful to see you.
Thank you.
And my question is this, and I could have missed it, but I didn't hear it in Ms. Sample's recitation of the amendments. Disability Rights Maryland has an amendment, so I wanted to see if you'd had a chance to review it and if you were amenable or not amenable to it. If not, I don't want to take the committee's time, but I can email your office their letter.
I have not seen it. I don't know if anyone else on the panel has seen it.
I have not seen it.
No.
Okay, I'll email you this. I'll email it to you afterwards. Okay, thank you.
All right. Seeing no other questions for this panel, we thank you very much. We have one person to testify in an informational capacity, and that's Ann Seacott, so we'll hear from her right now, but thank you all very much for
Thank
being
you
here
for
today.
allowing me to go first. Thank
Thank
you so
you.
much.
Apologies for the delay, but
It's okay.
Chair, we did have someone from the Wardens signed up as well.
I'm sorry?
Director Christopher Klein.
Oh, I'm sorry, yes, Christopher Klein, that's fine.
Wonderful, thank you.
We'll have you both come up. Ms. Seacott is informational testimony, Mr. Klein is favorable, or favorable with amendments. So Mr. Klein, why don't you go first for 2 minutes?
Thank you. Good afternoon, Chairman Clipperger and members of the House Judiciary Committee. I'm Christopher Klein, Vice President for the MCAA and Superintendent of Anne Arundel County Department of Detention Facilities. I'm testifying today in both of those capacities in support of House Bill 1084, Correctional Services MAT funding with the amendments. As a general statement, I want to share that the law only has value if it's enforced. While I do not want to belabor the point, the original legislation, House Bill 116, was introduced in 2019, requiring local detention centers to fully implement MAT programs within our facilities by January 2023. We did this. That bill also very clearly stated that the funding for these programs shall be provided for in the state budget. This never happened. I actually believe it was Senator McKay that received an AG's opinion that a local jurisdiction's obligation to provide these services, in their view, are contingent on the state providing necessary funding. It's my belief that if this law, as written, was enforced, there would be no need for me to be here today. While I do not know every detail of every MAT program implemented across the state, I do know that each of us continue to ask questions as to where and when we will receive the state funding for our programs. We also concur that the current options of each of us trying to piecemeal our funding together and seeking out grants that require more reporting are not guaranteed, unsustainable, and have us competing against each other, other entities, and in some cases, even our own counties, is not the solution and not what was intended. This legislation at face value will correct that. While I believe the State Budget Office could have made these funding decisions for themselves, they've willfully chosen not to. I'm thankful that this body has recognized that their failure to take action has caused our need to take action. I believe this bill still needs some work with the language clarity, however, it's necessary at this point. The cost of MAT programs and services come at a real price, but the alternative of continuing to lose individuals to opioid disorder is much higher.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. I'm Ann Seacott, testifying on behalf of the Maryland chapter of the National Council on Alcoholism and Drug Dependence. I want to say we understand what the amendments are to the bill, and we have absolutely no opposition to the amendments going forward and the bill going forward. I do want to do a little bit of history. If you all will indulge me, only a very small number of you were around, I think, in 2019 on this committee when House Bill 116 passed. NCADD Maryland was one of the lead advocates. We were very happy to have been joined by Delegate Polsky in those efforts. I want to say that while we recognized that requiring these healthcare services to be provided would need to be supported with other kinds of, with state funds or funds identified by the state, which is actually what the language in the original bill is, House Bill 116. It actually doesn't say that the state will pay for all of these services. It did say that the state would try to identify funds. And the state paid for these services for a number of years, largely from federal dollars. So the intent was always that eventually, and this is to the point that Delegate Arakan raised, that Delegate Sample Hughes raised, that this was going to be healthcare services built into healthcare contracts. These are healthcare services. Addiction treatment is healthcare. It isn't special. It's not add-on. It's healthcare. And we, again, fully support this bill moving forward. We need these services to get into place. But then we need this to be considered healthcare, and we would really love to work with the legislature if need be, and certainly with the correctional administrators and county governments moving forward in a few years to be able to accomplish that so that everybody can get the health care that they need.
Questions, Delegate Schmidt.
Thank you, Chair, and thank you, Mr. Klein, for being here. My question, I see your written testimony here, and the good delegate from Wycomico County brought up a question about the number of individuals, and we heard an answer that it varies. Do you know how many individuals this would help in Anne Arundel County?
Excuse me, Anne Arundel County, right now, we currently are serving 167 individuals on MAT, and that's divided between people on methadone and then the other group on Suboxone.
And is that a pretty relative number to what your normal rate is? Is it 167 the normal amount of people, or is it?
Yeah, our program's grown drastically since the full implementation in January 2023. Because we didn't have the funding, we had to sort of pilot how we were going to integrate. The legislation actually specifies that they have to have a program in each facility. So Anne Arundel County is unique because we have 2 facilities. So had the legislation actually said each department, we would have managed internally because we had a program since 2012 at Ordnance Road, but that forced us to add another facility component. So as we brought that online, it wasn't in our existing medical contract, so we had to partner with them to get the services. And then when we renegotiated our medical contract, then we were able to fully implement the full MAT services in 2023.
Okay, thank you. Appreciate your help.
Thank you, Mr. Chair. Thank you, Director Klein. It's just a follow-up from where I asked the previous panel. How many days after someone has been released is the prescription still applicable for their usage or paid for through this program?
Generally, depending on what a person has in their sort of, we call them stock meds, but what's been ordered for the individual, normally we'll let that person leave with the prescription that's that they have. I think with the Suboxone, though, I want to say probably 24 to 48 hours. But then we make sure part of that law is also connecting people for continuity of care. So we're going to set up people with release plans and make sure that we have those soft handoffs to the program. One unique thing about the program in Anne Arundel County is the van that comes into the facility to provide methadone is actually the community van. So they're already connected to that service, so they need to just be able to reconnect with that van in the community. But as far as their prescription information, their dosing and all of that, we've taken care of all of that up front.
Okay, thank you so much.
Seeing no further questions, thank you very much.
Thank you.
All right, that concludes the testimony on House Bill 1084. Now, we have a new member, and Delegate Stinnett is down here at the end of the horseshoe, and we want to welcome him to the committee. He is literally, I think, jumping into the deep end of the pool here a little bit late in session, but we're very happy that you're here, and if you have any questions, talk to the vice chair. All right. Or talk to me. Let's go to House Bill 499. This is an administration bill, and we'll hear from Miles Hicks from the governor's office, who will get the 3 minutes. Ivan Bates, the state's attorney, Baltimore City, Joe Jones, Aaron Haney, Harold Coleman, and Megan McDermott. All right, Mr. Hicks, you're going to go for 3 minutes. Everybody else is going to get 2. Make sure you're talking into a microphone. That would be nice. And we'll go from there. Mr. Hicks, please.
All right, good afternoon, Mr. Chairman, Vice Chair, members of the Judiciary Committee. For the record, my name is Miles Hicks, and I serve as Deputy Legislative Officer to Governor Wes Moore. I am here today in favor of House Bill 499, the Expungement Act, Reform Act of 2025. I'll start by just thanking this committee for all the work you guys did on the Abhishek bill last year. You passed it out of this committee, got it out of the chamber, and I look forward to continuing that work this year. And I also want to give a special thank you to the Vice Chair for her leadership throughout this process. House Bill 499 builds on this committee's work and the governor's executive clemency order from last year that pardoned 175,000 Marylanders convicted with that had convictions related to the possession of cannabis. The major parts of this legislation include reversing the Abhishek decision by the Appellate Court of Maryland, which ruled that people whose probation was unsatisfactorily closed after a violation cannot receive an expungement. This legislation would allow an individual who completes their probation or parole to be eligible for expungement. The second part of this bill would expand the list of expungible charges to include driving without a license, counterfeiting prescription, using a stolen credit card, obtaining property or services by bad check, resisting arrest, and making a false statement to an officer. A crosswalk of all of those charges are in my written testimony. The third provision would expand the list of dispositions that are removed from public view on judiciary case search to include stet charges. And finally, this legislation will remove all convictions included within the governor's cannabis pardon from public view on judiciary case search as well. Over the interim, you may have seen our administration start breaking down some of these barriers of access that hinder justice-involved individuals. I have already mentioned multiple times the mass clemency order, but I also want to remind you guys that we canceled the debt for outstanding mandatory parole, administrative release, supervision fees, and drug testing fees for individuals who are under the care of Department of Public Safety and Correctional Services. And today, we're here to continue those efforts with the advocates, the experts, the businesses, and those impacted people who are in favor of this legislation. These individuals and their respective organizations share Governor Moore's interest in ensuring that every Marylander has better pathways to work, wages, and wealth, that we're growing our economy, and that we're building a state that is more equitable and just. Again, I look forward to working with this body on getting this bill passed. Thank you for all the work, and I urge a favorable report on House Bill 499.
Bates?
Yes, thank you, Chairman Clippinger, members of the House Judiciary Committee. My name is Ivan Bates. I'm the state's attorney for Baltimore City, and thank you for allowing me to testify in favor of HB 499, Expungement Reform Act of 2025. I believe that we must hold individuals accountable, but I am a strong believer of second chances. The mission of the criminal justice system should include the rehabilitation of offenders who have demonstrated that they deserve a second chance. Allowing people to fully reintegrate into society after serving their time benefits not only public safety and strengthens our communities by reuniting families and providing shining examples of reform and redemption. For instance, say there's a young individual, 18 or 19 years of age, who stole a credit card and went on a shopping spree. They've now been sentenced to a year in jail and fined $500. 10, 12 years later, they've changed their whole life around. At this moment in time, that sentence is still hanging around their neck in a way that it hurts them in their future. This bill will allow us to go ahead and give that individual who worked hard to change their life a second chance. We also have to understand House Bill 499 would allow individuals like this individual to apply for expungement and removing those unnecessary barriers. One of the other things that's also important with House Bill 99, if it was passed, we can now allow reformed individuals to successfully expunge their records and pursue higher opportunities to reduce recidivism. The new charges eligible for expungement under this bill include nonviolent offenses such as fraud, related crimes, bad checks, credit card theft, false statements. House Bill 499 is a necessary reform that promotes rehabilitation, economic opportunity, and public safety. By removing the unnecessary barriers to expungement, we can empower people to contribute positively to society, ultimately making our community safer and stronger. Thank you.
Good afternoon, Mr. Chair, Madam Chair, Vice Chair, and members of the committee. My name is Joe Jones. I'm founder and CEO of the Center for Urban Families, a nonprofit based in Baltimore City that focuses on strengthening families and helping people achieve economic independence. While you have my written testimony, I'd like to personalize it with the story of a young man, Derek Liggins. Derek served about 8 years in prison. He returned home and he participated in our job training program called Strive. In 2007, he completed, and we asked the company, Mechanical Engineering and Construction Corporation, to give him a shot as a laborer. Since that time, Derek not only has earned his journeyman's license, he completed his degree in construction management. He manages multi-million-dollar projects for the company. He's married. He purchased a home in Baltimore City. In May of 2013, we hosted President Obama at the Center for Urban Families. The night before the visit, I spent time with the Secret Service and the White House advance team vetting members who would sit next to the president, helping him to identify ways to create more economic opportunity for people in Baltimore City and around the country. Derek was vetted by the Secret Service and allowed to sit next to the President of the United States. However, nearly 20 years ago, he gave a false statement during an encounter with a police officer. Because of that false statement, that charge, he can't have his criminal record expunged. Therefore, his employer has to restrict him to managing certain projects, and he is not allowed to work on certain government contracts because of his criminal record. This is a real example of a Marylander who's paid his debt to society, has given his all to his family and his community. And because of this, I hope you will consider Derek's story as you give a favorable report to this important legislation, House Bill 499.
Thanks. Chair, Vice Chair, members of the committee, thank you for this opportunity. My name is Erin Haney, and I'm the Chief Policy Officer at Reform Alliance, a national bipartisan organization that seeks public safety solutions through improving parole and probation. And what we've learned at Reform from passing 18 bipartisan bills across 11 states, red, blue, and purple, from Florida to Georgia, California to Pennsylvania, is that technical violations of supervision, like those that threaten to block a path to expungement, are not just detrimental to people on supervision, but they drive mass incarceration, they cost taxpayers millions, and they inhibit instead of further public safety. These violations, which usually come up from navigating the complex conditions, often occur when the person is doing everything right. You've navigated your check-ins with an officer, you've made it to work to earn money, to pay for the fines and fees you now have on supervision, and yet life happens. So while you're on your way home from work, you get on I-95, encounter traffic, and don't make it home in time for your curfew. Without HB 499, 5, 10, even 15 years of a commitment to rehabilitation and redemption would be blocked because of that one mistake of taking the wrong route home. Expungement benefits us all. It lowers rearrest rates for those who seek it, and it increases public safety. It's not just the right thing to do for people who are impacted by criminal records and who have done the work and deserve expungement. It's the right thing to do for us in order to create and increase public safety in our communities. That's why 24 states already rely on this as a form of relief and why we urge a favorable report on 499.
Mr. Cole.
Yes.
Yes.
Good afternoon, members of the committee, Vice Chair and the Chairman. I'm in here in support of Bill 499. My name is Harold Coleman. I support the governor's bill. I reside in District 10. For 16 years, I've worked at the Maryland Transportation Authority right here at the Bay Bridge as a maintenance technician. I often come to Annapolis to testify on criminal expungement bills to help people in my situations, like mine. My personal testimony, in 2023, I supported the REDEEM Act, which cut the expungement waiting periods in half, and I finally made my last charge for eligible expungement. I want to thank Chair Clippinger, Bartlett, and Wallstrike on the other side for sponsoring the bill. However, thanks to Abishag ruling, I'm barred from expungement due to a probation violation in 1988 and 1997, nearly 30 years ago. I want to thank members of the committee for their consistent conversation with me, and I'm looking forward to working with all of you to get this right, and I urge a favorable report.
Good afternoon to the committee. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid, where I represent some of the almost 2,000 clients we see each year for expungement. Since the 2022 Abishag decision, many of those clients cannot receive an expungement because they violated probation. Probation violations are very common. Data from the Division of Parole and Probation shows that 43% of those under general supervision in 2022 did not successfully complete their supervision terms. In addition to including 7 new charges on the expungible list and shielding stets and pardoned cannabis offenses, House Bill 499 provides a simple technical fix that clarifies once and for all that probation violations are not a complete bar to expungement. There seems to be a perception among critics that allowing probation violations to be expunged means that a person gets away with something or that they aren't really being punished. This is counterintuitive. Expungement is only available post-sentence. In other words, it's a remedy only after a person has been punished. Expungement is not meant to be used as a tool to make determinations about a person's behavior when their case was active. That already happened during the life of the case. If we do use expungement that way, if we do allow the Abishag decision to stand, we're in effect recriminalizing someone. We're saying that in Maryland, we want expungement to serve as a punitive tool instead of a redemptive one. I want to be clear that not everyone who applies for expungement receives it, and this bill does not change that. It does not in any way further limit prosecutorial or judicial discretion. In fact, the bill clarifies that restitution payments and probation success can be considered in expungement determinations. We urge a favorable report. Thank you.
Questions for the panel, starting Delegate Kaufman.
Yes, Mr. Chair, and if they're brief, can I have two questions? My first question is for Mr. Bates. Are you here as Ivan Bates or representing the Maryland States Attorneys Association? Because, okay, I'll let you answer and then I'll tell you why I was asking.
I'm here as Ivan Bates from Baltimore City, but if I'm not mistaken, I believe the Maryland States Attorney Association, we also support this bill with an amendment. However, someone will be here to speak on that.
Yes, Mr. Cox, Mr. Schellenberger's deputy, requested an amendment where in terms of, he said in terms of restitution, he said people should be able to, victims should be able to be made whole from someone who is financially able to do so just because the person received a PVJ. And then he goes into just changes that Mr. Cox wants to see on behalf of the MSAA. I wanted to know if you were amenable to that, since you signed up favorable and not favorable with amendment. And then I have a question for Ms. McDermott.
Yes, am I amenable to that change?
Yes.
Yes, sir. I do think that that change is important because victims need to be made whole if possible.
And then, Ms. McDermott, is that your name? Yes. You mentioned this legal thing is new to me. I'm a Medicaid expert when I'm not here. So you mentioned that probation violations are very common and about 43% of people violate their probation. Can you give some examples of common probation violations that make it so common?
Sure. I am a legal aid attorney and I don't practice criminal law, so I only see these folks after their cases are over. But in my experience, the legal aid clients, a lot of times when they violated probation, they were still actively using drugs. So they were arrested for something, they were found guilty for something, and a term of their probation was to stay clean. But they weren't ready to make that change yet for a variety of reasons, and they might have, had a negative drug test. That's a very common example. Other examples for legal aid clients, if you're low income, you often aren't very stable in terms of your housing. So people move a lot. They might forget to notify somebody. Probation officers also change a lot. So sometimes there's some confusion about who they're supposed to notify. Of course, someone can reoffend, and that can be a reason that there's a probation violation. If that happens, and the expungement statute does have restrictions around subsequent convictions that would address those issues.
And finally, Mr. Coleman, it's always delightful to see you. Thank you, Mr. Chair.
Thank you. I'm generally supportive of expungements, and this is no different, this bill. So thank you, Miles, for bringing it for the governor. I think this is probably for either you or for Ms. McDermott. But the automatic, or I don't know if it's automatic, but the elimination of the information from case search, specifically about that part of this. So we had some issues in the past, some of my clients and some clients of some other attorneys who've called me when we did expungements, automatic expungements in the past, particularly for cannabis, that it hurt the immigrant community and the non-immigrant community with being able to access the information so that they can prove that the case was disposed of correctly. My concern is if we are removing this stuff and they don't have access to it, are we going to hinder people who may be attempting to search for the information to show an employer, a potential employer, who may know that they were somewhere on case search at some point and now it's gone and they don't know what happened with the case?
Yeah, so I think that was a very long conversation that we've had with the judiciary, and I spent hours on it. When we were doing the mass pardons. I've heard those concerns. I think that's why we went with shielding instead of expungement. Shielding allows for law enforcement, those people that you're talking about, to still have access to it because it's not being deleted or obliterated. It's being shielded, and only specific people will have access to them.
Okay, thank you. We can just talk about this a little later. Thanks.
Yes, look forward to it.
Lily Phillips.
Thank you, Mr. Chair, and thank you, Miles, for bringing this, and thank you to all the panelists. I'm going to be very short. Mr. Coleman, yes, how many times have you been down here?
I've been coming down here since Obama was in office, pretty much.
It's been too many times, isn't that so?
Absolutely.
Thank you.
You didn't mean to be rude. We like it when you come, but we wish we didn't have to see you quite so much on this issue. All right, are there questions, further questions? Seeing none, thank you all very much. Oh, I'm sorry, Delegate Tomlinson.
Thank you, Mr. Chair. I was just looking at the list of some of the misdemeanors: assault in the second degree, or possession of stolen serial numbers, malicious burning of personal property, unlawful removing or attempting to remove human remains from burial site, racing a horse under a name other than its registered name. That's an interesting one. Haven't met anybody who's looking for that one, but I'm sure they're out there. No, but one of the things, and then even some felonies, including burglary in the first degree. One of the crimes that I was curious if anybody had taken into consideration, and I'm just scanning through this, so if I missed it, I'm sorry, were DUIs considered at any point? I know last year we passed out of this committee and passed overall. We allow now some expungements, but it's a very specific, narrow kind of field. I think, what was it? You had to have gotten a PBJ on your, PBJ? Yeah. So you can only have gotten a PBJ on your first, I believe that's what it was. But was that, did you guys ever look at that, on adding that to this list?
Yeah, we went through a number of different charges. The ones that we proposed in this legislation, I think, were, we received the best feedback from, or the most positive feedback from. A lot of those did come up, but this is what we think would be most impactful. If you look at the fiscal note, it has a number of, like actual numbers from the courts of who's going to be impacted. And I think this is just where we landed based off of just all the work groups and meetings that we've had with a number of folks.
I mean, I think that there would probably be a lot of people who would be who this could affect if DUIs was, if that was on the list as well. I'd like, if I could talk to you offline about that.
Yeah, I appreciate it. More than happy to talk offline.
Cool, thanks.
Seeing no further questions, we thank you all very much. Go to the next panel, the Mayor of Frederick, Michael O'Connor, Melissa Rothstein, Heather Warnken, Chris Sweeney, Chris Dews. And while we're at it, while we have 6 chairs up there, can I get any more? Also, we're going to take the 2 virtual people. Chris Sweeney is virtual. Stephen McDonald, okay. Is Trina Selden here?
She is
Trina
not.
Selden out for justice?
She was not supposed to testify.
All right, so no. Cam Bridges? Come on up, we'll let you. Just give me 1 second. All right, that should be fine, and I think that'll take us through the proponents. Whoever would like to go first.
I got this one covered. For the record, Christopher Dews from Cornerstone representing Out for Justice. Out for Justice represents returning citizens throughout Maryland, many of whom will be significantly impacted in a positive way by this piece of legislation. I also do want to highlight that this is a legislative priority of the Maryland Black Caucus. As was already mentioned, the bill has 3 major portions. One is fixing the APISEC decision. Again, we thank Madam Vice Chair for sponsoring that. The second handles removing things from case search, and the third handles the 7 common misdemeanors. I just wanted to highlight the conversation around that. These 7 misdemeanors were meticulously vetted by the governor's office. I'm happy to answer any questions that anybody may have about them, but for the newer members who may not have had the conversation on expungements previously, just wanted to reiterate that these expungible charges, as they're being added to the list, just a friendly reminder, are only eligible for expungement after the individual has served their entire sentence, waited an additional 5 years to complete the waiting period, and, to be clear, if the charge was a part of a unit of charges, it is not eligible. If a person is pending a criminal trial, it is not eligible. And if they are convicted of a new crime, it is not eligible. Just wanted to be clear about how the expungement process works, because in case there is any conversation that this is somehow a little too lenient, it's not. It's a very balanced piece of legislation, and we thank the governor's office for sponsoring it. Also happy to answer any questions about the specific charges. I think that's what our panel is pretty much here to do. Thank you all for your time.
Thank you, Chair Clippinger, Vice Chair Bartlett, members of the committee. Appreciate the opportunity to be here today. I'm Michael O'Connor, the mayor of the city of Frederick, and I'm here today to express my support for House Bill 499, which aligns with the core values of my city, our state, and our country: justice, fairness, and a belief in second chances. My administration has made clear that second chances are not only a moral obligation, but an essential for the long-term success of our community. We believe in opportunity, growth, and a capacity for change. Justice is not just about punishment, but redemption. This bill honors that principle by creating a pathway for individuals to move forward from past mistakes. The laws you pass can solve real problems and impact real lives. This one is personal because it can directly assist the chair of my Reentry Advisory Coalition, who I believe has submitted written testimony, Jason Lee. After an arrest and conviction in 1994, Jason served his time and rehabilitated. He has since built a multi-million-dollar business and serves on the boards of Frederick Health, Woodsboro Bank, and our Chamber of Commerce. However, despite his success, the stigma of his criminal record still limits his opportunities. For example, it restricts his ability to access Fort Detrick, where his company holds a contract. Our Reentry Advisory Coalition focuses on supporting individuals and the successful reintegration of justice-impacted persons, knowing that employment is a key factor in the process. One of the greatest obstacles faced by those with criminal records is the stigma that follows them, something HB 499 addresses. The ability to expunge a record easily after appropriate time in service is crucial for allowing individuals to be seen for who they are, not who they were. In Frederick, we ask people to join the story. This bill will help open new chapters for many, creating stories of redemption and inclusion that will leave no one behind. I appreciate your favorable report.
Good afternoon. My name is Melissa Rothstein. I'm the Chief of External Affairs at the Office of the Public Defender, and I urge you to issue a favorable report on House Bill 499. At the Public Defender's Office, our agency's work is largely at the front end of the criminal justice process, focused on the allegations underlying the charge and the punishment imposed. Expungement law is quite different. While prosecution and sentencing look backwards at the offense, expungement looks forward, recognizing that after someone has served their time and remained crime-free for a set number of years, removing the barriers that come from a criminal record are in the best interest of both the person and society. Ironically, an individual incarcerated on a misdemeanor conviction who incurs a disciplinary infraction in prison or jail is able to seek expungement once the waiting period after their incarceration and any subsequent monitoring ends. However, under the appellate court's decision in Abhishek, if that same person was released on probation and had even the most technical violation, they are barred from ever having the case removed from their record. I have worked with hundreds of people seeking expungement, and in my experience, most were justice involved due to substance abuse. As any treatment professional or person in recovery can tell you, relapses are part of the recovery process. Life stresses result in the return to coping mechanisms that may not be safe or healthy until the body and the mind learn to adapt to other supports and habits. The learning comes from the missteps. We as a society want people in recovery to have their basic living needs met to promote a sober and stable lifestyle. The bar to expungement established by Abhishek works against this goal. HB 499 is a modest measure that realigns the law to its legislative intent and adds misdemeanors that warrant similar relief. It does not change the avenues for states' attorneys or victims to oppose expungement, nor does it remove the judge's review in the interest of justice. Rather, it allows for more individuals to have a judge consider whether their misdemeanor conviction must continue to be a barrier to access their basic living needs. And I'm going to take my quick last 10 seconds to respond to, I know, some immigration issues that came up earlier, and I anticipate that will probably come up again on the automatic expungement bill, where it's a little more complicated. Here, it's where people are requesting an expungement because they've decided it. I know at our office, what we do is before we seek expungement, we make sure to make a copy of all the records. Now we scan them, make them electronic, so people have them for their availability for immigration. Not perfect, but it allows for people to get work opportunities.
Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. For the record, my name is Cam Bridges. I'm a public policy advocate for Job Opportunities Task Force, a nonprofit organization that helps low-wage workers gain access to higher-paying jobs. So over 1 million Marylanders have a criminal record. Advances in criminal background check technology have made access to these people's records easier than ever. But the unintended consequences of these changes are that Marylanders are barred from moving on with their lives after they have paid their debt to society, as we've seen and heard examples of today. These barriers did not exist even 50 years ago, but now they limit these Marylanders' access to employment, housing, education, and other critical resources. In an era of rising child care costs, ballooning healthcare costs, the ever-increasing housing and rental markets, and increasingly untenable costs of higher education, having a well-paying job is a necessity. The days where financial freedom were accessible to a significant portion of Marylanders are in jeopardy, and the percentage of Marylanders who can hope for even short-term financial security is dwindling. Preventing large numbers of Marylanders from accessing gainful employment will ultimately hurt the state and will worsen homelessness and public safety. Maryland must remove barriers to employment, not build them. This legislation would allow individuals who have completed their sentence to have their records expunged so they could truly move on and become active members of Maryland's economy. JOTF appreciates the opportunity to testify and ask for a favorable report on House Bill 499. Thank you.
Great. Good afternoon, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law. You've already heard a lot about why this bill is so important and how it will work. I want to just underscore both the gravity of the Abhishek issue and the incredible opportunity in front of the committee here today to fix it at next to no upfront cost and huge economic benefit to the state. Problem-solving tools at an enormous premium right now. The fact that any probation violation, no matter how old or how small, from a missed appointment to even decades-old possession of small amounts of now legal cannabis, categorically bars a person from ever accessing expungement, this is just one of those realities about Maryland that makes people's jaws drop. Criminal justice experts from around the country and Maryland residents alike. Now, we continue to say out of one side of our mouth as a state that we believe in the importance of second chances, both for our friends and neighbors who deserve and work so hard for them, and also for the economic viability of the state. Yet, by allowing the Abhishek interpretation to stand, we implicitly and explicitly tell anyone who has ever stumbled that we do not. But the opportunity before you is that we can fix it. HB 499 makes the legislative intent of the REDEEM Act, which was to improve, not limit, access to expungement real again, giving Marylanders with eligible convictions the opportunity to earn and seek relief. We all stumble. This bill opens pathways to opportunity and promotes the human dignity and meaningful societal participation that help any of us succeed. We urge a favorable report.
Had a person who was on virtually, and let's see if we can pull them back. Christopher Sweeney, there he is. Chris Sweeney, please, for 2 minutes.
Good afternoon, members of the committee. I really appreciate the opportunity to be here today. I'm Chris Sweeney with Maryland Volunteer Lawyer Service, where I support job trainees with removing legal barriers to employment. I support all facets of this bill on behalf of MVLS, but I'm also going to emphasize the violation of probation issue, which we believe to be extremely crucial. That portion of the bill is really a matter of equal treatment. The Abhishek decision unfairly punishes probationers for making the same mistakes that our expungement statute is already designed to allow in certain cases. The statute has rules dealing with subsequent convictions, where if someone reoffends, they are not categorically denied expungement for the rest of their life. That remedy can still be available if the person goes a certain number of years without getting a serious conviction. On the contrary, Abhishek permanently blocks a probationer from ever seeking expungement, no matter how minor the offense, if they do slip up on probation, meaning a missed appointment can result in a permanent criminal record. And were the violation to be for a serious crime, our expungement statute already takes care of that because the person wouldn't be receiving an expungement due to a subsequent conviction. I've participated in testimony for almost 10 years here and seen this legislature spend the past decade or so carefully improving access to expungement in Maryland. But the Abhishek decision muddies those waters and it creates unjust outcomes. And it actually disproportionately impacts those living with minor offenses on their background, who are really the people that our expungement statute is designed to lift up and to provide a second chance to those folks. And so for those reasons, I respectfully urge a favorable report, and I greatly appreciate your time today.
Thank you. Delegate Sample Hughes with a question, please.
Thank you, Mr. Chair. And this is an exhaustive list, and I'm supportive of majority of it. But I just want to ask, in the process and to determine which ones made the list, did you reach out to any of the agencies that may be, I'm sorry, not agencies, but boards in particular, that may be affiliated with the particular conviction? And one in particular I'm talking about is 10-402, the unlawful removing or attempting to remove human remains from burial site. Is that one that's already, law?
That's already in law.
Yeah, okay. So is that the process, though, for the ones that you have expounded upon or anything?
The process, one, there was a great amount of conversation in coalition with a variety of, business owners, workforce developers, impacted person groups. Many of these charges that are being added are ones that directly impact like members of very large impacted persons groups. So I will say this. A much larger list was originally sent. I know I can't speak on behalf of the governor's office. I know that they had reached out to a variety of other organizations as well to get a list from them. And then from that process, my understanding is that many more conversations happened with leadership. And then from there, we got down to the list that you see before you. My final understanding is that there were conversations with all impacted parties involved that would be directly affiliated. So for example, that would include the state's attorney's office, judiciaries, from my understanding. But I do believe that that's a question that the Miles Hicks from the governor's office can answer far better.
Okay, thank you. I'm just curious how all the lists come to be, the ones existing versus also your added one. Thank you so much.
Further questions for this panel? Seeing none, thank you all very much. Colin Andrew Willits. Stephen McDonald. John Cox.
Hey, how you doing?
Oh, I'm sorry, Mr. McDonald, hang on one second. All right, so we'll hear from Mr. Oh, okay, we'll hear from Mr. McDonald in a second. Mr. Willett is favorable, Mr. Cox favorable with amendment, and Mr. McDonald is also favorable with an amendment. So please, we'll start with Mr. Willett.
Yes, my name is Colin Willett, and I'm here to support House Bill 499 to clarify the expungements are to be allowed when time allotted for the sentence was expired, including mandatory supervision and the waiting period. When I was 21, I was caught in an unfortunate situation at the wrong place at the wrong time. This resulted in being, This resulted in being wrongfully convicted of credit card theft despite never having used said credit card. I was subsequently sentenced to 3 years of probation. As part of my probation, I met with my parole office weekly as mandated. My only violation was in an unfortunate DWI. Following my DWI, I began to attend weekly Alcoholics Anonymous meetings and completed my sentence. Despite finishing my sentence, this wrongful conviction has been a heavy burden for the last 26 years of my life. I have been bounced around from one low-paying job to another, never landing a decent job because of 26 years ago. I was lobbied a thief. Potential employers see only the word theft, not my skills or desire to improve myself. Since my DWI, I've stayed out of trouble with the law and have stopped drinking entirely. None of this has mattered in the courts, and my expungement has now been denied twice. The situation has caused me severe depression and anxiety, which I am now in therapy for. House Bill 499 will lift the current ban on expungements for charges where a violation of provision occurred and allow all my charges to be eligible for expungement. I urge a favorable report. Thank you.
Thank you, Chair Klippinger. I guess we've lost the Vice Chair. Members of the Judiciary, I'm John Cox. I'm Deputy State's Attorney for Baltimore County, and also speaking on behalf of the Maryland State's Attorneys Association. And we do support House Bill 499 with an amendment. I was here, I believe it was last year, when there was reaction to the Abhishek decision, and the clear inequities that can occur on occasion as a result of the Abhishek decision. And we supported that, but expressed the one concern, and that was restitution for the victims. That's a part of the successful completion of one's probation. This would eliminate that as a factor, or the original bill eliminated that as a factor. And so I expressed concern about putting something back in there to make sure the victims are taken care of in the event that the individual is financially capable of paying that restitution. This body, I believe, added an amendment, and it's in House Bill 499, but only as with regards to 10-110, and that's the convictions that can be expunged. It did not address restitution when somebody gets a PBJ. And that's where our concern is. And we're asking that it be amended to also have that requirement of the payment of the restitution if the person is financially able to do so. I believe that there's an easy solution to do this, and we could do it as an encompassing one. In the bill itself, at page 6, they have the factor in there for 10-110 at lines 25 through 27. It appears to me that it would be an easy solution to take those words and add them to the new definition of completion of the sentence, which is at page 2, lines 3 through 5, to include the requirement of successful completion of the sentence being meeting that financial obligation, paying that restitution, unless the individual is financially unable to do so. Thank you.
All right, we'll go to the person who is here virtually, I think. We'll pop back on the screen. There we are. Mr. McDonald now for 2 minutes, please.
All right. Thank you, Chair and members. My name is Stephen McDonald. I'm a member of the Local 5 Plumbers and Gas Fitters and a resident of District 28. I strongly support Governor Moore's Expungement Reform Act, which will assist me in moving forward with my life. I only request a favorable amendment to allow criminal law section 5701D counterfeiting prescriptions to be added to the expungement list. I was informed by my attorneys, state's attorneys, and a judge to address a legislative fix for my charge because under section 5601 existing expungement law, the text language reads, counterfeiting or alteration of a prescription is eligible for expungement. It is not covering the charges see just like intended. These charges are under the next section 5701D prescription counterfeiting charges. When I was 18 in high school, I had a spine injury, which the doctor overprescribed me with Oxycontin, which was the encouraged drug at the time. There wasn't much discussion about addiction, which became the nature of my only charge. The governor's bill is already adding criminal law section 8610 counterfeiting prescriptions to the expungement list, and criminal law 5601 is already a misdemeanor for counterfeiting or alteration of a prescription is already expungable. Sections 5701D, section 8610, and section 5610 are essentially the same charge in 3 different statutes. If this can be rectified by adding section 501D to the expungement list, it would be a legislative fix to have these 3 sections together to clarify the intent for counterfeiting prescription charges in existing expungement law. All prescription crimes are low-level misdemeanors with the lowest level seriousness category at 7. It would also clarify the governor's intent to help individuals like me who survived an opioid epidemic. I urge a favorable report.
Questions for this panel? All right, seeing none, thank you all very much. That concludes the testimony for House Bill 499, and thank you for that. Delegate Embry now, please. House Bill 1147. Mr. McKesson. Mr. McKesson will be joining Delegate Embry. She'll get 3 minutes, he'll get 2. Delegate Embry.
Thank you, and Chair and Vice Chair and all my committee members from my favorite committee. So this bill is about parole, the parole process, and it's focused on issues of transparency, predictability, and equity. And it does a number of things which I'm going to run through, and then Mr. McKesson, I want to thank him and Campaign Zero for all the work they've done on this issue broadly. He'll go into what other states are doing and how this fits into the larger picture. And then I'll also talk about, I've had conversations with DPSCS. They have a a really helpful informational sheet, and also Ms. Jordan's, and how we plan to address those through amendments. So the first thing that the bill does is specifies that the annual report made by the Parole Commission includes more data, like number of cases where parole was granted or denied, and making sure that the data is disaggregated by race. It provides that the commission has to affirmatively provide documents that will be relied upon in the hearing, versus right now, the inmate can request to see them, can have access to the file. So this will be more like a discovery provision with all appropriate redactions already in the law. It will require each commissioner to provide reasoning and justification, not just their vote, and provide that within 7 days of making their decision. And also providing prompt written notice of their decision. It will require the hearing examiners, and Delegate Phillips has a bill that may intersect with this, so I will, with the caveat that parts of that bill may affect this bill, but require that hearing examiners make recommendations within 7 days, which is a shorter time frame. And again, like the commissioners, include their reasoning and justifications. Also, and this might be the most critical part of the bill, right now in Maryland, many parolees, when they're denied, are never given, not never, but are given no new date. And in some cases, they ask for a new date, they don't hear back, and so there's no predictability for the inmate about when they can have their parole reconsidered. So the current time in this bill as written is 2 years. I'll talk for a second about possible amendments to that, but I think it's important that there be some date certain for inmates to know that they will be reconsidered. Let's see. And finally, requiring hearing transcripts to be created and maintained for public access in addition to the inmates' access with the victim names redacted. And then briefly, I want to talk about some of the amendments requested that are, I think, very reasonable. Department of Public Safety said to create actual transcripts, having a human create them is very expensive. So I think the amendment will just be to have that recording available, or use AI to create the transcripts. We don't want to spend money on transcript writing. DPSCS is concerned about the 7 days for the decision. That turnaround's very tight, so we've asked them to come back with a compromised time. And MCASA is concerned, well, I'll get to that in questions if I'm asked any. Thank you.
Chair and Vice Chair, it's an honor to be here in committee. I'm DeRay McKesson, a Marylander, and also the Executive Director of Campaign Zero. We focus on criminal justice reform. My support of this bill is informed by our national analysis of every parole system that currently exists in the United States. Remember that 17 states don't have parole, so there are 33 states with active parole. And also informed by an international analysis that we've done around parole with some big countries. The first thing I'd remind is what Delegate Embry said, is that remember there is a unique part of the Maryland parole system right now, is if you ask about denials and appeals, in Maryland, denial means that you had a hearing and got a no, and a yes means you got a yes. But in Maryland, 1,000 cases per year are refusals. So if you apply for a parole hearing in the state of Maryland, the Parole Commission will just refuse to give you a hearing. So there are people that they have just essentially permanently refused to ever have a hearing, and you will not see that in the data because most people ask for denial data. They don't ask for refusal data. So even in, and this is in the bill as well, even in the annual report that does exist, because state law is silent about what is supposed to be in that report, it is very hard to get that data. We know that they refuse 1,000 cases a year because we've asked in FOIAs for the past 2 years, but this bill will correct that with automatic scheduling. Remember that 25 of the 33 states that do have active parole currently do have automatic scheduling on a cadence of either annual or biannual. Remember that hearings are not released, so this would put people in a predictable cycle. And it would make the commission actually have rationales for the decisions, which is a big deal because it doesn't do that now. And then this wouldn't change any of the victim rights that currently exist. What we do know from the data itself is that in Maryland, parole hearings are closed. They're only open if victims ask. And in Maryland, 99% of the hearings for the past 2 years did not have a victim participate. So we are favorable, and I think this would be a huge addition to the parole system.
Other questions for the panel? Delegate Erickson.
Thank you, Mr. Chair. Thank you, Delegate. I know you were about to say something about MCASA, so I wanted to give you the opportunity to tell me.
Thank you, Delegate.
Yep.
Thank you. And I'll be quick. So MCASA has a number of concerns, and I really appreciate their informational testimony that I want to address and through amendment in some cases. So they're concerned that victim information be fully redacted, not just names, but all information. Absolutely, I think that makes complete sense. They're concerned about, in victim cases, especially, serious victim cases, what is 2 years the right number? And so we are very open to maybe a tiered system. We're looking at other states. There could be different categories, depending on the type of crime and/or the length of sentence. So thank you so much for that.
Yeah, absolutely. Thank you.
My question.
All right. Any further questions for this panel? Seeing none, thank you both very much. Now in opposition, a former member of this committee, former Delegate John Cluster.
More importantly, Mr. Chair, former member of the Parole Commission for 8 years.
I got it. I'll let you get there.
So my name is John Cluster. Thank you for giving me this opportunity. When I read this bill, it's kind of weird being on this side of the table instead of where Delegate Arcand sat. I sat there for most of my career. There are provisions in this, a lot of provisions in this bill that I don't think can happen and shouldn't happen. Number one, the fact that we cannot deny parole. Very rarely do we deny parole for lifers. That's only happened 1 or 2 times, and I can get into that case if I have time. But the fact is, it's for the lesser cases, the child abuse, the sex offenders, those that come into prison and don't change their ways. They continually are in trouble. They get time after time, they're getting written up for infractions, hitting other prisoners, hitting COs, drugs, some sex offenses in prison, having weapons. These are the ones that need to, when they come into prison and they get a sentence of 20 years, they're eligible for parole in 10. Their MSR date is probably around 16 and a half years, but they don't behave. And they're the ones that should be eligible for the parole commissioner. Look at the case and also deny their case parole. The second provision is the 2-year provision. Again, we go back to people that don't behave themselves and constantly, and you're only giving them a 2-year hit. I mean, everybody's going to come in there thinking, well, I can do whatever I want. I'm going to get a rehear every 2 years. And that's not going to happen. There's 17,000 prisoners. There's 7 parole commissioners. I don't see how those numbers work out. We should have 10. Our secretary hasn't filled 3 positions in over 2.5 years. So I just don't see how those provisions can happen. I think we need to leave that up to the commission, the commissioners themselves.
Thank you, Mr. Chair. I wanted to give you the opportunity to tell us about the 1 or 2 times you had mentioned that you actually denied.
Yeah, I had both of these cases. One of them was the Route 40 rapist. He was convicted of raping between 6 and 8 women, but in reality, they didn't charge him with another 6 or 8 rapes. And during the hearing, he told us that there was many, many more. He was a soldier up in Aberdeen. He raped many, many more women, and they just didn't convict him of those or didn't even bring them to court. I mean, we're talking probably, his number was around 20, 20 women that he raped. Somebody like that, do we want him on the street? I don't think so. As a former police officer, sex offenders usually are the hardest ones to rehabilitate. The second one was, and I hate to bring this up, but it was a CO that actually went to his home, got his shotgun, killed his wife and 2 kids. And while he was there was another woman with her 2 kids. He killed her and those 2 kids also. So he killed 4 kids and 2 adults. Then he kidnapped a woman and took her to Chicago as a hostage. And on the way to Chicago, raped her many times on the way out to Chicago. They finally caught him out in Chicago. Do we want somebody like that on the street? I mean, 6 murders, 4 of them kids. So there are cases, and there were just 2 of the cases that I can remember that I had in the 8 years that I was there.
Thank you for sharing that.
Thank you, Mr. Chair. You mentioned some numbers about commissioners to prisoners ratio. Can you talk a little about what a parole commissioner does and your ability to kind of work through that?
Sure. The parole commissioners, our main objective is parole hearings. Anytime we have a lifer, somebody that gets life, or somebody that's involved with a death, it has to be heard by 2 commissioners. That's the #1 priority of the parole commissioners. But we have many other duties. There are 10, I know I heard, hearing officers. There are 10 hearing officers also that are below the commissioners. They hear all the other cases that aren't lifers and that aren't the death involved. They get between 15 and 30 cases a week that they hear. All those cases have to come before a parole commissioner, and we have to review every one of those cases and either approve those cases or give them another decision. If we do give them another decision, then they go before 2 more commissioners and hear those cases. So that workload is on us. We review all warrant requests, and we approve all warrant requests for retake warrants. Retake are people that are out on parole that violate their parole, and their parole officer writes a warrant request. So we have to review all those, and we have to approve all those. I can remember one day I had 37 of those in one day, 37 requests in one day. We have revocation hearings. When they are retaken, we have to hear the revocation hearings. So it's basically a mini trial. They're incarcerated. We go to the prison. We hear a revocation hearing and make the decision whether we're going to violate their parole or they're going to release them again and give them more requirements. Subpoena hearings are the same way. Subpoenas are for lesser crimes, the DWIs, the minor thefts, things like that, but we don't want to lock them up, so we have subpoena hearings. Once a week, we have to meet with victims and advocates. One parole commissioner meets with victims and advocates once a week. That's on a weekly basis. We have to prep cases daily for our parole hearings and also our revocation hearings. The commission meets every 2 weeks for the entire commission, once every 2 weeks by law, to hear en banc cases that we're going to review for lifers that we're going to let them out. So there's a lot on a parole commissioner already without having the added of every 2 years having to hear every case in the state of Maryland.
And when does a lifer get their first hearing?
Life in Maryland is not life. Life in Maryland is based on 30 years. And under the law, they get their hearing at half of their sentence minus their diminution credits. So every lifer usually gets their first hearing at 11 and a half years. That's the norm, 11 and a half years.
Okay, thank you.
Vice Chair. Thank you, Mr. Chair, and thank you for being here. You've provided some really helpful information. So when the commissioners review parole, do they get like a parole packet of information, and what's in that packet?
We get their file, their complete file. Everything's in there. Everything from the day they entered the system to the day we get the file. I've had file. We had one we reviewed that we ended up letting go from Southern Maryland, and his file was in 4 boxes. We have to review every one of those. So yes, we get everything. It has their infraction. We pull up their infraction records on the internet, on our internal internet, and any other information that we need, we can get their FBI records by going to the case managers or one of the others. So we get a complete file of that individual from day one.
So you kind of answered my other question and that was, you said there's an internal file. So some of this is electronic. Yes, or
very little. We are so heavily paper-based. If we had a fire up at the parole commission, we'd be in trouble.
I was thinking about another bill. That's why I was asking that question.
We ought to have everything put in the computer. But it would take data entry. It would take probably years to put all the data.
Sure.
You would not believe our file room. It's probably 3 times the size of this room here with nothing but parole files. We don't throw parole files away. So they're there, but it's all paper-based. There are things from the prison, like the infraction records, we access through our internal internet.
Okay.
That kind of stuff.
So are the same 2 commissioners reviewing the same inmate when it comes to lifers? Or is there a rotation?
There's a rotation, yeah, it's a rotation. You may get the same person more than once. I mean, I was there 8 years, and yes, I had the same person a couple times that I made a
Because
decision.
there's so few of you, right? And so
There's that, right, like I said, there's only 7 of us. There's only 7 of them. I left in May. I finally retired. I left in May, and when I left, there were 6. Now we're back up to 7, but the 7th person isn't fully trained. We're supposed to have 10, but our secretary, for some reason, does not want to fill those 3 spots, or hasn't filled those 3 spots in the last 3.5 years that I can remember.
Okay, and is there a recusal process?
If they are a process, when we have the parole hearing, we discuss.
I said refusal, but I meant recusal. I don't know if you heard.
Oh, recusal, yes. I've recused myself on several cases. One case in Baltimore County where Jamie, I can't think of his last name, was murdered and buried in the Gunpowder State Park. I worked on that case, so I didn't have anything to do with it. I've had several occasions where officers in Prince George's County where 2 sheriffs were killed. One of their sheriffs reached out to me and talked to me about the case. Well, I recused myself from that case because I had some inside information that I didn't think was fair when I went to the hearing. So yes, we can recuse ourselves.
Okay. Thank you so much.
Further questions? Delegate Phillips.
Mr. McKesson mentioned kind of 2 options, approved, denied, but then those that kind of fall in the middle. How does that actually work?
Like I said, there are very few, well, there's more on the lesser offenses that are denied parole because of what they do in their sentence structure. If they're denied at that level, they have a right to appeal that denial. Okay, so they can bring it to the commission, and 2 commissioners will look at that case and make a final decision on that case. Not the commissioner that handled the case. 2 additional commissioners will look at that case. When we go to a parole hearing, and let me talk about lifers because that's what we do most, our lifers and people that are that are involved in a death case. 2 commissioners hear that case. Usually it lasts anywhere between an hour and an hour and a half for a parole hearing. I ask a lot of questions. They give us a lot of information. At that point, we ask the inmate to leave the room. The 2 commissioners then discuss the case, I don't know, anywhere between 10 and 20 minutes, 30 minutes, whatever. We go over all the facts of the case, what our decision is going to be. We actually issue a decision. I don't know where they came up with, we don't issue a decision, but we issue a decision that day to that particular person. We give them a written statement as to why they were denied. And we also put in that statement what we look at, what we'd like to see them improve, and if they, when they come back to us. We also give them a month and a year of their next hearing. So I don't know where that came from. Every case I've ever had, if it's a 2-year hit from March 15th, we'll give them a 2-year hit. It'll be March of 2 years from now. We actually put that on the paperwork that they get. So they get all that information. At the hearing officer's case, they give them, after we do a review of the case, it's given to them, and it's got a month and a date of a rehear date if they give a rehear. If it's a denial, again, if we deny the case, it goes to 2 additional commissioners to look at that to make sure that we did the right decision.
Okay.
The other thing, Chair, I don't know where he came up with, there's 1,000 cases a year that we don't have hearings. Everybody gets a hearing. If they're in for even less than a year, they get an automatic hearing within the first month of their prison sentence. So, I don't know where that came from. We go to local jurisdictions. We go to every prison in the state of Maryland and have hearings. The rules are if they're a year or more on their sentence, they come to the states, and we put them in a state system. But if they're a year or less, we actually go to the prisons where they're stationed. I mean, I've been all over the state to all the local prisons, and we have hearings right there at the location. So, and I've never heard of anybody not, there might have been 1 or 2 fall through the cracks, but I've never heard of anybody not getting a hearing. And those numbers, anyway, 1,000 is just, I don't know where that came from.
Okay. Are there further questions? Yeah, the Vice Chair.
So there's this section that's called like administrative hearings, administrative review. Have you ever heard of anything like that?
The administrative, yeah, that's something that came under the JRA, and we don't deal, the parole commissioners don't handle the administrative reviews. They're handled by some administrative judge, I believe, but I've never heard of that many of them. But that came under, if you look under the old JRA, and I was here when that happened, but that administrative review process came into play then.
Okay, thank you so much. Thank you, Mr. Chair.
Seeing no further questions now, thank you very much.
Thank you.
That concludes the testimony on House Bill 1147. We'll go now to House Bill 365. And that'll be Delegate Embry and Rebecca Snyder, please. Rebecca Snyder not here, so Delegate Embry, go ahead.
But yeah, if you don't mind, I'll start and then.
Yeah, go ahead.
And her support is the same as it was last year. Thank you, Chair and Vice Chair and committee members again. This is a bill that we passed last year, passed out of the House. It's actually stripped down a little more, so it's a smaller version of what passed last year. And what it does is we have done such great work in the state expanding expungement opportunities. That's great. But the one result is that data connected to expunged cases is totally unavailable for any kind of research purpose or any analysis. And so this bill allows totally de-identified data to be provided to facilitate research, for newspapers to do analysis, for us if we wanted to consider data in some of our bills. So I think it's an unopposed bill that helps any unit of academia or the press or government to make informed decisions by having access to complete data sets instead of having 30–40% of the cases that are expunged not accessible for consideration. So with that, I will stop talking.
All right, questions? Delegate Phillips.
I just want to make sure, isn't this a bill that we passed last year?
Correct. Yes, I took out one section that really wasn't directly about expungement, so it's a slightly smaller version, but yes, it does the exact same thing as last year.
Thank you.
Delegate Conaway.
Chair, thank you, Delegate, for bringing the bill.
Thank you.
So when you have this information that's stored somewhere, will it have identifiers as to who the people are?
So the courts will be responsible for what they provide has to be stripped of all identifying information. And that's not just name, but that's, address, age, anything. So it's just like, let's say you wanted to study the outcomes of armed robberies. This would allow you to get a full data set of all armed robberies with no information about the defendant, so you could know the outcomes of all the cases.
No information about the defendant?
Correct.
Okay, thank you very much.
Other questions? Seeing none, we thank you very much. And that concludes the testimony on House Bill 365.
Thank you.
Three bills from Delegate Phillips now. House Bill 1156 is the first one. Mr. McKesson is coming back to the table, and the two of them will testify on House Bill 1156.
And after 1156, could we skip down and then come back up?
You want to do 647 after that?
Yes.
Okay.
Uh-oh. Give me a second, Mr. Chair. I don't see my testimony inside of my notebook. We'll figure it out. There you go. Thank you. Yeah. So, Chair Clippinger and Vice Chair Bartlett and my fellow colleagues, as you can tell, I'm losing my voice, so I'll try to be brief. Currently under Maryland law, the Secretary of the Department of Public Safety and Correctional Services has the authority to appoint parole commissioners with the governor's approval. While this process has worked in some ways, it has its limitations, particularly when it comes to ensuring the selection of commissioners is based on qualifications, experience, and impartiality rather than political considerations. House Bill 1156 seeks to address these limitations by creating a parole commissioner selection committee. Think of the Judicial Nominating Commission. This committee would be tasked with thoroughly screening and recommending candidates for the governor to appoint as parole commissioners. This change is crucial for several reasons. enhanced transparency. By involving an independent committee in the selection process, it will ensure that the process of appointing parole commissioners is open and transparent. Second, greater accountability. Under the current system, the parole decision-making process is somewhat fragmented, as hearing examiners often have a role in making parole recommendations. This would consolidate it directly to parole commissioners. Third is improved efficiency and structure. The creation of the parole Commissioner Selection Committee will bring greater structure and consistency in the selection process. It will standardize the approach and ensure that most qualified individuals are chosen to make these critical decisions, minimizing the influence of political motivations and increasing the overall quality of the parole decision-making process. House Bill 1156 aligns Maryland with national trends that are pushing for fairness, transparency, and accountability in parole systems. It would help to enhance public trust in the parole process, ensuring that decisions are made by individuals who are not only qualified, but also held to the highest ethical standards. This bill would also increase the number of parole commissioners from what is now 10, and as you heard, only 7 currently sitting, to 15 to up to 20 parole commissioners. It would remove the examiners from the process. So that would be, and I would ask for a favorable report on House Bill 1156, and to give more color and to provide more of a perspective of what's happening nationally, I'll turn to Mr. McKesson.
Hi, it's an honor to be back. I'm DeRay, the Executive Director of Campaign Zero. Wanted to address some things in this bill. Remember that Maryland and Kentucky are the only 2 states where the Secretary of Corrections has the sole appointment power. This bill will put Maryland more in line with other states that have a more holistic understanding of putting together the parole commission. Remember that hearing examiners who have a lot of power in the state of Maryland, because essentially they are holding the hearing alone. They give the recommendation to the parole commissioner. They are but they are employees of the secretary. They are not appointed by you all. They are not empowered by the legislature necessarily as parole commissioners, but the weight of their decisions is effectively a parole decision. Remember that the parole commission in Maryland is a black box. It is a secret sort of process. It is only open to a victim if a victim participates, but it is largely a black box, and they make unappealable decisions. I say that because if they cannot be appealed, it is even more important that the process is fair. And I just wanted to address some of the things from the last conversation, is I remember that neither this bill or Delegate Embry's bill changes the commission's ability to deny parole to anybody or forces the commission to grant parole to anybody. What it does do is that both of these bills make it so that the parole commission can no longer refuse to hold a hearing. And today in Maryland, the parole commission, not just denying you parole, they can just refuse to ever hear you ever again. So where does that data come from? Again, that is a FOIA from the Department of Corrections itself that said that they have refused to hold 1,000 hearings per year. This bill at hand, again, will put the state of Maryland in line with having a parole commission that is empowered to make all of the decisions, that requires 2 people to participate in every hearing, which is not the case today. The majority of people who will go before a parole body will actually have a hearing examiner. They will not have a hearing conducted by a parole commissioner.
Thank you. I see a couple of questions. I'll start with Delegate Kaufman and then Delegate Sample Hughes.
Yes. Thank you, Madam Chair. Delegate Phillips, I know sometimes DLS doesn't get us our fiscal note for a while until right before the hearing, but have you given any thoughts on how to reduce the $1.1 million fiscal note?
To be quite honest, there's going to be some offset. Once again, we will be removing the hearing examiners and adding parole commissioners. Parole commissioners generally make more than the hearing examiners, so I do understand that that's a challenge. I think it's important, though, that we relieve the backlog that we have of individuals who really don't get a hearing. And on the flip side of that, if we can relieve the backlog and perhaps have additional individuals who are eligible for parole, we'll bring down the cost on the number of individuals who are incarcerated.
No, I mean, I support the bill. I just wanted to flag the fiscal note for it.
No, and I understand it. And I think that I'm not going to suggested that fiscal note is not real. When we go from 10 to 20, there's going to be real implications.
What's, can I have another one, Madam Chair? What, do you know what the salary for a parole commissioner is?
Ooh, I do, but
yes. And if not, could you get back to me? I think that they make a good salary. But what do you think your changes might reduce it to when you said you're taking out the hearing officers?
The parole commissioner's salary is 117.
Oh, that's a good.
And the hearing examiner is 99.
Okay, so both parties make more than we do. All right. Thank you, Madam Chair.
Thank you, Delegate.
Yeah, thank you. Delegate Sample Hughes, please.
Thank you, Madam Chair. And maybe those two openings on the commission, maybe one of us can fill them. But I did, actually, that is part of my question. But so with that being said, did you speak with the secretary to find out why those vacancies are?
I have not.
Okay. So if they're not willing to fill those two, and it's been, what, 2 years? I was just curious, how do we get to the 10 or, I'm sorry, 10 to 15 or to 20?
So once again, we professionalize the process. No different than the Judicial Nominating Committee, right? We've got people who are interested in a position. You take them, you vet them through the process. The governor then makes the selection based on the panel. And so I think if we did that and we professionalized it, we would get more people interested, we'd have more of a pool, and ultimately the governor would make the decision and not the secretary.
Okay. And prior to us voting on this bill, would you be able to find out the response from the secretary?
Sure,
about
absolutely.
Just the procrastination, maybe?
Yep.
I don't know.
Absolutely. I will absolutely ask that question.
Okay, thank you. Thank you, Madam Chair.
Thank you. Delegate Taylor?
Thank you, Madam Chair.
And if you just pull down your mic.
Thank you, Madam Chair. My question, I think, is mostly for Mr. McKesson. First of all, thank you for the graphic understanding House Bill 1147 and 1156. And can you tell me, will these two then work in tandem if passed, or do they overlap? Can you explain that?
Yeah, I think that they do work in tandem. So I think that Delegate Embry's bill will actually just modernize the parole process. Again, if the process is going to be unappealable and sort of secret, it should at least be fair. And I think her bill actually does that. I think the way to do that at scale is actually to do both of these bills together. So if you make it fair, if you actually do hearings on a cadence, 2 years, 3 years. Right now in Maryland, the law is silent on this, but there's department policy that says if you get sentenced to less than 10 years, you can apply every year. And if you get sentenced to more than 10 years, you can apply every 2 years. That is department policy. Now, they refuse a lot of people consistently, which is sort of a challenge. But this bill would create a workload that I think would probably have to be offset by increasing the commission if you believe that every person should have 2 people hear their case. So if you keep the commission the same size today, then it would be a system where the majority of people will have an employee of the department actually do the hearing, make a recommendation to the commissioner who is not in the hearing. That is one option. That's what it is today. This bill would actually say 2 appointed commissioners are in every hearing and actually make the decisions. Does that make sense?
Yeah, it does. It does. Thank you. And then there's the hearing examiner. You know, thinking about jobs, and they would lose their job, right? Do you think they would qualify to become a commissioner?
It's possible. I would think most of them might not, but it is possible.
As a matter of the law, the law says that literally they have the same qualifications. Now, if they go through the process, do they get chosen? But the law is actually literally like a carbon copy of the same. But the secretary just chooses the hearing examiners. They don't go through a process.
Thank you.
Thank you. Delegate Pasteur.
Thank you, Madam Chair. I like the idea of having more because we know that the commission is so backlogged and we're not seeing people, or they're not seeing people. So having double, but and I think the last two people sort of addressed this, but I need you to just clarify again. So we're looking at 15 to 20 commissioners, right?
Correct.
Okay. And you want to make sure that everyone gets to have 2 people for
Correct.
each one. So right now, we have problems even with examiners who substitute and do all of that, and we're down some. So I know you're going to address this going back to a previous question, but what is written or somebody saying to assure us, even with making it more professional, that we're going to be able to have 2 people on a consistent level? Because essentially with 2, you're back down to where we are now, hoping that everybody is there, right? Because if you have 20, you're really talking about 10. So I'm still worried that we're going to end up in the same, if we're not if it were not cost prohibitive, I would see more numbers, right? So that when you have that 2, so can you just make us feel good? Be a James Brown song.
There are 10 hearing examiners today. So I think you're right about the workload issue. And as you know, there are 10 positions on the parole commission today. 3 are not, or 2 are not filled. Somebody just got appointed, I think, a week ago. So, you know, there is a belief that if there's a nominating panel, that panel will be able to just move quicker and recruit better than the secretary has been able to do, which is why us and Kentucky are the only 2 states that have this model remaining. And I think that you are right, that if we go to a system that does have automatically scheduled hearings, there will be a workload issue that the department will have to figure out. It is not clear, and this is also in the other bill, but the state of Maryland reports almost nothing about the parole process. So it is my belief that this is potentially a workable situation, and maybe there's a way to ask for more data about how many hearings are had. But from the data that they do report, it is not clear that there will be too many cases for a bigger board to handle. That is not, I've not seen data from the commission to suggest that. We've asked for a lot of data from them. And what they would say is that they do 6,000 hearings a year, which makes sense to me, but that's not, they don't report the data in people. So it is not 6,000 people, if that makes sense, because they're only sending out 4,000, like, there are nuances that make us believe that it is not people data, same thing with the refusals. So I do think this is possible. That makes sense.
Yeah, no, it all makes sense. But you understand the worry here that now we're essentially taking the same process, but we will have 2 doing, so we can eliminate examiners, but you're still down, if you're gonna have 2, down to the 10. So somewhere there has to be something in place that says, and even if 2 commissioners out of commission, that there's some sort of backup so we can keep going. Because that's a piece, this is a piece that comes up every single time we talk about anything else, any other bill, you know, to exonerate, not to exonerate, to release. Well, we have the commission. But if it's already behind, we know that, I just would like to know, what is that backup? Because we're going to end up looking the same way. I agree wholeheartedly with the number. I just want to know, is there a backup so that we don't get into this hole even with more people? So that somebody else can come in and say, well, we have this, and somebody else is going to say, and look at how much money we're spending for more people, and we still have the same problem.
No, I appreciate that, Delegate Bastard. So allow us to kind of look at that and come back with some recommendations. This idea of figuring out contingencies.
Thank you. Thank you both. On top.
Thank you. You're welcome. Delegate Crutchfield.
Thank you, Madam Chair. Delegate Phillips, I'm kind of interested more in the transparency because clearly we don't have much right now in the selection. So can either of you just tell me a little bit more about what your proposed new process would look like, transparency-wise?
I'll let Mr. McKesson, but once again, in my mind, I think of this similar to the Judicial Nominating Commission, right? Where you've got a group of folks who are looking at a set of skills, capabilities of an individual to serve on the bench in similar fashion, but actually even more public than J&C, because that's a very kind of insulated, insular process. This would be a more public process in my mind than the J&C. Mr. McKesson?
Yeah, I have very little to add. That is true. And the only thing I'd add is that because it would be a cross-section of people on the nominating committee that is not just corrections, the belief is that it will be a more public, more open process. If the question is who is ready to return to society, that the corrections lens is not the only lens from which we should actually answer that question.
Okay, thank you.
Thank you. All righty. That concludes this panel, and that concludes the testimony for House Bill 1156. So, Delegate Phillips, I heard you mention, did you say you wanted to go to House Bill 647 next?
Yes, if we could do 647, and then I think 1157 might make even more sense.
Okay. All right. Well, so can I call up your panel?
Yes, if we could, Mr. Trumbull, Ms. Berry, Ms. White, Ms. Williams, Ms. Benjamin, and Ms. Warnken.
Okay.
Is that too big?
It might not, well, Mr. Turnbull is virtual, I hope. Margaret Berry, I see you. Benita Taylor. I saw her earlier. Oh, she's not here. Benita Taylor, no. Karen Clark.
Do you have Ms. Benjamin?
Right.
Oh, yeah, Ms. Benjamin's here. I'm sorry, I didn't know.
That's okay.
Oh, yes, Alexis Benjamin.
Yes, Alexis Benjamin Thorne, I'm sorry.
Okay.
Thank you.
And Ms. White, is Ms. White?
Let's see if I can find Ms. White. I am not seeing Ms. White. Nope.
Okay.
Where's Ms. White from? Do you happen to?
Natasha White.
Yeah, and Natasha White is from Interfaith Action for Human Rights.
Okay. Nope.
Don't have it.
Unfortunately. Oh, I have Chris Zacharias from there. Okay.
Yes, he should be on too.
Oh, but I don't have her, so yeah. So,
No problem.
Here's what I want to do. I want to start with the folks we've got in person. So we've got, I know we got Margaret Berry. Benita Taylor is not here at the moment. She's not here. Where? Ta-ta. Aha. I figured if I kept saying your name, you would walk in. Okay, so we've got Benita Taylor. We've got, we don't have Bruce Turnbull on yet.
I thought I just saw him. He was just on.
There he is.
He's on.
You guys are playing musical chairs with me. No fair, no fair. Okay. Is there anybody else you want me to call up? I have Public Defender, Shanice Anderson. Do you want me to call her up now? She's out there. She here? Can we go get her? Well, no.
Yeah.
I don't want to lose anybody I've got. Let's just go ahead and start.
Let's go.
Start with this panel. We'll have you all in person first, and then we'll have the two folks who are on the digital. And Delegate Phillips, whenever you're ready.
All right. I think I'm going to be relatively short, but I do want to share this with the committee. Madam Chair, and to my committee members, I'm here today for a favorable report on House Bill 647, and I want to give you some background. Over the course of the interim, I visited Jessup, I visited Hagerstown, and of course several of us visited Youth Detention Center. The visit to Jessup was in a restrictive housing. In that restrictive housing, I had an experience that was, it impacted me. Watching individuals who were in restricted housing and the mental angst associated with those individuals, the physical space that they sat in, and knowing that those individuals were relegated to that space for 23 hours a day, in some instances longer than that. It provided mental angst for me. It was at one point that some of the individuals began to throw feces out of their small windows, out of their anger of us just simply being there. We need to do better. This bill focuses on some small changes to restrictive housing, to be quite honest. It looks at increasing the amount of time out of cell, reducing the amount of time, the amount of days that an individual could be restricted, remain in restrictive housing. It looks at vulnerable persons who probably should never be in restrictive housing because of their mental capacity. In our system, we take people who are in what we call administrative restrictive housing, and we treat them the same exact way as someone who is in restrictive housing because of disciplinary action. And to me, this makes no sense. And so you'll hear a lot about how our restrictive housing operates today. I will also say that over the course of this period of time, myself and Senator Love have met with the commissioners of corrections for New York and for New Jersey. I've had conversations with my colleagues in Virginia, our colleagues, legislators, who have all made reforms in this area. To do what we really need to do is going to cost us a lot of money, and I understand that. But right here today, we're talking about some changes that need to happen so that Maryland can be more humane in the way that we treat our individuals. The system that we have today is not good for those who are incarcerated. It's not good for our corrections officers. It's not right for our system. And so with that, I'm going to turn it over to people that have been studying this and can give you their perspectives much better than I can. So I'll go to Ms. Berry.
Good afternoon, Vice Chair, members of the committee. I'm going to move this over. I'm Margaret Martin Barry, and I'm here for Interfaith Action for Human Rights and also Maryland Alliance for Justice Reform in support of HB 647. I've also submitted written testimony to the committee. This is the third time I've advocated for such legislation, and I do so because restrictive housing is destructive and immoral. HB 647 differs from the prior legislation because Delegate Phillips and his Senate counterpart took care to narrow the goals to avoid costs. Despite the fiscal note, they have done so. First, the bill limits the use of restrictive housing in 3 ways. It removes vulnerable people. One can only be sent to restrictive housing for committing prohibited acts, and one can only be in restrictive housing for 15 days at a time. There are sound reasons for each of these. Restrictive housing is dangerous in that it harms people mentally and physically, and it does so to a greater degree for those the bill identifies as vulnerable. Second, many people are placed in restrictive housing for nonviolent offenses. And third, beyond 15 consecutive days in restrictive housing has been identified as torture under international standards. DPSCS reports that 5,209 individuals spent more than 15 days in restrictive housing in 2024. Other jurisdictions have reported, and our own assistant DPSCS commissioner has said, that it costs twice as much to keep a person in restrictive housing. So while there might be costs associated, the bill provides for significant savings with regard to removing people from restrictive housing. The department generally needs more corrections officers and improved facilities, but it is incorrect to append these needs to this bill. We urge favorable vote for HB 647 and your support for its passage into law.
Good afternoon. Benita Taylor from the Office of the Public Defender. We are requesting a favorable response to this bill. This bill addresses many concerns that we've had in the state of Maryland regarding how we treat our citizens, whether they're behind the walls or in front of the walls. In fact, one of the important things for the Public Defender's Office is that the bill currently talks about pregnant women not being able to be in restrictive housing. This bill adds women who have already had their child, postpartum, women who may have had a miscarriage, women whose pregnancy may have been terminated for other reasons. Those women should not be placed in restrictive housing as well. But what we have here is we have a bill that has a price tag on it, but we don't know what is the price tag that we are currently paying in the state of Maryland for restrictive housing. That information has not been provided to the advocates. How much is Maryland currently spending on restrictive housing in the Department of Corrections? We don't know that number. If we knew that number, if we had those reports that we were supposed to receive in 2022 and 2024, we would be able to say what the real cost would be to make some of these changes. And the changes are really meant to affect those least among us, the vulnerable among us, the folks with mental health issues, the folks who have just given birth, the people who are young adults. This is meant to make sure that they do not suffer long-term consequences behind restrictive housing. Restrictive housing has been said to create things such as individuals, severe depression, anxiety, schizophrenia, suicide, dementia, as well as increase the onset of Alzheimer's. All of this is scientific. We request a favorable result from this committee. Thank you.
Good afternoon, esteemed body. My name is Shanice Anderson, and I am the Community Engagement and Reentry Coordinator for the Office of the Public Defender. And today I request a favorable report for House Bill 647. An enormous body of research has shown that overuse and or misuse of restrictive housing can have profound negative psychological, physical, and neurological effects on those that experience it. The Prison Policy Initiative published an article in 2020 entitled, "The Research is Clear. Solitary confinement causes long-lasting harm. Placing people in solitary confinement adds an extra burden of stress that has been shown to cause permanent changes to their brains and personalities. The effects of solitary confinement on mental health can be lethal. Even though people in solitary confinement comprise only 6 to 8% of the total prison population, they account for approximately half of those who die by way of suicide. The irreparable damages caused by solitary confinement are unjustifiable and have led the United Nations to consider solitary torture unjustifiable and have when used for longer than 15 consecutive days. But this overwhelming research is often ignored in jails and prisons, where solitary confinement is frequently used as a solution to nearly every problem that arises, including disobedience, perceived threats, alleged gang affiliation, and even supposedly for individuals' own protection. Many are incarcerated alone. And understanding the damaging effects of solitary, changing these practices is more important than ever. Some of the imprisoned exhibit mental health issues that have been placed in what is called suicide watch or the butt naked cell. These incarcerated individuals should be monitored by skilled clinicians, but most times are being monitored by their own peers, also called observation aides. It is for this reason that we ask that you vote favorably for House Bill 647.
Thank you. Mr. Turnbull next. Bruce Turnbull, you can just, yep, there you go.
Thank you. Thank you, Madam Vice Chair, members of the Judiciary Committee. My name is Bruce Turnbull. I'm a resident of District 16 and I'm pleased to be able to support HB 647 legislation offered by Delegate Phillips. This legislation will place long overdue limits on the use of restrictive housing in Maryland jails and prisons. I'm appearing on my own behalf as a citizen of Maryland, but with the background of working with several Jewish and multi-faith organizations with respect to needed reforms in our criminal justice system. I want to address 2 points. First, the local officials testifying in opposition to the companion bill in the Senate seem to believe that the bill requires 7 hours of out-of-cell time for those in restrictive housing. This is incorrect. While out-of-cell time is important, the bill actually has no out-of-cell mandate at all. Second, the fiscal note for this legislation is simply incorrect. My first note on this is that the department somehow was able to tell the Department of Legislative Services that there were 5,209 individuals who spent more than 15 days in restrictive housing in year 2024. However, the department has yet to publish the statutorily required annual report on the use of restrictive housing for either fiscal year 2023 or fiscal year 2024. And really, they had over 5,000 individuals who had been in restrictive housing for more than 15 consecutive days. That's outrageous on its face. Second, every study, and there are actually quite a few, has shown that it actually costs less for people to be in prison's general population than in solitary confinement, known as restrictive housing in Maryland. And on December 3rd, 2024, during a meeting of a work group with the Maryland Equal Justice Collaborative, a DPSCS official directly stated that it costs approximately twice as much to keep someone in restrictive housing than it does to keep in general population. Accordingly, I urge a favorable report on HB 647.
Thank you. We're going to go next to Christina O'Neill.
Excuse me, Madam Chair. I thought we were doing Ms. Benjamin.
I did too, but I thought you said that you
Yes.
wanted to. So now we're going to Ms. Benjamin. Thank you. Sorry, Ms. Pellnell, hold tight. We'll get to you in just a moment.
Good afternoon, everyone. My name's Alexis Benjamin Thorne. I am the mother of Amari Wilson. I'm here on the behalf of the bill, and I'm asking everyone here to please support this bill. I'm going to ask, if everybody in this room really know what restricted housing consists of? If you don't, I do, and I can share with you my personal experience with my son, Amari. Amari is no longer here. He was murdered at North Branch Correction Facility after being in solitary confinement for over 300 days. He asked me to come here and speak for him, as well as all the other incarcerated individuals that are still currently there in isolation for more than 200 and 300 days. This is very hard for me, and I'm gonna tell you why. The restrictions for my son was as followed. He was unable to take showers. He was unable to have toilet paper. If anybody in this room know what an air tray is? Because I want to explain to you what an air tray is. An air tray is when the officers bring your tray, bag, have you go against the wall, throw it in your cell. When you open it up, there's papers and junk inside. That's what's inside the airbag, nothing. Also want to explain to you meal times. 5 a.m. for breakfast, 9 a.m. for lunch, 3 p.m. for dinner. My son was unable to have visits, phone calls, tablets, communication with his family and friends. I'm very, very concerned about these institutions up in Cumberland and the Eastern Shore, and all of you in this room should be too. And I'm gonna tell you why. There's a lot of hate crimes in those areas, and there's a lot of things going on that you guys need to know about, and I'm going to share them with you. You have COs there, and I'm not gonna say all, but I'm gonna go with majority, that are taking advantage of these individuals in this isolation. They're raping, sodomizing, and having inmates come out and fight each other. My son Amari, who loves people because I taught him to love himself. When you love yourself, you treat people the way you feel about yourself. Refused to fight other inmates that the officers wanted him to fight. And in return, he was beaten and maced. And he said he was okay with that because he refused to be a yes, sir. He bows down to no one but God. I want to also make clear in this room, my son had no felonies and he believed in God. He was not suicidal. Yes, he suffered from mental health, but mental health is not a crime, and we need to stop treating it like it's a crime. So what I would like to say is, I'm supporting this bill. I'm asking everyone to support this bill, but I also need you guys to look at who you're hiring for these facilities. Eastern Shore, Cumberland, North Branch, WCI, and what is it, Eastern ECI corrections need to be investigated because these deaths are not all suicides. My son was murdered by the staff. He had told me Mommy, I'm not coming home. They already told me. And I don't know which day it's going to be. But I need, when this happens to me, for you to go out and advocate for everyone, because I don't want no one going through what I'm going through. My son's teeth was knocked out his mouth. He was beaten. And remind you, when you're in isolation, the only people that can come to you is the guards. So my son was never no threat or felt unsafe with the incarcerated individuals. It's the staff you guys are hiring. Who are you hiring? You're hiring people who are okay and supporting and teaching people and showing them how to kill themselves. I don't understand that. What kind of people is these? Taking someone's food? Tell me where in this manual say you're not supposed to eat. My son was 165 pounds. He died at 130. 130 pounds because they was not feeding him and they would not allow us to give him food. So I have proof for everything that I'm speaking. My son had wrote letters, we have documentation, and we have names. The reason why he stayed in confinement so long is because he refused to take people's names out of those ARPs. Those ARPs need to be changed. They are not to help the incarcerated individual. How am I going to make a complaint about the person I'm handing it to? My son was constantly retaliated, and that is why he was constantly moved from prison to prison. He had no felonies. Let me be clear. He had no felonies. He's never touched a gun. My son was in prison for the first time for using his hands for assault and resisting arrest. That's what he was in there for. He was supposed to go to Bowie University. He had a scholarship. He was not on his medications, and he went out and made some board choices. But he's not here. And I want to show everybody what he came back to me as. This is what the Department of Corrections sent me back on my son after spending a year. This is what they sent me back. I want everybody to see this. This is my son. The books here, he never received because they wouldn't allow him to read. He's a big reader. And Joyce Meyer happens to be one of my son's favorites. And he was refused his books. But I want you to see what solitary confinement really looks like. You have to screen these officers. I feel these people are not trained. You have a lot of people in these prisons that have a lot of hate that we may or may not know about, but it has to be addressed. No one should be raped and sodomized and abused in solitary confinement. And if you don't do what they ask you to do, which my son refused, that's why he's not here. He's not here because he refused. Some of the other individuals had to do what they have to do to survive. Amari Wilson was not one. Okay?
Ms.
So I'm
Benjamin?
asking everyone to support this bill.
Thank you. And I know that, and listen, we appreciate your testimony. We appreciate you sharing your story, and I'm very sorry for your loss.
I don't have a loss. My son was taken. I'd like to correct that. Thank you very much.
sorry.
He was taken.
Yeah, okay. So we're going to see if we have any questions. The panel is just the folks that you've heard, and then we'll continue on with the next panel and the other folks who are on digital. Delegate Kaufman.
Yes. My question is, and I know it's an oversimplification, but my question is for Delegate Phillips. Reading the opposition testimony, they seem to be suggesting that if these restrictions come to Maryland, the sky is going to fall, and you know how it's an important management tool, and it will put more correctional officers at risk of death or injury. And so you mentioned some other states that don't do this. You know, have we seen in the states that have some of the things you're trying to bring to Maryland an uptick in murders of correctional officers or beatings, or, I mean, what happens in the other states? Has it been as bad?
Thank you for asking that question, Delegate. In the conversations that we've had with New York and with New Jersey, once again, those were the commissioners, they've acknowledged that it's been difficult to adapt to what the legislature has asked them to do, but they are adapting. They've also acknowledged that that the sky is not falling, that their correction officers, in many instances, are actually safer. And let me tell you why. What we don't talk about is what causes these frustrations inside of the prison system. Often it is the incarceral nature of being kind of in close quarters without having that outlet. We've got to figure this out, right? Particularly for, and I'm serious about this, particularly for the corrections officers. When we were in Now, I can't remember which one of the facilities. I can't remember which facility. But one of the things that the corrections officers talked about is, you know, when the prisoners are angry, they lash out. And a number of them are operating, they don't have full staffs. They're operating 3 and 4 shifts in a row. So we have a challenge in our system. A lot of it is not about restrictive housing. It's about our ability to staff appropriately. So there are a lot of issues. But restrictive housing is not necessarily the answer to keep people safer.
Absolutely not.
And if I could add, there are a number of studies that have found that there's been no increase in violence when people are not put in restrictive housing. And so the evidence is there, the studies are there. I've cited some in my written testimony. And also, the other studies have found that the recidivism rates rise for people who have been in restrictive housing in terms of the impact of what that experience has been. So not only is there no greater violence in the prison if you don't put people in, but there's more recidivism if you do put people in restrictive housing. So there's not been a cost benefit to that, that procedure, that approach to prison discipline.
Thank you, Madam Chair.
Thank you. Delegate Conaway.
Thank you, Chair. Thank you, Delegate. Thank you, panelists, for coming in to testify. To the panelists that spoke about the ear tray, what is the purpose of an ear tray?
Control. They have control and power over the incarcerated individuals. You don't do what they want you to do, or maybe they get something out of it, but they are denying a lot of the individual incarcerated individuals food. My son happened to be
so
one.
Instead of food being in the tray, it was just papers?
Papers. They would take the food out, the people you guys are hiring.
Thank
Yes.
you so very much for your explanation.
The people that you guys are putting in these positions, I think they need to be replaced with robots.
Delegate Taylor.
Thank you, Madam Chair, and yeah, I'm very sorry for what has happened to your son.
Thank you, because he was not a loss. Right, he's my son. Right, and he was he would have been a great asset because Amari was going to be an educator.
Absolutely.
And we need more educators in.
The members of this committee were mothers, were parents. We don't hire. So, well, let me direct this to Delegate Phillips. Knowing the torturous nature of restrictive housing or solitary confinement, why 17 hours? Why not get rid of it altogether?
I'm with you. There you go. Sorry.
That's a good question.
I'm sorry. I'm with you.
I think corrections officers and the correction system would say that there needs to be some way, particularly around disciplinary confinement, right? Restrictive housing or solitary confinement. And often, I think in New Jersey, what they talk about is the incentive factor associated with maybe using restrictive housing to improve one's behavior. And they actually do step down. So they might say, you know, you're on restrictive housing, you get 2 hours a day out of the cell. As your behavior is modified, you get 3 hours, 4 hours, et cetera. But in the correction system, they believe that it is a tool. The question is, at what level does this tool just become something that you use because it's the easiest way to deal with an individual, where we're not really rehabilitating, where we're not really moving them to a place where they will, where we're rehabilitating. We want them to come out. This idea of recidivism, Maryland's recidivism rate is over 40%. Virginia's recidivism rate is somewhere around 26%. There are all types of reasons for that. I'm beginning to believe, just because of the time that I've been spending on this, a lot of it has to do with what happens to those that we incarcerate and the way that we incarcerate them. It really does not inure to the benefit of reducing recidivism. We return people that are very angry.
Yeah, I think sometime during, Madam Chair, is it okay? I think I read, we instituted solitary confinement somewhere in the 18th century. And then we removed it during the 20th century, early 20th century, because we realized how egregious it is. And then somewhere in the 90s, maybe, when we were tough on crime and we're in a lot of these issues that we are now digging ourselves out from under, were instituted. I'm trying to find a question in here somewhere. Yeah, isn't that so?
Isn't that so?
All righty, seeing no further questions, that concludes this panel. Thank you very much.
Thank you, Madam Chair. Thank you, committee members, for listening.
Thank you. I'm going to call up the next panel, and since we already have Chris Zacharias online, and we have Christina Pell-Nell online, we're going to also hear from Karen Clark, if she is here. Karen Clark?
Yes. Yes, I'm here.
Okay, can you come on up? Thank you. Heather Warnken? Terry Speaks from Out for Justice. No Terry Speaks at the moment? All right, we're going to go ahead and start. Ms. Clark. And what's your name, sir?
Speaks.
Oh, great. Okay, come on down. So, Ms. Clark, and then we just work our way down. Thank you. Each of you will have 2 minutes.
Okay. Well, I am Karen Clark, representing the Unitarian Universalist Legislative Ministry. It's a statewide group. And good afternoon, Vice Chair and the committee. Restrictive housing, formerly known as solitary, continues to be a topic in our judicial system. How do we deal with creating a safe and motivating environment within our prisons when individuals are struggling with trauma, mental health issues, addictions, and so forth? One of the unique situations has been discussed of pregnant women, and this presents challenging situations. Several years ago, she would have been kept in her cell under solitary for the last 3 months of her term. Even earlier than that, there was a policy to shackle the legs to the birthing table. This bill includes detailed care management that addresses multiple situations that calls for her treatment to be as close to the normal care that she would have on the outside. Efforts are now being made to make the solitary confinement as close to normal as possible. Juveniles are now to remain in a regular prison environment unless there is convincing evidence of personal harm to the juvenile himself or her or others. They are placed in restrictive housing. They are to receive daily mental and physical assessments to affirm when they may leave solitary. While in solitary, both of these pregnant women and juveniles can receive phone calls, visits, and mail. You see a trend towards efforts being made to improve the conditions that those in solitary are experiencing. And again, the UN is saying no more than 15 days as torturous, and that is in the bill. You may, for the next, you may have in 60 days, no more than 20. So between the 2 months, it's lessened. Okay, so could I add one more thing?
If you could just finish the next sentence, and then perhaps there'll be questions, Ms. Clark.
I didn't write this in, but the correctional ombudsman that we worked so hard to get established is listed in this bill to make unannounced visits, do daily logs, and administer anonymous surveys. Thank you.
Thank you. Mr. Speaks?
Good afternoon, Vice Chair, delegates and senators. I come here today from my personal experience when being incarcerated and spending time in solitary confinement. I'm firsthand witness of PTSD, how you're being isolated inside 23 hours a day without sunlight, sometimes not showers, depending on how the officers feel. Sometimes when your food comes, it's cold. The only thing that ever got me through solitary confinement was my spirituality, belief in God. And I also know firsthand how correctional officers use you being into solitary confinement as not just to punish you, but sometimes they do it out of spite because they have the power to do so. It's no regulations. No other CO is gonna go against another CO. And when you try to pull up, whether it be a higher up, it is what it is. No one ever really addresses the PTSD from people that's been in solitary confinement once they are released. And then we wonder why the recidivism rate and things of that nature is high, because nobody worries about the trauma or the triggers that one suffer. But if I was in a war zone and I was over there fighting for this country, they would worry about the PTSD. When you take a person out of the environment and you put them in a brutal environment with no structure, they're gonna suffer PTSD, they're gonna suffer depression, they're gonna suffer a lot of forms of different things inside that environment. To isolate people with no sunlight, lack of rec, and sometimes you don't even get a chance to go out your cell to stretch your legs if the officer doesn't feel like opening the door. If someone disrespects another officer, it has nothing to do with the entire range. They penalize the entire block. I suffered this. I've seen inmates next door to me hang themselves. Thank you.
You can finish that thought. Were you going to give another example?
I've seen a lot of different things. I'm not saying individuals shouldn't be punished for doing wrong, but when you isolate them and you take them out of sunlight and you put them inside a room for 23 hours a day, on their psyche, it affects them. I've witnessed this. And you put them in there for 6 months, sometimes a year. But thank you.
Thank you. Thank you, Mr. Speaker. Ms. Warnken?
Good afternoon, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law. I'd like to focus my brief time today on the critical importance of this bill for addressing the unlawful and highly problematic misuse of solitary confinement for one of the most vulnerable groups of incarcerated individuals, those who are transgender. According to U.S. Department of Justice data, incarcerated trans people are nearly 10 times more likely to be sexually assaulted than the general prison population, with an estimated 40% of trans people in state and federal institutions reporting a sexual assault in the previous year. I've heard in previous hearings on this issue pictures painted of people placed in solitary as either extremely dangerous or having self-selected for protection. Yet in Maryland and across the country, it is well documented that LGBTQIA+ individuals are routinely placed in segregation against their will as a, quote, protective measure, effectively punishing and harming them as a response to their high risk of victimization. These individuals also face disproportionate risk of being placed in restrictive housing as retaliation, including for attempting to report harassment or abuse. Our center's recent published analysis in partnership with the Trans Rights Advocacy Coalition on the treatment of trans incarcerated people in DPSCS documents that the department's own data demonstrate disturbingly high rates of placement in restrictive housing. These problems persist, notwithstanding legal protections against them, as well as the auditing and reporting mechanisms under PREA, and notwithstanding multiple lawsuits brought against the department alleging in horrific detail the violence and suffering endured behind the walls, including misuse of restrictive housing. The department entered into 3 settlements with incarcerated or formerly incarcerated trans individuals in 2024, amounting to more than a third of the settlement dollars paid out by the department last year. HB 647 provides an important step in addressing what should truly be an intolerable source of human suffering and deprivation of rights occurring for those in our state's custody and care. Thank you.
Thank you. Christina Pelnell.
Hi, thank you for having me. I'm here to testify today on behalf of my 21-year-old son, Herbert Randall. He has been in solitary confinement for over 2 years of his 3-year incarceration so far. He has been put into administrative segregation or disciplinary segregation, not for anything violent, 16 tickets for drug use, which I don't understand why there's drugs in prison, but he's never done anything violent or hurt another person. And he spent 2 years in solitary for either drug use or for his own protection from other inmates or guards. He has not been given medication for schizophrenia since he's been incarcerated for 3 years. The psychologist told me about a week ago that the reason why is she was never able to get in because he was in solitary confinement to do the evaluation or give him medication. He has been without a fan in the summers where the cells reach over 90 degrees and people flood their tears in order to stay cool on the cement floor. And he was also put in solitary confinement for that. He was denied a blanket for November, December, January because you can't place an order for things out of the catalog for 3 months at a time. He has been in solitary for over 5 months at a time, denied food, denied medication. I have only seen him twice since June because you're not allowed to have visits. You're not allowed to go make, doctor calls. And if you are, it takes sometimes 4 weeks. He's had 2 staph infections that he almost died from. He's been seriously injured and abused by prisoners and guards, sent to the hospital with gashes in his head. This is cruel and unusual punishment. This is not what this country should have. And I'm here to testify that this bill should pass because my son and everyone else should not live in this kind of conditions. Animals do not live like this. We would sue if animals were treated this way.
Thank you, Ms. Neal, for your testimony. We're going to go now to Mr. I have you right here, Mr. Zacharias.
Thank you. Good afternoon. My name is Pastor Zacharias, and as a member of the faith community and executive director of the Interfaith Action for Human Rights, I'm submitting this testimony in favor of HB 647, which aims to place restrictions on the use of restrictive housing in Maryland jails and prisons. Studies have shown that prolonged solitary confinement causes mental trauma, heightens the torture and unfair treatment experienced by incarcerated persons. Solitary confinement for 15 days or longer is considered torture and results in immediate and permanent long-term effects on the psyche of the incarcerated individuals, and has supported a limit of no more than 20 days in a 60-day period. Unfortunately, restrictive housing has not been favorable to any incarcerated person and deprives them of the various human rights and respectable treatment. This is especially true in the state of Maryland, where the use of restrictive housing is among the worst in the country. The Department of Public Safety and Correctional Services has hidden its practices for the past 2 years. The annual reports required to be issued by the end of each calendar year for the preceding fiscal year has not been issued for 2023 or 2024. In fact, in the fiscal year of 2022, it shows that Maryland overuses restrictive housing with an average stay of 42.5 days. So I'm hoping with the help of the Maryland legislators, a move to lessen this crisis will go a long way. So thank you for your attention, and I hope your actions will be favorable on HB 647. Thank you so very much.
Thank you. Thank you for your testimony. Do we have any questions for this panel? Seeing none, that concludes this panel. We're going to move to Mr. Donald. I saw Mr. Donald Bovello. Did he drop off? Is he still there? He is there. Can you go ahead and bring him in, please? Hi, Mr. Bovello.
Good evening. How are you this evening?
We're doing great. We don't see you anymore. We can hear you. Oh, there you are. Okay.
My apologies. I'm on my way to my last job, but I am
Mr. Bovello?
Yes.
You're driving. I'm sorry. You're going to have to, we have a policy. You can't testify while you're driving. If you pull over, you can testify.
I'm pulling over right now.
Okay, great.
All right, here we go.
We want to make sure you're nice and safe. All right, perfect.
All righty, here I am.
Okay, so you go ahead and you testify. You'll have 2 minutes. Thank you.
Thank you so much. Good afternoon. Thank you, honorable members of the House Judiciary Committee, for allowing me this opportunity. My name is Donald Bovello. I was incarcerated in the state of Maryland for over 35 years, serving a life and 20-year sentence. I was released via the GRA, and I spent 2 times in restrictive housing, not including the 2-year lockdown for COVID-19. To be brief as possible, I totally understand correctional officers wanting to use this as a tool. They have a very tough job. The problem is that if you give someone something like a weapon and they go out and they use it and then they get comfortable with it and they use it again, then they use it again, and it just becomes repetitive when they don't really need to use it. The same thing has happened with restrictive housing in the state of Maryland. It's become overused. Restrictive housing causes mental and emotional problems with anyone that is put into it because of the isolation and feeling so alone while you're there, being removed from human contact except for a hand handing you a tray through a slot. Restrictive housing is a tool, but it's overused in the state of Maryland, and I'm asking for a favorable report on this bill so that it can be limited and that other tools can be used that actually correct behavior and modify behavior. So when individuals are released from prison, they're released from prison not as a detriment, but as an asset to society. Thank you for allowing me this opportunity to speak, and thank you for your service to the state of Maryland.
Thank you, Mr. Bovello. We're going to move to Ms. Magdalena Songdas.
Thank you, Vice Chair and members of the committee. My name is Magdalena. I'm submitting this testimony as a family member of an incarcerated person in Maryland. I also lead the Maryland Second Look Coalition, and we have many family members who have loved ones serving extreme sentences. My own loved one spent a total of 4 years on and off of solitary confinement, starting at 20 years old, an experience of profound isolation that still impacts his mental health. While visiting my loved one in prison recently, I sat next to a mother who shared that her son was on restrictive housing for his mental health, and she believed that because of his mental health condition, he would always be on that restrictive housing. And for her, that means she will never get to hug her son through his decades of incarceration because they can only meet through a piece of plexiglass for 30 minutes. And that is only one of the many types of solitary confinement that Maryland employs. But I think it's very important to mention too, as Donald said, that the reality is for people in particularly the Eastern and Western facilities in Maryland who are in general population, they are facing lockdowns more often than not that mirror the same conditions that are in solitary. I spoke to a mother whose son is at Eastern Correctional Facility last week. They were on 23-1 lockdown, so the entire facility, everyone was locked in for 23 hours. I spoke to a woman whose husband is at WCI last week. They got out for 15 minutes that day to take showers, and that was it. And these are people who have decades long sentences, and the majority of the time, the whole facility is locked down. So as we're working to address out of cell time for individuals, we also need to realize that we incarcerate 16,000 people in Maryland, and we have double-digit staffing shortages that have been on for years. So without thinking through avenues that can release people who are no longer a danger to the public, like Second Look, we will continue to see lockdowns that mirror restricted housing use. I urge a favorable report. Thank you.
Thank you. Thank you for your testimony. And I'm asking for questions for either Mr. Bovello or Ms. Magdalena, and I see none. Thank you so much for being here and for being virtual and providing your testimony. Okay, we're going to move now to favorable with amendments. Lucianne Parsley is the only name I have for favorable with amendments. We still have the unfavorable panel to go. Okay, Ms. Parsley, you'll have 2 minutes whenever you're ready.
Great. Good afternoon, Vice Chair, members of the committee. I'm Lucianne Parsley from Disability Rights Maryland. We're the state designated Protection and Advocacy Center for Persons with Disabilities for the state. Over the past decade, DRM has investigated mental health care and conditions for individuals with mental illness in our state correctional facilities. We've found the care and conditions seriously inadequate, and individuals with disabilities and segregation are exposed to harm and significant risk of harm. We're grateful to Delegate Phillips and the sponsors for bringing this bill, and grateful that House Bill 647 limits the use of restrictive housing for individuals with disabilities. However, we would like to propose 2 amendments, both to the definition of restrictive housing. First, as currently drafted, the bill would continue to allow unlimited use of restricted housing for up to 24 hours per day for individuals with mental health disabilities if they are in a clinical area of the facility, which is not defined. My understanding is this exception was included based on the HALT law in New York, which does have clinical standards for its clinical programs. Maryland does have some clinical programs, but they are restrictive housing. There are no standards for getting out of cell and very little standards for actually receiving mental health treatment. Our second amendment would remove the reference to clinical services and substitute, our second amendment would bring into the definition of restrictive housing people with disabilities who request to be in restricted housing due to credible fear of harm if they're housed in general population and have not been offered protective housing, protective custody. We routinely meet with people who request to be in restrictive housing. Not every facility offers protective custody, and we believe that people should have the right to get out of their cells and have programming if they're in that situation. We respectfully request. Thank you.
Are there any questions? And there is Delegate Conaway.
Thank you, Chair. Thank you for coming in to testify. You said on the First Amendment, you used the term clinical areas. Is that correct?
Yes.
But you're saying that clinical areas is undefined?
It's not defined in the bill, Delegate Conway.
Is it defined in the code?
No, I don't believe so.
So therefore, if we adopt your amendment, it kills the bill.
No, I think what we actually, in my written testimony, we suggested alternate language that would allow for the use of restrictive housing if there was a contagious issue, an issue of contagion for the individual, or the person presented an imminent risk of danger to themselves or others due to their disability. And that could be extended for another, so that would be limited to 7 days and could be extended.
That's wonderful. Can you tell me exactly what is the term that you would use to replace clinical areas?
We would use, when there's a contagious condition or a need for quarantine, or for up to 7 days, 7 calendar days, when the individual is suffering a mental health crisis and presents an imminent risk to their health or safety that cannot be mitigated with less restrictive measures, which exception may be extended for an additional 7 days.
Thank you very much.
Any other questions? Seeing none, we thank you very much. Now we'll go to those people who are testifying against the legislation. Thomas Reese, Daniel Lasher, Ryan Ross, Daniel Galbraith, and Sarah Sample. Whoever would like to go first should go right ahead, and we'll go from there.
Thank you to the chair and members of the committee for having me. My name is Sarah Sample. I'm here on behalf of Maryland Association of Counties, and we are here in opposition to House Bill 647. I'm speaking on behalf of the local detention center, so I just want to make that clear. We also have a number of professionals here, so they're going to get into more of the nuances and the details of the facilities and the bill. I'm going to speak to the fiscal impacts. We did send DLS a good amount of information just in terms of what the fiscal impact is on our facilities. That did not end up in the fiscal note, so I'll go through some of that now. One of the major concerns is that the new definition for restrictive housing requiring 7 hours of out-of-cell time is that we just don't have enough space in a lot of these facilities to abide by that number. The other thing is we don't have enough staff in some of these instances. Our other concern is that even if we did try to get to those 7 hours of out-of-cell time, we didn't have that staff and we didn't have that space, that we would end up being in a situation where we have significantly more liability because of someone getting hurt, either a detainee or an individual. So, and I also would add that we did get a quote on what it would potentially be to add new areas of our facilities, and I think it was Director Ross that got the quote that it would be about $30 million to add a new wing. So those are some of our concerns, and I also just wanted to speak a little bit about the fiscal climate for the counties right now, because I don't want you to hear that we're coming in and saying that these things are expensive and they're not important things to do. I just want you to understand some of the situation that we're in, because we do have very limited revenue authority, and 2/3 of Marylanders live in counties where they are already at the max income tax. And then we also have the property tax as a mechanism, but we know if we lean on that too heavily, it is going to make housing even less affordable than it already is. But on top of those circumstances, we have mandates that we're trying to fulfill that the state has handed down. I know everyone's pretty familiar with the blueprint. We can see from our most recent estimates we got from DLS that it is about $500 billion more expensive for FY26 than it was originally anticipated. And then on top of that, we are also covering costs of things like medication-assisted treatment that you heard earlier, things like the care for individuals who are in our facilities that need to go to a state facility. That's just to give you a little bit of a picture. Thank you so much. That's the fiscal impact that we're concerned about.
Why don't we start from my right to your left and go that way.
So, good afternoon, sir and members. My name's Warden Dan Galbraith, Harford County Sheriff's Office Detention Center. Local detention centers house inmates committed to them by judges after a review by the judge as to the inmate's threat to the community, threats to others, and other factors. If an inmate was not a threat to the community or a flight risk, the inmate probably would be released back into the community. Judges' commitments on their face value places inmates in restrictive housing, detention centers, and not released back into the community. One of the most concerning aspects of House Bill 647 is the drastic reduction in allowable restrictive housing hours from 22 to 17 hours within a 24-hour period, combined with the bill's proposed limit of 15-day consecutive days in restrictive housing and a cap of 20 days in a 60-day period. If these changes would severely hinder our ability to manage individuals who pose serious, persistent threats to the safety. If this body feels that the proposed change is the right way to manage all inmates incarcerated, then propose legislation to release all inmates after 15 days. If you feel that's all it takes to change an inmate's bad behavior, I hope you agree this will not work for all inmates in our care and custody. These changes fail to account for the realities of prison and jail dynamics, where dangerous behavior sometimes require extended confinement to ensure safety. For an example, individuals involved in violent incidents or those who present serious threats to themselves or others may need more than 15 days for de-escalation, monitoring, or assessment. By restricting our ability to address these behaviors properly, we risk increased tension within the facility, potentially leading to higher incidents of violence. I'm asking for an unfavorable report.
Thank you. Thank you. Sir?
Good afternoon. Thank you, Chair Clippinger, Madam Vice Chair Bartlett, and committee members for this opportunity. I'm Ryan Ross. I'm the president of the Maryland Correctional Administrators Association and the director of the Charles County Detention Center. I'm also joined by the dedicated local correctional professionals on this panel and in the gallery behind me. Concern raised in Senate Bill 702 is the establishment of vulnerable population, those under 21, over 55, and those perceived to be LGBTQIA+. While these groups have unique needs, behavior, not demographics, should determine placement, especially if individuals pose safety risks and degrade other detainees' living conditions. Risks must be assessed on a case-by-case basis, not based on age or gender identity. The bill's approach overlooks the complexity of correctional management and the dynamics of human condition. Although Subtitle 10 applies to state correctional facilities, as professionals in the field, we believe it's important to share how these changes could impact safety in any correctional setting. Our goal is best outcomes for detainees, their families, and staff. We're open to conversations to help shape effective, feasible policies. We welcome fact-checking and unannounced facility visits by this committee. Come to my facility, catch me doing the right thing. Local jails are subject also to the most stringent state standards, including regular audits by the Maryland Commission on Correctional Standards. A lot of our facilities, we pursue even higher certifications through the NCCHC and the ACA, and I can answer questions about that. These assessments ensure compliance with safety and health requirements and ensure that restrictive housing is used responsibly. Placement in restrictive housing is not automatic. We are rule followers, as we've said in our other testimonies today on MAT. There's thorough approval processes, assessments by case management, medical, mental health professionals. It really ensures that it's only used when necessary and for as long as essential. Local correctional management is progressive. We prioritize safety, rehabilitation, and mental health care. This approach is a far cry from outdated stereotypes. Restrictive housing is used judiciously. I respectfully urge this committee to issue an unfavorable report on Senate Bill 702. Thank you.
Good evening, Mr. Chairman and members of the committee. I'm Major T.D. Reese, the Administrator of the Calvert County Detention Center, and I'm speaking in opposition of House Bill 647. A simple formula to describe a local jail's population. 90% of all inmates held in local jails are no issue at all. They know why they are in jail, they accept their situation, and patiently await their court date. This population does not want other inmates running the facility. They only want to do their time and not be bothered. Approximately 10% of a local jail's population wants to continue to operate their hustle or their crimes while incarcerated, using fear, intimidation, and cunning to enact their will over others. They do not like rules or regulations, nor are they prone to abide by any. Within this 10% of this population is 3% that are dangerous to the other inmates, as well as staff. This 3% of the inmate population desires to be in control, to lead others. The other 7% in bullying, assaulting, stealing, and intimidating the other 90%. One major responsibility of a correctional officer's job is to ensure this 3% is not successful. When this small segment of the population acts out, no matter the degree, there must be a reaction by the staff. The 90% is watching us. Remember, they have to live with them. They know it is our job to ensure a safe housing unit. A sound and orderly and consistent disciplinary system shows our support to the 90% that are not a problem. If the 90% believes that we do not care about them and we are leaving them to the mercy of the 10%, then all 100% become a problem, and the facility is impossible to manage, it is inefficient and unsafe for everyone. The use of restrictive housing is an essential tool available to shift supervisors to protect and reassure the 90% that we do care about them, and we do appreciate their appropriate behavior. It encourages the inmates to let us handle the problems through the use of the disciplinary process. The inmates do not need to handle the situation on their own. This very restrictive bill will erode the control and result in chaos, as it already has in New York and New Jersey. I ask that you please support MCAA and all rule-abiding incarcerants in Maryland and the state prison system by opposing Bill 647. Thank you.
Thank you, Chairman, Vice Chair, committee members, for the opportunity to testify. I'm Captain Daniel Lasher of the Allegheny County Sheriff's Office, and I'm here in opposition to House Bill 647. On February 17th, correctional officers in New York began a strike due to understaffing and unsafe working conditions, with the governor activating the National Guard to assist in operating those facilities. The latest agreement to stop the strike provides for a 90-day suspension of the HALT Act, legislation that did just what this bill proposes. Since the implementation of the HALT Act, inmate-on-inmate assaults in New York are up 169%, and inmate-on-staff assaults are up 76%. This according to Congressman Nick Langworth of New York. In September of 2024, our legislative committee met with the administrators from Massachusetts to discuss how they have adapted to similar legislation there. They informed us that they have had to spend tens of millions of additional funds to restructure facilities, hire security staff, counselors, mental health professionals to meet the needs of this legislation, and they still, in instances, have to use restrictive housing. In 2022, the same legislation came before Governor Newsom in California. He vetoed the bill, siding with law enforcement and correction officials. In 2023, the U.S. House H.R. 4972, the End Solitary Confinement Act, died without receiving a vote. In 2023 and 2024, the Solitary Confinement Reform Act in Rhode Island died in committee. And in 2024, the governor of Virginia vetoed similar proposed legislation. It's important to point out that over 200 people in local facilities are awaiting transfer to the Maryland Department of Health, who by law, they should have taken custody of within 10 days. I have 17 currently in my facility, averaging 60 days waiting for MDH for a bed. And I've had 3 over the past year who were there with me for 150 days or more each. These people cannot be housed with others. The United Nations Mandela Act is often mentioned in these hearings. I'm pointing out that if you read the Mandela Act, the rules adopted by the United Nations also state that untried prisoners may order food procured at their own expense, such as DoorDash, and it directs Rule 81 that facilities with men and women prisoners that in the area set aside for women must be under the authority of a woman, and that no male staff member can enter without a woman staff member to accompany them. Quite a huge step backwards, so not everything in the Mandela Act is what Maryland would want. I humbly ask that you vote unfavorable on HB 647.
Questions for the panel, starting Delegate Grammer.
Thank you, Mr. Chair. Gentleman on the left on the end here, you said you're waiting for MDH to get back to you because of lack of beds. What type of beds are you referring to?
Well, they were committed in a court of law to the Department of Mental Health for mental health beds.
Some shortage of mental health beds.
We're always at 200, 220, 190. We're consistently waiting on beds from MDH. So these individuals, and there are a few, don't get me wrong, but if I were to use an example, I currently have 29 people in my facility. I have 153 people in that facility. 29 right now are somewhat segregated somehow. 17 of them are awaiting mental health beds. 2 or 3 of those can associate with other people. The rest cannot. Then I have, for lack of a better, I have sex offenders who other inmates don't want to be around. So I have to maybe house a few of them together if they get along together. And then there are some disciplined people. So if I were to look around this room and fill every one of these chairs, that's roughly the number I have. And then trying to get those individuals out 6-7 hours a day, and there's not enough space, not enough time in a day to do that. We're trying to protect people. You know, and again, take that 17 away from me. Yeah. It's a little bit more manageable.
Shortage of mental health beds. We continue to hear about that. What's the total number again that you have waiting?
I have 17 in Allegheny County awaiting beds.
Total statewide?
Oh, there's, last number we got was 233.
Right. Thank you so much.
You're quite welcome.
Thank you, Mr. Chair. I wanted to know, on the Governor's Correctional Commission report, the standards report that you get, does it, I know it asks that interviews are taking place by the audit team, but are any of those persons that are interviewed, inmates that is, do they come from the isolation at all, or they're just traditional inmates that are not in isolation?
But no, ma'am, they're from general population.
Okay.
But they review all of the documentation that we're required to keep on every person in restrictive housing. The time out of the cell, cleaning equipment, all the different things we have to log. The Standards Commission reviews and requires us to keep all that documentation.
Okay, so they wouldn't capture some of the things that we heard today, like the no toilet paper, the air trays, and no showers?
I mean, they do a complete facility tour. I mean, I think they would pick up on, you know, if areas in our facility were that they described were like that. I think the audit team would definitely pick up on it.
I'll speak to that real quick. That is not anywhere in the culture of local corrections, period. I will tell you that, and I'm not just speaking for the Charles County Detention Center. I put my words on the line for all the local detention centers. That is not in our culture. We don't do that flat out.
Mm-hmm. Yeah, and I can attest to the fact I used to monitor all y'all's reports because I was on the Correctional Commission. So yes, you do a stellar job, but I guess because we don't have a state sitting in your seats right now, I just wanted to remember from about, 10 years ago or more, what your reports look like. And I couldn't remember, we're talking about isolation, if that was inclusive of someone who was in confinement. That was where I was going with that particular question. So thank you for that information, and that's all.
If I can just add, they do ask those inmates in the interview about the disciplinary process, and do they consider it to be fair? And so the question is asked to them, and they answer the.
Oh, so they do get a question?
Yep.
Okay. Thank you so much, sir.
Delegate Coles.
Thank you so much for being here. I just had a couple questions. Can you speak to the process for putting an inmate in solitary confinement? Walk me through what that process would be. Because on the favorable panel, many of the individuals mentioned, you know, inmates not getting food. There was obviously some interactions with law enforcement. So could you just speak to what that process is like and then what happens in terms of inmates getting fed?
Certainly. I mean, I can answer for my facility. I guess we're all somewhat differently. Everyone has a different set of rules in their facilities. All our facilities are not cookie cutter. They're not the same, but you can be placed in a housing. Now, first of all, I'll tell you, I have no solitary confinement. That doesn't exist. There's no put you in the hole. There's no, every cell has sunlight. It's air conditioned in the summer. It's heated in the winter. There's an officer in the unit with the prisoners at all time. If they need something, they knock on the door. The officer goes over, answers the question. They can be there from, if they had a disciplinary issue, generally they're in their general housing unit in my facility until they get a hearing within 48 hours. And then if they are found guilty and given 10 days, they're taken over and placed in that unit. And then dependent upon the amount of inmates that are in there, I mean, everyone gets at least 2 hours. But if for some reason I've only got 7 people in that unit, then I'm going to get them out if I can get 2 or 3 out and give them more time. They're all fed the exact same food that everyone else has. They're not fed at bizarre hours. Bizarre hours would come into play when I do have, say, 19 or 20 people in that particular unit, like I do now, or between 2 units with 17 MDH. Some of those folks may not get out until 2 a.m. in the morning. And that's very difficult for their families. But that's the only way I can get when you have that many people out those hours of the day. We have to run 24 hours a day. They all get a shower. They all get clean sanitary supplies constantly. They're allowed to sit and watch television, depending upon what they're there for. They can call home. They can get on a tablet. It's probably a little different in each institution. So, I'll take this opportunity to say, as we have said every year, please show up at my facility. Please come unannounced at any time. I've got nothing to hide. I would love to walk any of you or all of you through and let you speak to anyone as freely as you would like to speak. And I'm sure someone would say they're probably being taken out back and flogged, but you can sit and watch. They're all sitting there in their cells. Our housing units are constantly under supervision. My unit's half the size of this room, and it's got 6 cameras in it. So everything is to be seen at all times.
Okay, if I could follow up, Mr. Chair. So you make it sound like a country club. And I don't think these individuals that came in are making this up. We had a woman whose son was taken. You had, another woman who I was concerned. She said her son was 20 years old. And it looks like under 21 years, they are considered a vulnerable population. So, to me, it's very concerning to me. So could you just further explain what's the difference between the restrictive housing and what you're saying where there's sunlight, they get meals, they get...
Well, that is my restricted housing. If it were general population, my officer will come in at 8 o'clock in the morning. Okay. He'll go around and do a head count of everybody. He'll inventory all of his equipment, and then he'll pop the door at 8:30, and all 60 prisoners will come out into the day room and spend the day out there. They'll watch television, they'll play checkers, they'll play cards, they'll make coffee. There are those types of things. Again, please, you're welcome to come see. When there are altercations there, let's say there's a large fight or someone floods their cell, and for many reasons, who knows. But if they're given a disciplinary and removed and taken to that unit where we segregate, then they're not going to have that opportunity to be out all day. They'll be out 2 hours. It might be out 3 or 4, but it depends on how many people I have there. But everybody gets their 2 hours out. And honestly, that could go away too if while they're in there, and this has just recently happened, you need to be there to see that, is someone's in there and about their second day in there, and they're upset because they can't get out when they want to come out, and then they decide to flood the cell, or they smear excrement all over everything, or throw urine, or because those things occur in these institutions, and then that individual will lose that privilege for a while.
And just a follow-up, Mr. Chair, thank you. There was some talk about mental health. I mean, it's a real issue, I think, not just obviously within our, prison system, but I just think all over the country. And how do you handle individuals? There was, again, on a favorable panel, someone who mentioned, their son had mental health issues. How do you handle that? Do you have a mental health specialist in there that is trained that could know how to, mitigate the situation?
If we don't have them in the facility, we do have them, they'll have to telemed, and we'll have to do it that particular way. But there are counselors and social workers in there. There's someone for them to talk to if that's a necessary item. But
no, I'm saying your officers what is the training like?
Oh, my officer.
Do you get training for mental health so that you can
No, because not in my facility. Not, I mean, they may take, that may be part of their training this year. They might have a mental health class, but it might be a one-day class. It's not that we send them away to school for that, only because those same officers don't work those units all the time.
Knowing our mental health has increased so much, and particularly within, that could be in the prison population, would you be open to having some mental health training for your officers on maybe more than a one-day class, but some detailed mental health training that could help diffuse?
Well, it'd always be, I'm open to any training as far as we can get training.
All right. Thank
and then
you,
we
ma'am.
also like to have funding for that training, but I do believe Dan.
Yeah, I
something.
think, ma'am, the one thing about special confinement, whether it be restrictive housing, PC, or admin say, in Harford County, every Thursday at 9:30, I have a team of individuals that get together. It's mental health, medical, classification, security, administration. Every week, 9:30 Thursday, we sit down and we talk about everybody that's in restrictive housing. We go over their medical issues, their mental health issues, any disciplinary issues. So that's Thursday at Thursday at 9:30. Senator Delaney James, I was testifying 2 weeks ago over in the Senate, and she had come and sat in on one of our special confinement meetings. And she told the other senators it was amazing what she saw and how detailed we talk about these individuals. We don't lock them away in a cell. We care about them, and we want to make sure we're doing the right thing. So come to Harford County, Thursday at 9:30. See what we are doing up in Harford County. And I'm sure my other partners.
I don't even know what Harford County is. Just kidding. But okay. I don't know where Harford County is, but no.
Follow me. I'm going there as soon as I leave here.
I'm going to be here till probably about 9 o'clock. So.
All right.
I'm kidding. Thank you, Mr. Chair.
Thank you.
Delegates
Delegate Simmons, then Delegate Phillips, then Delegate Taylor.
Thank you, Mr. Chair, and thank you all for coming out to really explain to us the process and some of the experience that is going on behind the wall. Can you talk a little bit about the differences? Because I think we're kind of focusing on the conversation on state facilities and y'all are county facilities, no? So can you tell me the difference of operations when it comes to a county facility compared to an escalated state facility with level of charges, time served, and your authority line?
Yeah. Well, local facilities, we're short-term facilities. The longest somebody can be incarcerated in any of our facilities by state statute is 18 months. We are independent in each county, meaning that we don't have other facilities to move people to. All we have is the different sections and different wings that are already established. So this idea of moving people around the state, we can't do that necessarily. From that aspect, does that answer your question to that point?
Yeah, absolutely. Can you talk a little bit about, so obviously, y'all been sitting here, you've been hearing some of the testimony and the idea that, folks are going into the facilities and they're being escalated into these isolation areas. Can you tell me out of each of your units, each of your facilities, do y'all have isolating units for prisoners as well? And during that time, what would be a reason to put someone in an isolated unit? What would be some of those reasons?
I think we all, in some semblance, have units that we isolate certain parts of the population away. We reserve it for one, if it's of a disciplinary nature, you've committed one of the worst offenses in the jail, which would be some kind of assault, some kind of serious theft, things that would disrupt the order of the facility. And really, we talk about these different groups. Basically, they're creating victims. So that's why we would place them there. To the point we talked about with the MDH folks that we have, we all do everything we can to get them time out. One of the big things is, Dan here talked about, these weekly meetings. We all have weekly meetings where we're looking at our people that are in restrictive housing. And we go to great lengths to try to find ways. It's a big game of Tetris to get people out and give them as much time as possible. And it's very complex. These two people can be out, but not with this person. This person can be out with this person. This person has to be out by themselves. So we have to find ways to manage that time when it comes to the mental health piece. It's difficult. And, again, we're short term, but we're doing the best we can to get people's cases adjudicated, whether they're held locally, released locally, or they do end up going into the state prison system. And with that being said, I spoke to our culture earlier. A lot of the things that we do in Charles County, I've got Captain Lasher across here. I mean, we are very far apart from each other regionally. He is at the northernmost point. I'm at the closest southernmost point. But for the most part, we do things the same way. In addition to these weekly classification meetings where we're taking a look at people, in my facility, I'm NCCHC certified. If you don't know what that is, National Commission on Correctional Health Care. So part of that certification, I have mental health professionals, LCSW, licensed LCSWs in person, go to each of my restrictive housing units on a daily basis and speak with all of the incarcerated folks in there. In addition to that, my medical group, who takes a look at that other aspect, they are in there and they're doing weight checks. They're talking to people, asking. They have access to different programs. They have access to medical care. A good way to describe this, I've talked about this with folks at my facility, and this is why it's important for everybody in here. Come visit us. Our cells in restrictive housing are constructed the exact same way as our cells in general population. They look no different.
Sure. Can you tell me this in your lifetime, and this goes for the panel, have y'all been privy to anyone inside your facility that have died as a result of homicide, suicide, or undetermined nature? And if so, how many people you say in your career at your facility?
So I've got about 21 years in. We had a string of about 3 or 4 suicides back in the early to mid 2000s. As a result of that, we went and had a total suicide audit done to our facility. In fact, we had 2 done by national experts. And the result of that was we spent a whole lot of money to make sure not just the physical structure of the facility, but also we looked at our medical contractor, who we had 2. And we went out and we paid the most money possible for the best medical contractor that had the best mental health assembly that we could get. So since that run that we had in the mid 2000s, early in that area, we have had none, knock on wood. It's one of those big things. It's terrible not only for the incarcerated individuals, but our staff too. I want to protect them from that. I mean, I can tell you from experience, I have done mouth-to-mouth CPR on somebody who's attempted to hang themselves. Now, in my case, after doing 6 minutes of compressions, I brought someone back to life, and probably one of the most incredible things outside of having my children, probably even crazier than that. So, I mean, I tell you from experience, we take the incarcerated individuals that come to us, and we treat them with great care. They matter to us. In a local facility, there's just this difference where, we do have people that we know are from our community, and unfortunately, there is recidivism. They come back in. But, there's people I talk to, whether it's in the facility or out on the street, I kind of see like we grew up together. I started at the Charles County Detention Center. I was a much younger guy, as were some of our incarcerated individuals, and we definitely have a professional relationship at this point. So it's a lot more than just jail guards and inmates. You're welcome.
So Harford County, I've been the warden for 4 years. I've had 2 COVID-related deaths. I've had 2 suicides. Both suicides have been reviewed by the law enforcement, because law enforcement comes in on all suicide, all in custody deaths. both suicides were reviewed by the state's attorney's office and finding no faults. I personally reviewed both of those cases, and our deputies did everything they were supposed to do by the checks that are mandated, by immediately reacting. We've had multiple attempted suicides where our deputies have saved people. The most recent one I'm getting sued over, where we saved an individual who was trying to kill himself, and we saved him, and now he's suing us. That inmate was only in his cell for 5 minutes before he put something around his neck to try to harm himself. And our deputy, within 5 minutes, he put him in the cell, 5 minutes he went back to get him out of the cell to allow him to take his hour shower. And in that short period of time, and he was unconscious and blue and had no pulse. We saved the man. There's so many saves where people try to harm themselves because they're in jail. Some of these people are going to be in jail the rest of their life. And the mental health, and we've increased in Harford County. I've almost doubled my mental health staff. I have mental health staff there 7 days a week now and into the evening because I know mental health is so important. I care about these individuals. We up in Harford County, if you want to come quality incarceration, I preach quality incarceration to my staff, to the inmates. Quality incarceration is excellence. Excellent training, excellent care that we provide.
Okay.
Quality incarceration.
I've let the question, I'm sorry. No, the other two can respond in writing because this line of questioning has gone for about 15 minutes. Delegate Phillips.
All right, thank you, Mr. Chair. And I'll try to be brief. In the bill, it does talk about 17 hours of in-cell time, but that is for definition. Do you all understand that? So that would be the definition. And for your facilities today, one of the things you mentioned is that what you consider restrictive housing are all of your, what we might call restrictive housing, are the cells the exact same as your general population? So much of this bill, as you all know, is focused on state facilities. And last year when I brought this bill, it was much broader, but it did not include state facilities, local facilities at all. This go round, it was included more for definition and more for identifying vulnerable people. Do you generally have issues with the folks that we've identified as vulnerable individuals and actually placing them in really more restrictive housing than you're discussing, more like a federal, more like a state prison? But do you have issues with the vulnerable people component?
Well, my only question is this, in a prison system, I can't speak to that. But I will say this, in the past year, I know I've had 2 individuals under the age of 20, one that put 2 of the police officers that arrested them in the hospital, were quite violent once they got there for several days. So there's a lot of, sometimes a lot of youth anger and testosterone, or your name. So if there were a restriction that said I could not place them there, then I would oppose that, because there are times for that. But it's never the intent on our part. Our part always is let's all get along. If you assimilate back here, it's much better for you. It's much better for us. But I would see that as a restriction. I think the age of 20. I think if you're in an adult facility, unfortunately, those adult rules, at least that's my opinion, need to befall you, because those things can happen.
And you all addressed this issue of MDH and having mental health facilities to send the individuals to.
We address it constantly.
Okay.
Yes.
All right. I appreciate you, gentlemen. Thank you very much for sharing your perspective. Much of this, in my mind, is not necessarily geared toward the local facilities, but I don't want to let you guys out completely. Thank you.
Delegate Taylor with the last question.
Thank you, Mr. Chair. This bill has $5.3 million in costs for hiring 83 correctional officers to provide supervision in order to create the least restrictive environment for restrictive housing units and to provide supervision for members, et cetera, et cetera. It includes salaries, fringe benefits, one-time startup costs, and ongoing operating expenses. If we could pass this bill and give you the resources you need, would you be favorable to the tenets outlined in this bill?
No.
Yeah.
So it's not.
I just think that the whole 15 days, 20 days, not any more than 60 or whatever that is, it is every day. Every day I go to work, there's a unique individual that arrives, and we have to figure out how we're going to house them. I have 12 housing units. My jail is not elaborate. It's old. It's built in 1978. You fight like hell to get budgeting to add on to it. You get a transgender inmate that rolls up in there, you got to figure out what are you going to do, where they're going to go. I don't have a whole transgender wing. I don't have a whole wing for them. I don't have those things. I got people in wheelchairs. I got to figure out where I'm going to put them. So restricting how long somebody can be anywhere, it's constantly being managed. We try to do the best we can with what we've got. We give them access to the phone, we give them access to TVs, we give them access to books if they're behaving. If they're not behaving, then they're going on disciplinary segregation. Disciplinary segregation, they're not going to get any of those things. So it's a constant. I think everybody here, that's why we meet, have mental health meetings during the week, we have classification meetings during the week, and we have general meetings every day with medical and mental health as to what are we going to do with this person? How are we going to handle this person? How can we help this person? It's constant. So no, the very restrictive bill, it's not going to work.
Delegate Taylor, and I'll be very quick, I promise. I'll tell you exactly what I said during my Senate testimony. If you built a facility in each county that was tailored exactly to this, which, you know, those facilities would cost $350, $400 million. Yes, you build it in Charles County, I'll start doing all these things tomorrow, and I need the staff to do it. So this isn't like none of us have like this big problem with it. The problem that we do have is that we just can't physically do it.
You've answered the question.
Yeah,
Thank you.
thank you.
I hear you. Thank you.
All right, seeing no further questions for this panel, we thank you all very much. And that concludes the testimony on House Bill 647. Going now to House Bill 1157 and Delegate Phillips. It's Delegate Phillips by himself. Just one witness.
Thank you. Great.
Delegate Phillips and House Bill 1157, please.
Thank you, Mr. Chair, and thank you for allowing us to kind of change the order, because I'm solo, but I spent a lot of time, as I said, over the course of the interim, looking at all of these things. And I think we need to do something significant. And House Bill 1157 attempts to do that. Maryland correctional system has long been plagued with systemic issues. However, we cannot address all of these things effectively without having a clear, data-driven understanding of the root causes. We've got to understand where the system is failing, and we must do so through evidence-based analysis. And this is what we're trying to do with the House Bill 1157. At the core, House Bill 1157 is to require the Office of the Correctional Ombudsman to hire an independent consultant who will conduct a comprehensive assessment of Maryland's entire correctional system. This assessment will be thorough, evaluating the facility infrastructure, staffing levels, programming, and health services, all of which are critical to the rehabilitation success of the system. The goal of HB 1157 is not to implement immediate changes, but to ensure that we have the critical data and analysis needed to make informed, strategic reforms down the line. The assessment will include a cost-benefit analysis of current practices, as well as a comparative analysis with best practices from other states that have successfully addressed similar challenges. This information will provide us with the roadmap for improvement and offering actionable recommendations based on evidence and real-world experiences. The assessment will not only highlight weaknesses in the system, but also point out strengths that we can build upon. The findings will come with clear timelines for implementing changes, as well as a strategy for ongoing evaluation, ensuring that the reforms are measured and continue to evolve based on the results. By supporting House Bill 1157, you're not just supporting a bill that gathers data, you're supporting the future of Maryland's correctional system, a future where decisions are driven by facts, where reforms are based on the actual needs of incarcerated individuals and staff, and where we are creating a more humane, effective, and efficient system. With that, I'm just going to ask for support on moving House Bill 1157 forward.
Questions for the delegate? Seeing none, we thank you very much. And that concludes the testimony on House Bill 1157. All right, we're going to hear House Bill 55 next. All right. 23 witnesses. Megan McDermott, Colin Andrew Willett, Harold Coleman, Maria Spears. Delegate Ruff, when you're ready for 3 minutes, please.
Thank you, Mr. Chair. Good evening. Mr. Chair, Madam Vice Chair, and the hard-working members of the House Judiciary Committee. For the record, I'm Delegate Malcolm P. Ruff, Legislative District 41 in Baltimore City. I'm here to introduce House Bill 55, which adds Section 10-113 to the Criminal Procedure Article to grant the judges of our state in the district and circuit courts the discretion to determine whether or not to expunge any criminal conviction. First, I want to note that this bill has been identified by the Legislative Black Caucus as a priority on our legislative agenda. One unfavorable piece of testimony on this bill stated, and I quote, "Criminal records have nothing to do with racial equity." However, please read the racial impact note. It states, this bill's good cause expungement provisions will likely impact Black individuals to a greater extent as these individuals are overrepresented in charges, arrests, and incarceration for many crimes at a disproportionately high rate, making them also disproportionately affected by the collateral consequences of a criminal record. Second, I must note that it's clearly an auspicious sign that on House Bill 55, exactly 55 advocates have submitted testimony favorably, urging this committee to pass this bill, including the Center for Urban Families, Maryland Legal Aid, the Maryland Public Defender's Office, Out for Justice, the ACLU of Maryland, the University of Baltimore Law Center for Criminal Justice Reform, and the National Association for Public Defense. Criminal records cause and are the consequence of poverty and have terrible effects on employment prospects for an estimated 25% of working-age Marylanders that have a record. Demographically, 71% of Maryland's prison population is Black, the highest in the nation, and 1 out of 3 Marylanders returning from incarceration are returning to Baltimore City. Maryland has a variety of laws that prevent Marylanders from accessing expungement services needed to reintegrate into society. Nearly 93% of all charges are not expungible, and people are not able to get over the barriers to education, employment, housing, public assistance, occupational licensing, and many other things. This is a clear and logical solution to the expungement access problem. It allows our judges to use their sound discretion to grant a petition for expungement, and the good cause provision already exists, but it's rarely granted even in the context that it exists now, which is for non-convictions. There are specific factors, the nature of the crime, the person's character and history, the person's risk to public safety, any successful rehabilitation, the amount of time since the conviction, and the impact that we just talked about on all these barriers. So to wrap up, I will just say, if we can trust the courts to punish and convict individuals with sentences that will drastically alter their lives, potentially for decades, we should trust these same jurists when granting expungements. And for those reasons, we respectfully urge a favorable.
Thank you very much. Who'd like to go next?
I'll start here.
Hello, Honorable Chair and Vice Chair, members of the Judiciary Committee. I'm Lori Towns, James Towns. I am the Executive Director of the National Association for Public Defense. I'm also a lifelong Maryland resident. I've spent my entire professional career involved in criminal justice reform and public defense. I stand before you as the Director of NAPD, which connects, inspires, and empowers public defender professionals to fight for racial, economic, and social justice while championing the constitutional mandate of public defense. NAPD was formed in 2013, 50 years after the U.S. Supreme Court recognized the right to counsel as fundamental and necessary, and has a membership of over 25,000 practitioners from across the country who are guided by the 15 principles of public defense. Principle 14 states that public defense lawyers and public defense professionals are essential participants in achieving justice reforms, and we believe that reform must be an opportunity for reconciliation, redemption, and restitution, which is included in House Bill 55, Expungement for Good Cause, as it represents progress towards justice reform. Our voice here today is our belief in second chances and rehabilitation. House Bill 55 also addresses our 12th principle, which states that providers must address disparate treatment of racial and ethnic minorities. The Racial Equity Impact Note is clear. Black individuals make up the majority of Maryland's prison populations. I urge you to issue a favorable report for HB 55, for it represents a path towards ensuring fair and just legal systems for all, particularly for those willing to make amends and move forward constructively with their lives. Thank you.
Thank you, Honorable Chair, Vice Chair, and this Judiciary Committee. My name is Dr. Sabrina Njai, and I'm here before you today as a mental health therapist, as a published author, as an expert in treating trauma, and a leader in community healing modalities. I'm the founder of the Hartnett Center for Peace and Healing in Baltimore, and I have been privileged to work with people who have been impacted by the justice system, and also people who have been struggling with addiction for over 30 years. This legislation represents a significant stride toward justice and redemption, underpinned by my personal and professional belief in second chances and rehabilitation. Senate Bill HB 55 moves us closer to empowering returning citizens with the mechanism to petition for expungement of certain eligible offenses. And just allow me for a moment to expand on the impact that expungement could have. Returning citizens' criminal record is the biggest hurdle, and it's the biggest challenge that I see in my practice with people who are returning in securing gainful employment. Rehabilitated citizens gain access to housing to create and enhance stability and growth for their families and the return of their children. An expunged record widens the gates for those who seek self-improvement and economic mobility through higher education and training. When certain offenses are wiped clean from a person's record, it dismantles barriers to community engagement, supports family unity, and fosters societal inclusion. HB 55 embodies the values of forgiveness, growth, and equity. Members of the committee, I urge you to contemplate the long-term benefits that HB 55 will usher in, not only for individuals seeking redemption, but for society at large, which thrives when each of its members is accorded dignity and an opportunity. Thank you.
Good evening to the committee. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid, where I supervise our expungement practice. Expungement is a strict statutory process. I've been in court countless times when a judge has said to a client from the bench, "I wish I could expunge this case, but the law will not allow it." This usually occurs in one of two scenarios. The first is the unicorn. This is the client who's done everything right for the last 20 years. The unicorn screwed up when they were young, but since then, they've gotten a job, they've raised a family, they're volunteering, and they've generally been an active, contributory member of the community. And they've not reoffended. But they can't get their singular offense from decades ago expunged because it's not on the list in the expungement statute. The second situation is the client that has a case that is very similar to a charge on the list, but it's not exactly the same. the client who can't get their trespass on private property expunged because the statute only allows for expungement of trespassing on posted property, or the client who can't get their open container citation expunged because the eligible offense is drinking in public. Or there's the client who was charged with street walking in the late 1970s but couldn't get an expungement even though prostitution is eligible for expungement. The statutory framework of the current expungement law provides no guidance or flexibility in these matters, even though these are common sense situations where my clients really deserved a second chance. House Bill 55 provides that flexibility, that judicial discretion, while also creating specific guardrails to ensure that only the most deserving Marylanders receive a good cause dispensation. For these reasons, we urge a favorable report on House Bill 55. Thank you.
Good evening, Chairman, Vice Chair, and Committee. My name is Maria Spears. I'm a resident of District 40, and I strongly support good cause expungement. In my experience, I feel like there is no justice for victims. I became a victim at the age of 7 and grew up believing that the abuse was my fault. By the age of 13, I was homeless. I grew tired of being abused, so I started to fight back, and I was good at defending myself. However, the moment I started to protect myself, I was labeled as a criminal. Now I'm left with traumatic memories and all my scars, but my record haunts me the most. I'm a single mother of 5. I've been an alumni at Center for Urban Families since 2017. I'm also a member of Turnaround Tuesday, and I volunteer for Safe Streets of Baltimore. Strive being the most intense career development center in Baltimore City, and I still can't get a decent paying job. I've always been a caregiver, a natural healer. I've been rescuing animals since I was 9. Good cause expungement will give me opportunities to follow my dreams, allow me to make a change and advocate for my children and also children in my community. I urge for a favorable report. Thank you all for your time.
Questions, Delegate Kaufman?
Yes, Delegate Ruff, I have a question. My question for you is this. The state's attorneys, Maryland MSAA, really doesn't like your bill. In fact, they go as far as to say that it's radical. And they say that as a result of your bill, rapists and first-degree murderers would get out, and that it's an issue of public safety. So what I want to know is, in your view, is that hyperbole that you'd expect because it makes sense prosecutors wouldn't like that, or do they have a point about public safety issues?
You actually stole the word right out of my mouth. The word hyperbole is exactly what I think of that position. At the end of the day, we're talking about the people who've been either appointed by the governor or have been elected by the people of the state of Maryland, of that jurisdiction, who serve with dignity, and the people that we trust to dispense justice from the benches of our courthouses that are the gatekeepers of these expungements. That there is no way that a judge wants their name on an expungement of somebody who they think is going to reoffend, who they think is going to take that expungement and take it for granted, right? These are going to be expungements that are going to be doled out to the most deserving people, just like my colleague on my left here said. The people that are the unicorns, the people that have proven the point that despite their past indiscretions, they have overcome that, and they are deserving of an opportunity to be fully reinstated into our society with a clean slate.
Okay. Mr. Chair, just to make sure I understand his point. So I just want to make sure I'm understanding you. So what you're saying is, in essence, they needn't worry because you trust judges to exercise common sense. So did I understand your point correctly?
Yes, I mean, they go through a rigorous vetting process through the Judicial Nominating Commission. And these are not folks that are not experienced in criminal law and in determining how to weigh out a test such as the 6-factor test that is delineated in this bill. So we should trust those jurists who sentence who sentence people who have been convicted to determine whether or not they are deserving under good cause standard of an expungement.
Thank you, Mr. Chair. Thank you, Delegate Ruff.
Seeing no further questions, we thank this panel. We'll move on to the next one. Colin Andrew Willett, Harold Coleman. Bring up Christopher Sweeney on the, he's there, all right. Christopher Sweeney will be virtual, Zachary Alberts, Melissa Rothstein, Marcia Needus. All right, we'll start from my right and go across. So please, on this side, we'll go across 2 minutes each.
Thank you so much for being here today. My name is Marcia Nettis. I am the Vice President and Regional Director for America Works of Maryland Incorporated. We specialize in getting, in particular, people who are looking to get a second chance back to work. We work with a diverse group of individuals, anywhere from the town of populations to SNAP, but as it pertains to this bill, we are working with those who are trying to get a second chance at getting back into the workforce. We are in support of this bill, HB 55. And I had my own words I wanted to share today, but one of our customers that came down here from Baltimore City, he took off half a day just to come down and testify, but had to leave, unfortunately, because the hearing is going on a little bit longer than he expected. I promised him I would read his testimony. It was just that important that he took off half a day that it is being said. So I'm going to read this. I know time might run out, but I want to get through as much as possible. He said, "Good afternoon. My name is Robert Stokes, and I am here today on behalf of America Works and myself to speak in strong support of HB 55. After 38 years of incarceration, I know firsthand the challenges of reintegration. Finding employment has been one of the most difficult hurdles, as many employers are hesitant to hire individuals with criminal records. Housing presents another major barrier. Many landlords refuse to rent to former inmates, and public housing policies often exclude people with past convictions. Without stable employment and housing, the risk of recidivism increases, not because people want to return to crime, but because they feel they have no other options. Expungements place. There's another paragraph, but I'll just finish with the last paragraph out of respect for the committee. I am fortunate to receive support from America Works, which helped me find employment as a warehouse and secure stable housing, but many others do not have the same level of assistance. Expungement would provide thousands of Marylanders with a free shot at rebuilding their lives and contributing to the communities and staying on the right path. I urge you, as well as America Works, we urge you to pass House Bill 55. If you'd like
to just provide that in writing, to the committee, that would be fine. Sir, please.
Yes, good evening, members of the committee.
You need to put the microphone in front of you, I'm sorry. Go ahead.
Good evening, members of the committee, Vice Chair and Chairman. I'm in support of HB 55, and I believe that if this bill was implemented and put into law, it would really help people like myself in the situation I was in, and maybe the next person coming behind me won't have to do a lot of testimony, and it will give the judges some more options to be able to make judgment on allowing people to file expungements early. And I urge a favorable report on this.
Afternoon. Thank you for the opportunity to testify today. My name is Zach Alberts. I'm the Director of Advocacy at the Center for Urban Families, here to represent individuals most impacted by the limited scope of Maryland's expungement laws. As previous witnesses have testified, in Maryland today, there are over 1,000 different charges a person could be convicted of. About 120 of those are eligible for expungement. Just an example of one that isn't, selling a sparkler to someone under the age of 16. The limited scope leaves countless Marylanders permanently branded by their past mistakes with no pathway to a clear record. Every session, today included, that this committee hears testimony on bills that would add specific charges to the expungement statute, inevitably, there's an impacted individual asking you to add their particular charge to the statute. It's because our piecemeal approach to expungement fails to wholly address the fundamental purpose of our expungement laws. This can also be seen in the distinction between distribution and possession with intent to distribute, which reveals the sometimes arbitrary distinctions we make between charges that are expungible and those that are not. Many of these charges stem directly from the failed war on drugs, with hand-to-hand transactions resulting in different charges based on circumstance, not culpability. Finally, and again today, opponents of this legislation often bring up objections like, well, would you expunge someone with an attempted murder charge? Anyone who lives and works in communities most impacted by mass incarceration and centuries of structural racism, sexism, and classism knows a profound truth. Some of the best people you'll ever meet are individuals who did something really bad 45 years ago when they were young and dumb, but have since transformed themselves into pillars of the community. As Delegate Ruff said, we should trust the judges who levy the sentences with the power to recognize and reward individuals' rehabilitation and transformation. We urge a favorable report. Thank you.
Christopher Dews, Cornerstone Government Affairs, representing Out for Justice, strongly in support of House Bill 55. Just wanted to add some flesh, or specifically data, to some of the collateral consequences that come from a record. Should have said this earlier, but I want to make sure this gets across now. According to the Professional Background Screening Association, more than 90% of employers perform a background check on all job applicants and, of course, have the power to deny employment based on those records. Any past conviction reduces job offers by half. So that's the employment side. On the housing side, Urban Institute highlights that 90% of landlords perform background checks on every applicant who applies for housing and has the power to deny access, similarly on the basis of a record. Similar numbers exist for occupational licensing, for getting loans and financing. So for the vast majority of my clients, House Bill 55 is imperative simply because for us, more expungements means more jobs, more housing, more education, more civic engagement, and more empowerment. I just wanted to be specific to what Delegate Kaufman had mentioned, just so people understand what the bill does and what it does not do. The bill does not make, and this can be a little confusing, any felony conviction eligible for expungement. That's a big misconception. It does allow an individual to make a compelling case to the court as to why their specific charge should qualify for a good cause expungement. Then it leaves the decision to grant the petition for the expungement to the courts. It does not force the courts to grant an expungement based on one hearing. As with the current expungement process, the state's attorney's office and any victims from the conviction will receive a copy of the petition for the expungement and have the power to object, therefore causing a hearing, therefore causing a conversation that will allow a conversation as to whether or not this expungement is in the best interest of justice. Also note that the bill only allows a good cause petition once every 5 years per charge, and there is no opportunity for appeal. We added that in for balance, so to reduce conversations and basically the court burden. That being said, I'm happy to answer any questions and urge a favorable report. Thank you.
Good evening, Melissa Rothstein from the Office of the Public Defender. The Public Defender's Office is proud to be among the 55 supporters of HB 55. And most of the things that I would have discussed in terms of the importance of expungement and the unicorns and other examples that have been discussed have already been discussed, and I'm not going to rehash those. I think the only thing that I will add, again, going to some of Delegate Kaufman's questions regarding the good cause process, I really just want to highlight that good cause isn't something that happens automatically, and it's not something that happens easily. When I've tried to apply for good cause for people who I've represented where it is eligible, if you don't have sufficient documentation, if you don't have something to show how it's going to actually harm them to not have it happen in the near future, it is not granted. And there are objections that are made by state's attorneys and that do preclude good cause from happening. So this isn't going to result in a wide range of going around the expungement statute, and it is an important measure that we support. Thank you.
All right, we had one person who was virtual. as part of this panel. Mr. Sweeney?
Good evening. Thank you again for the opportunity to be here. I'm Chris Sweeney. I'm staff attorney with Maryland Volunteer Lawyers Service. I help job trainees with removing legal barriers to employment. And here in support of this bill, I believe to the members of the committee, as lawmakers, you know better than anyone how complicated legislative drafting can be. And our expungement statutes are carefully designed, but they simply cannot capture every possible scenario. Things like the recodification of criminal statutes, variations in charging language, other changes to criminal practice, or just the specific circumstances of cases create confusion for many expungement petitioners and their attorneys as well. Certain cases appear right in line with the spirit of the expungement statute, but they don't meet the letter of the law. And I've heard countless judges lament this very fact in open court, that the petitioner seems deserving of expungement, but the statute simply doesn't contemplate their particular situation. A good cause expungement provision would allow courts to hear a petitioner's case. In such an event, the petitioner would have to demonstrate rehabilitation and, of course, convince the judge to grant the expungement. Right now, the existing law, it doesn't allow anyone to even get their foot in the door if they don't meet the exact letter of the statute under their specific case. So this bill is not about opening up the floodgates of expungement. It's carefully designed to simply provide a process for those seeking a second chance who's have the circumstances of their case fall outside the exact statutory guidelines. And so I thank you for the opportunity to testify virtually today, and I urge a favorable report respectfully. Thank you.
Thank you, Mr. Chair. Can you remind me and the rest of my colleagues, when is a person eligible for expungement? I'd look at the OPD or Mr. Dews.
Well, for eligible convictions, it varies based on what the conviction was for.
But at a minimum, what must happen in terms of completing their sentence?
I got this one. I'm sorry. You guys are great. Yes, no. So first of all, the individual has to fully complete the entire sentence. That includes the time allotted, at least as listed in the bill, with probation, parole, as well as their entire sentence. Then outside of that, normally they would have to wait a 5, well, depends on if it's a non-conviction, but if it's on 10-110, 5, 10 to 15 years in regards to a waiting period. I got you covered, buddy. We're good. Yeah, so it's we're talking about around for most people about a decade has changed from the time the person has been convicted minimally. A decade has gone past from the time a person has been convicted to when they would be at the earliest eligible for an expungement, usually.
And does this change that process?
This does not change that process. A good cause expungement is an entirely separate section that would allow an individual to a petition for a good cause, but this does not change that statute whatsoever.
Okay, thank you.
Thank you.
Seeing no further questions for this panel, thank you very much. We're going to move on to the next panel. Candace Baker, Kelly Meyer, Stephen McDonald is virtual. Monica McCants, William Freeman, Heather Warnken.
So Candace Baker and Monica McCants are not, yeah.
Okay, Melody Mitchell, Martin Mitchell. All right.
He's a me too.
That's fine. Go ahead.
Good evening, Chairman Clippinger and members of the committee. My name is Kelly Meyer. I'm a program manager at America Works of Maryland, overseeing several of our programs, including our reentry program. I am here today to express my strong support for HB 55. At America Works, we help individuals find sustainable employment, but too often our customers are denied job offers due to charges on their background that under current law cannot be expunged. I'm on the front lines seeing the challenges that our customers face. These individuals have worked hard to turn their lives around, yet outdated barriers prevent them from securing stable employment and fully integrating into society. HB 55 would provide a much-needed opportunity for those who meet the criteria to have their records cleared, removing a major obstacle to employment. By passing this bill, we are not only giving individuals a fair second chance, but we are also strengthening our workforce and communities. I urge you to support HB 55 to help give Marylanders the opportunity to build a better future. Thank you for your time.
Okay, thank you. We'll hear now from Stephen McDonald. Mr. McDonald?
Yes,
there he
I'm
is.
here.
Go ahead.
All right. My name's Stephen McDonald. I'm from District 28, Charles County. I'm favorable for the bill because many people like myself are not eligible for expungements. The expungement article needs to cover more misdemeanor crimes. It's unfair we have violent felony convictions, first-degree burglary, distribution, assault, and theft eligible while I have the lowest seriousness level misdemeanor. I can't get an expungement. That legislation already intends to cover my charge under Section 5601, alternate prescription. But it falls under 5701D, counterfeiting prescriptions. There are tens of thousands of Marylanders who have low-level crimes that cannot get an expungement ever, affecting my job where I can't get advancements in my career and housing. It's keeping me stuck in poverty. It's affected my family and my kids. I did 8 years of plumbing school, and I've been offered many advancements in my career, and I've been denied because of background checks based on me getting on bases in government facilities where most union jobs are. There needs to be more focus on the expansions of low-level misdemeanor crimes. I asked for an amendment in House Bill 499 and a favorable report for House Bill 55 that will cover my charge under 5701D, counterfeiting prescriptions and altering prescriptions. I urge a favorable report. Thank you.
Any questions for this panel? Seeing none, thank you very much. That concludes those people testifying in favor. We'll go to those in opposition. Mr. Cox.
Chair, oh, there we go. Thank you. Thank you. I'm John Cox, Deputy State's Attorney for Baltimore County, and also speaking on behalf of the Maryland State's Attorneys Association, and in opposition to and ask for an unfavorable report with regard to House Bill 55. I'm the one who wrote the written position of the State's Attorneys Association. Don't remember saying rabid. I did say disaster. And I have the State's Attorneys Association has great concern for this. As I said in the written, we set up a structure for expungement process, a well thought out process through the Justice Reinvestment Act, and with a large number of eligible offenses for expungement, and a process by which this happens, which gives rights to both the state and the victims in the circumstances where it's appropriate. Just to address some of the things that have been said already, and I've dealt with Mr. Dews for a long time, and I have the utmost respect for him, but he said that this does not make any felony eligible for expungement. The statute, the bill reads, a person may file a petition for expungement of any misdemeanor or felony conviction after the completion of the sentence. It does make any offense eligible. Murder, rape, distribution of child pornography, everything would be eligible under this. He also said it gives the State's Attorney's Office and victims rights. It does not. There's nothing in this bill at all. This is a separate statute from the expungement statute that exists already. There we have the ability to oppose and be involved in that process. Delegate Phillips, you asked the question, does this change that process? It absolutely completely changes it. This creates a wholly separate, everything can be expunged for just a generic phrase, good cause, where there's no other entitlements to the state or to the victims. This is just, and there's no reason to use 105 or 110 anymore, because this just has the generic phrase, good cause, anything can be expunged.
Great. Thank you very much. Are there questions for Mr. Cox? All right, seeing none, thank you very much. Mr. Mitchell, Martin Mitchell, has joined us, and as long as he is not operating a motor vehicle, especially one with a apparently cute child in the background. We will be happy to hear from him for 2 minutes.
Yes, Chair, as I will state at the beginning, I am parked. I am not moving. My name is Martin Mitchell. I'm a community organizer with Life After Release, and I'm here today in strong support of this expungement bill because I believe in second chances and the power of redemption. Life After Release is a community-based reentry organization that helps our brothers and sisters returning home, and some while still in a carceral state. Life After Release is an organization that helps with court support, mutual aid, and overall providing a community of support and resources for our clients. Over the past 3 years, I've hosted about a dozen free expungement and record clearing clinics to help individuals clear their criminal and/or traffic record. I have firsthand seen individuals go from retail jobs to the medical field because of that expungement. For too long, past convictions, no matter how old, have haunted individuals long after they have served their time, completed parole, and fulfilled every court-mandated requirement. Even when people work hard to rebuild their lives, a criminal record blocks them from jobs, housing, and opportunities that could help them fully integrate into society. This bill ensures that those who have paid their debt can petition to clear their records and move forward. It also allows the courts to grant expungement at any time when there is good cause, because justice should not be one-size-fits-all process. These provisions provide individuals with an opportunity to seek relief from the collateral consequences of criminal records by demonstrating to the court that expungement is warranted based on their specific situation. I have seen firsthand how expungement can keep people trapped in cycles of poverty and instability. This is not just a matter of fairness, it's a matter of economic and social justice issue. I urge you pass this bill and give the opportunity to truly move forward beyond their past. Thank you.
Questions for Mr. Mitchell? Seeing none, thank you very much. That concludes the testimony on House Bill 55. Thank you very much to everyone who's testified. We'll now go to Delegate Long, and we'll hear his legislation. This is 1154. Delegate Long is going to present, and then we have 2 people in opposition. Delegate Long, please, for 3 minutes.
Thank you, Chair. Thank you, Vice Chair, and members of this committee. For the record, I'm Delegate Bob Long. I'm here on HB 1154. You heard this bill last year. It has to do with home detention. And this bill would require the commissioner or correction of the commissioner designate to remove any incarcerated individual from the home detention program for violation of a condition of the incarcerated individual placed in the program. Last year, I brought this bill, and I described a case which meant to be, a man was meant to be on home detention, and he actually shot and killed 2 people in Brooklyn right after that. Now something similar has happened again. This month, actually, 2 teenagers were shot, and one died immediately, and then one other one just passed at a shooting at the mall. I'm trying to think of the name of the mall, but anyway. Yeah, anyway. Let me get back to what I was saying. We had talked about this last time, and we're just trying to figure out why that these companies that are monitoring these ankle bracelets, why they're not calling, the commissioner, calling, parole and probation immediately. If this would have happened, we could have probably saved these 2 young men. This gentleman that killed these 2 young people actually had been in trouble several times. And, this is a privilege. If you're on home detention, that's a privilege to be out on home detention. And these people are violating, what they agreed to stay in, within range, and the GPSs are very accurate. And I think it's very timely that this bill needs to be passed. Given the crime and the way things are happening right now, we need to do something. And I think if you're out on home detention and you make an agreement, you're going to stay at either your home or your job or whatever, you're going to abide by that. If not, why are we even putting them on home detention or monitoring? Why are we wasting their money? And with that, I would just like to ask for a favorable vote. And again, you know, we need to do something because things are just getting out of hand. I mean, every time you turn on the news, you see something happening, somebody's on home detention out committing another crime, and nothing's happening. That's unconscionable. Thank you.
Thank you. Questions for the delegate? Seeing none, thank you very much, Delegate Long. In opposition, Ms. Rothstein, Ms. Taylor. The guy dream of me too. We'll see. Melissa Rothstein, please.
Thank you, and good evening. Melissa Rothstein from the Office of the Public Defender. I asked the committee to issue an unfavorable report on House Bill 1154. Correctional Services Law 3413 already allows for a commissioner to remove someone from home detention for any reason, including if they violate any term of their home detention. HB 1154 seeks to remove that discretion and require that the person be returned to jail. It does not account for the seriousness of the violation, any underlying circumstances, or whether a less restrictive alternative is appropriate. Individuals who commit new crimes or otherwise jeopardize public safety are returned to prison. This bill will target technical violations among people with nonviolent convictions with the most restrictive and costly approach. Everyone on home detention has a sentence that will end and has already served at least the minimum term of their sentence. Home detention serves a valuable role in transitioning the person from incarceration to the community, providing for the opportunity to work, assist with childcare or other responsibilities, and reacclimate to the structure of a non-institutionalized lifestyle. Requiring that every minor violation result in a return to incarceration, even when the Commission does not think that is necessary, will ultimately harm public safety and thwart efforts to both reduce costly incarceration and promote successful reentry. As a result, I urge the committee to issue an unfavorable report. Thank you.
And committee, me too.
Questions for the panel? Seeing none, thank you very much. That concludes the testimony on House Bill 1154. We'll go to Delegate Otto, who is here by himself, and he's able to do this completely by himself. It's amazing. House Bill 1247. Go ahead and tell us what the bill does.
Thank you, Mr. Chair, and it's a privilege to be here before this fine committee and the good work that you try to do. But I am Delegate Charles Otto, District 38A in Somerset, representing Somerset County, but this bill is a statewide bill, and it's pretty simple of victim protection. We had it struck close to home with me, an individual that the family didn't know the victim was had passed away in release of one, and I knew both the victim and the perpetrator. So it's been put forth that more due diligence needs to be done to notify the victims or their survivors of changes in the sentence and or release. So HB 1247 alters the existing requirements and basically adds an additional notice of registered mail, a second notice. And I hope that the department would do a good job of fixing and notifying people to be involved in the process. So I ask for a favorable report.
Questions? Seeing none, that concludes the testimony for House Bill 1247. Thank you very much.
Thank you, good luck, and we'll take you to dinner sometime.
All right.
Come to the clam bake Christmas.
Delegate Riley out there?
I think you just glad you're not on this committee.
Is Delegate Riley out there? Delegate Grammer? All right, we're going to do we're going to go do these two bills from Delegate Grammer, and then we'll switch back to Delegate Riley if they arrive. This is 777.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Cranber to present House Bill 777.
Ms. Rothstein should be up there too. Sorry.
I'll keep rolling. House
Okay.
Bill 777 establishes that a person who has been granted an expungement shall be determined for all purposes not to have been arrested for, cited for, charged with, or convicted of the underlying offense. I'm joined by Roland Harris, who serves in assisting Marylanders to achieve expungements for folks whose records stand in the way of their employment or social participation. Maryland does not have a federally recognized expungement statute, and the federal government does not recognize expungement in our states to be real expungements. House Bill 777 attempts to remedy this problem by establishing that a person who has been granted an expungement shall be determined for purposes not to have been arrested for, cited for, charged with, or convicted of the underlying offense. I would yield to Mr. Harris to expand on why this bill is necessary. Thanks for the opportunity to present and ask for a favorable on 777.
And good evening. My name is Roland Harris. I'm an attorney. I've been a defense attorney in the state of Maryland for going on 20 years at this point in time. And I will say, I just wanted to say thank you to everybody that's expanded expungements. They help people tremendously. And what this bill does is, all it does is it solidifies. It just says what it is that expungements already do in the state of Maryland. I want to give you an example. When we're talking about the guidelines in the state of Maryland, you can go to section 7.1. And in there it says, if we're doing the sentencing guidelines, we do not consider an expunged conviction in calculating the guidelines. We don't use it for sentencing enhancement purposes. So all we're doing is we're taking what it is that we know about expungements and we're just putting it into words and making it the law. And what, Delegate Grammer is talking about, where it's removing the effect of the conviction. So if you look at our juror statute, it says if you've been convicted and you received a sentence in excess of a year, if you receive a governor's pardon, you're able to serve on a jury. Technically, in that statute, it doesn't say anything about an expungement. And so what we're talking about is not the history. What we're talking about is the status. Is it a conviction or not? So when you look at the sheriff's bill, or the sheriff's opposition, or you look at the prosecutor's opposition, what they're talking about is erasing the history. Nobody's asking to erase the history. The history is still accessible under 10108. A prosecutor can't stand up in court and say, he's been convicted before, he has an expunged record. They're not allowed to do that. 10108 says, no, you can't do that. They have to get a 10108 order, and then they can use that record. So what it is that the prosecutors are concerned about, it's not a concern. And what it is that the sheriffs are concerned about, not a concern, because those records are still available.
Thank you. Melissa Rothstein from the Office of the Public Defender. I'll just quickly sort of reiterate that House Bill 777 codifies the true intent of expungement law to remove the case from a person's criminal history. While much of the focus of expungements is on document destruction, which has been discussed, that's meaningless if the person is required to verbally disclose the event. Purging the record should also prevent it from being disclosed in other forms, and we hope that you do issue a favorable report. Thank you.
Thank you. Delegate Valentine and then Delegate Cardin.
Thank you, Delegate, for bringing the bill, and thank you, panel. The only question I have, I'm kind of trying to understand the bill. Delegate, could you explain to me exactly why this is necessary?
Yeah, so a few years ago, if you remember, the federal government issued an opinion and it said, what you're doing in Maryland is not an actual expungement. This is a simple bill, it's a one-sentence bill, and it essentially says, when someone has an expungement, it will mean, it will be essentially as if that person never committed the crime. And this has a lot of ramifications for, participation with state government and anything related to that. And I actually like to defer, if I can, so Mr. Harris could articulate about it.
Absolutely.
And that is correct. When we're talking about things like jury service, if we were to read the statute, as it reads, it does not allow for jury service. But that's interesting because I've picked juries before with judges, where the judge is giving the advice to the person, you can get an expungement, and that would restore your right to serve on a jury. But that's technically not the law of the state of Maryland. So by doing this, rather than, there was a conversation earlier with a different bill, how everything's happening piecemeal. And I will say, I love the expungement advancements that Maryland has done, but it's very much a Frankenstein. It's very much done in piece by piece by piece over the span of years and years and years with lots of different people's input along the way. What this does is it clears the field. We just say what we mean and mean what we say. And then everybody's on the same page. So when somebody calls me on the phone and says, I got a question, do I have a conviction? And I have to go, well, what happens is your record's actually been removed from public viewing under 10101, such and such, and all this other stuff. I don't know whether they have a conviction or not, right? The statute is not clear on that, and that's because over the 20 years, we've kind of danced around the issue. This would solve that once and for all.
Ms. Rothstein, you want to comment?
Yeah, I'll just add to that in terms of the confusion. Sometimes it comes up where people have to answer the question of, have you ever been arrested? Have you ever had a conviction? And what they are supposed to say if they have it expunged can be complicated, and this sort of makes it explicit. I think it's similar to Delegate Moon's bill in that sense, in terms of places where somebody is sort of forced between, do I say that, do I respond in the way that's consistent with expungement with the risk that I'm going to be considered dishonest? Or do I disclose something that I shouldn't have to disclose because it's been expunged? So this is just a way to make that more explicit.
So if you have issues with housing or education or certain permitting, those are some circumstances.
I was thinking along the lines of a job application. Have you ever been charged with or convicted of a crime?
Exactly.
Similar? Okay. Thank you, Madam Chair.
Oh, sure. Delegate Cardin?
Thank you, Madam Chair. Thank you very much for the bill. I think I like it because I think it makes sense that that's the purpose of expungement. The state's attorney gives an example, which I don't understand. Maybe you can explain it, but they'll probably come up, Mr. Cox will probably come up and explain it. But there are circumstances where it's appropriate to, for example, an individual has been charged with a crime and then it resulted in a conviction which was expunged, and then someone else was charged with the same crime. The prosecutor would be ethically obligated to disclose the information to the next charged person as potentially exculpatory evidence. I have no idea what that means. Can you explain that?
I understand that, having been in court with a lot of prosecutors. So person A gets charged with the crime. Ultimately, that charge is dismissed for one reason or another. Or even they have some low-level conviction of some sort. They get it expunged. Ultimately, it's expunged. Person B then gets charged with the crime. Person B may want to say person A is the perpetrator of the crime. These were the circumstances of said crime. And so what they would do is exactly what it is that the state's attorney references in their letter, is that they would file a 10108 motion with the court and say, we have good cause. You need to give us those records so that we can give them to this defense attorney so they can set up their defense. And the judge would make a decision as to whether good cause was found to unseal the records and pass them on to the defense attorney in that situation. So that is already covered by the 10108 rule. And then the second part here, there's a kind of an add-on paragraph that they stuck in there. And what they say is that they would be required to say that they don't have a conviction. That's not true. They're not allowed to say anything. 10108 says you can't disclose anything about an expunged conviction anyway. So if they wanted to say anything, they'd file the 10108 motion. With that, they would be given good cause to be able to go and say whatever it is that the judge granted them in that particular order, and then they could say whatever they wanted to say about the expunged conviction at that point in time. So neither one of those are a concern.
And this is important because if you read the definition of expungement, it has to do with the record and the unavailability or the availability of the record. This is a one-sentence bill. It says, for all intents and purposes, an expungement means the crime is gone. And isn't that the intention of an expungement?
I got it. Thank you.
Thank you.
Okay, Delegate Taylor?
Thank you, Madam Chair. This bill will not conflict at all with good cause expungement, right? It's more in tandem with, right?
This is more to kind of express the intent of expungements as they stand. Am I?
Yes,
okay.
Because I'm sorry, when you're saying the other form is when a conviction's a certain age, that was Mr. Ruff's bill or Delegate Ruff's bill. Yeah, no, this would actually do more with the status. Is there a conviction?
Okay.
And that's what it's
So it doesn't conflict.
Yeah,
It's both can be passed, right? Okay. And I have a question, and this is probably for the attorney, and this is just to satisfy my curiosity. Unless we pass a ban the box type legislation, and I think somebody just mentioned it, if I have a prior, I'm fully expunged, but I have an arrest record, but that box is there, and I'm applying for an apartment, and it says, have you been convicted? Do I still have to click that
My answer to a client is you don't have to, but I'm pulling that out of experience. And my interactions with prosecutors, judges, other attorneys, and everything like that. I can't pull that out of the statute. Like, I couldn't point them directly to a specific piece of law and say, this is my advice, I'm just reading you the law. I couldn't do that.
And if you sense some vagary, it's because there is some vagary, and there's a lot of repercussions for that.
Yeah, thank you.
Did you want to?
Yeah, I mean, I would just say with that, realistically, when I sort of advise clients on it, it's not going to come up in a background check. So, it has been expunged. You shouldn't have to say that it happened. It won't come up in a background check. However, if there was ever a newspaper article about it and somebody does a Google search on you, they're going to see that, and then they're going to think you're being dishonest. Right. And so what happens with that? And that's something that could still happen with this regardless, but they would have the benefit of a statute behind them in terms of what their decision was and how they responded.
Thank you.
Thank you. Delegate Phillips.
Thank you, Madam Chair. I want to go back to one of the big issues, I think. If you are applying for a background check, Secret Service, something of that nature, right? How do they view that? Do you know?
I would not be able to say how like the Secret Service or anything, because they get to the point where they're doing lie detector tests. But part of that process, my understanding is, one of the things the prosecutors talk about is that they would have to send somebody out to interview your neighbors. They already do that. Right? They already do all those extra background kind of a thing. And just answering in accordance with state law. Now, if you're applying for a federal job, maybe the federal government has different laws, so there's too much of the unknown to say.
Well, my point was, and I think Delegate Grammer, we went through this last year, there was a question, if under the Fed's definition, an expungement is not an expungement as they define it, and we don't do this, then we continue with this conflict between how we view it in the state and how the Feds view it. Is that correct?
That is correct.
Okay.
I would say to some extent we already have those conflicts. Immigration is the most sort of striking example of where we have it. So state law isn't going to correct inconsistencies with federal law, but it doesn't mean we can't make good law for this state.
Okay, seeing no further questions.
Thank you.
That concludes the favorable panel. Now we have one person testifying unfavorable, and that's John Cox. Come on down.
I want everybody to remember I was favorable on the first expungement bill. I'm John Cox, Deputy State's Attorney for Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association. There's been reference made to the written, so I won't repeat that. This could not be more clear. It says a person who is granted expungement under this subtitle shall be determined for all purposes not to have been arrested for, cited for, charged with, or convicted of the underlying offense. It's basically asking if there's a situation where this has to be known or dealt with, we have to lie and say, no, this person was never arrested, because for all purposes, they're deemed not to have been arrested. Counsel actually explained for you, Delegate Cardin, my hypothetical that I had in there, and it's exactly the truth. If for some reason one person's charged with an offense, let's say they were convicted, and then somebody later charges another person with that same offense and only one person did it. This basically says we can't tell the defense attorney in the second one about the first conviction because they're deemed to have not even been arrested for it. Nothing comes out during the course of that. The opposite would be true. If somebody was charged and acquitted and then they get that expunged and we're now determining that were never even arrested, and we've got another person charged, we have an ethical obligation to disclose that to the defense attorney. And this is saying for all purposes, they're not deemed to have been arrested or anything along those lines. This is not expungement, and I guess maybe it's a vision out there about what expungement is, but expungement is removing from the public view. And if we're deeming, and there are circumstances, or the council was indicating situations where we can ask to be allowed to then disclose something of some nature, this would eliminate that possibility and very greatly harm law enforcement and our ability to do our jobs.
Delegate Cardin?
Thank you. Thank you. So first of all, I think expunge means to completely remove. It doesn't mean to remove from public view. I think that's the definition of expungement.
Completely removed from what?
I mean, and that's really, I think, the essence of the question here that we're talking about. So it's not from public view, it would be to completely just remove it. So the question, so the answer that was brought up by the gentleman who testified in favor of the bill said that you can file a motion to the judge to release that information. You don't believe that you're allowed to because of the way that it's?
Not with this bill. It says for all purposes.
Okay.
Deemed not to have been arrested.
Okay. So, and you don't believe that you have an obligation to just dismiss the charges against somebody if you have exculpatory evidence showing that they didn't do it, that somebody else was charged, but you know because of the records that the other person was already convicted of it? You don't have an obligation. You would rather, you think you're obligated to tell the defense attorney as opposed to say, wait a minute, somebody else has already been convicted of this.
Oh, I guess maybe I didn't parse the right word here. It's potentially exculpatory.
Okay.
And so, I mean, obviously, I'm not going to be prosecuting somebody that I know didn't commit an offense. And so if I have an individual that we feel should be prosecuted, the fact that somebody else had been charged with that same offense before, I guess in that scenario, I've decided they didn't do it. But I still have to tell the defense attorney that happened.
Okay.
So they can pursue their defense.
Thank you. Got it. Great.
Delegate Embry?
Thank you. Thank you for being here, Mr. Cox. I'm very sympathetic to the purpose of this bill and the intent. I wonder if there's an amendment that you could come up with that would protect your ability to seek court permission to share information under circumstances you've described, but that would also accomplish the purpose of the bill.
I don't know what it could be, honestly. The irony is, I think this affects your data collection bill, if we remove any indication of an arrest.
No, I don't think so, because it's still, it would still be available, the expunged records. But anyway, I would actually just encourage you to think about it.
Okay.
Thank you. That concludes the testimony and hearing for House Bill 777. Our next bill with Delegate Grammer is House Bill 318. And
Ready when you are.
I'm almost ready. Hold on one second. So this was introduced in 2024?
Yep.
So this, I don't know if it's a reintro. I think it is.
It is.
But anyway, okay, so it's just you and Wesley McNeil. Oh, there you are.
Got him.
Okay. Moving along.
Thank you, Madam Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 318. House Bill 318 adds failure to obey a court order to report to confinement to the list of crimes available for expungement. I'm joined today by Mr. Wes McNeil, who's a resident of my district. Mr. McNeil went to purchase a firearm and had several charges expunged from his record in order to do so. One charge could not be removed: failure to obey a court order to report to confinement, as it is not on the list of charges available for expungement via state law. In his youth, Mr. McNeil reported a few minutes late to a court date. Although he was only 5 minutes late, this still resulted in a criminal charge which continues to be on his record. I know Mr. McNeil personally as a man of trustworthiness and character, and I consider him to be a person for which the expungement process was designed for. For that reason, I believe we should add this charge to the list of crimes available for expungement. And for the committee's consideration, as has been mentioned several times today, there are a list of crimes that can be expunged, and there are many that have not. And it seems to be a great focus this year to revise the list so that when we have folks who we have records standing in the way of their social participation, that we bring those folks in, consider their circumstances, and revise the list. So this is a bit of an odd charge, not one that's in front of us every day, but I think we should add it to the list so that folks can participate in life as they see fit. With that, I'd be happy to take questions and ask for a favorable on House Bill 318.
Good evening, Madam Chairman, committees of the board. We introduced this, again, like I said, last year. A little bit about myself. I'm 47 years old. Work at the Port of Baltimore for the last 25 years. When I was about 18 years old, I had a little bit of mishap with some friends and all, got in a little bit of trouble, got myself together, ain't been in trouble since. Went to get my life back together, got 4 kids, been married 18 years. Went to get everything expunged, got everything expunged except one charge. And that was the second-degree escape where I failed to report 5 minutes late. And they slapped me with that charge. In the meantime, I went and got my HQLs, my firearm license, wear and carry permit and all. Was granted it, did everything like I was supposed to do. Went to purchase a firearm, bought it. Went to purchase another one, bought it. Went to purchase another one, came back denied. And I went to find out why, and they said the state had overlooked one charge. And that was the second-degree escape charge, which I'm hoping that we can get this in the package for expungements as of today in favorable 318.
Thank you, Mr. McNeil. Are there any questions? Seeing none, that concludes the hearing on House Bill 318.
Thank you, sir.
All right, Delegate Riley, we're going to call you up, bring you up for 2 bills. First bill, House Bill 356, and Joseph Thompson, Dennis McCulley. All right. And Delegate, whenever you're ready, you'll have 3 minutes. Everyone else will have 2.
Okay, I think we're ready. Good evening, Chair Bartlett and members of the Judiciary Committee. For the record, I am Delegate Teresa Riley, District 35A, here to introduce HB 1356, Criminal Procedures Pretrial Release Bail. This bill prohibits a district court commissioner from authorizing the pretrial release of a defendant on personal recognizance or unsecured bail if the defendant committed a crime within the previous 5 years or failed to appear in court. However, under these circumstances, the judge may authorize a pretrial release of the defendant on a secured bond and any other condition that will reasonably ensure that the defendant will not flee or pose a danger to any other person or the community. I respectfully ask for a favorable report, answer questions at any time, and I will forward to my panel. Thank you.
Good evening, Madam Chair, members of the committee. Thank you for the opportunity to address you tonight, on an issue that strikes at the heart of justice, the rights of crime victims, and the devastating impact defendants fail to appear in court. Our justice system is built on the principle that both the accused and the victims have rights. While we often discuss due process for the defendants, we must also recognize that victims have an equally important right to seek justice, to be heard, and to find closure. However, when the defendant fails to appear in court, that right is delayed, undermined, even denied. When a defendant does not appear in court, the case is postponed, forcing victims to wait even longer for resolution. Many victims have already endured painful delays due to investigations, legal proceedings, and evidentiary process. A failure to report adds to that suffering, prolonging their trauma and uncertainty. Victims are often required to prepare themselves emotionally for hearings and trials, reliving painful events as they testify. When the defendant fails to show up, victims must endure additional stress, anxiety, and disappointment, knowing they will have to go through this process again. When a defendant absconds, victims may feel abandoned by the justice system. They may lose faith in the court that can protect them and hold offenders accountable. This lack of trust can discourage victims from cooperating in future cases, making it harder for law enforcement and prosecutors to bring criminals to justice. Maryland's made great progress in strengthening victims' rights. We must do more. We need policies that prioritize prompt apprehension of defendants who fail to appear. With the staffing of the police department at an all-time low, law enforcement does not have the resources or manpower to locate and arrest absconding defendants swiftly. The victims of crime have already suffered once. They should not have to suffer again because a defendant refuses to face justice. By strengthening our response to failure to appear, we are not just improving our courts, we're standing with victims, restoring faith in our justice system, and ensuring that justice delayed is not justice denied. Thank you very much.
Thank you.
I'm Joseph Thompson. Honorable delegates, thank you for hearing me today. Thank you for the opportunity to speak today about an urgent issue in our justice system, the predatory nature of unsecured bails and its impact on defendants, particularly those in marginalized communities. At first glance, unsecured bail may seem fair, alternative to cash bail. After all, it allows defendants to be released without paying anything up front. But the reality is unsecured bail functions as a trap, disproportionately harming low-income individuals and perpetuates the cycle of poverty and incarceration. Here's how. Unlike secured bail, which requires payment before release, unsecured bail imposes a debt-based punishment on defendants if a defendant fails to appear in court, even for a reason beyond their control, such as lack of transportation, illness, or work obligation. There are immediate saddled with crippling financial penalties. This can mean thousands of dollars in fines and even civil judgments that damages credit scores and prevents individuals from securing housing and employment. The reality of unsecured bail functions more like a predatory loan than a fair justice measure. It is unfairly punishing poverty and forces individuals to navigate the legal system to penalize them for circumstances beyond their control. This is not justice, it's exploitation. Maryland must take bold steps to reform the bail system and should not be for sale. Let's put an end to the predatory and use of unsecured bail and create a system that is truly fair for Marylanders. Thank you.
Thank you. Does anyone have any questions? Delegate Conaway?
Thank you, Chair. Thank you, panel, for coming in to testify. To the witness that testified about the unsecured bail.
Yes.
You feel that unsecured bail is better than having to post a bond?
So unsecured bail, the way it impacts people is when you fail to appear, the court gets a default affidavit judgment against the defendant.
Yes.
There is no explanation to a judge on why you failed to appear. The judgment is entered, it goes on their credit. It's there until it's paid. So when we have individuals, let's say with drug problems, that miss court and have $5,000 unsecured bails, that judgment is going to be on their credit. It's going to affect their housing. It's going to affect their ability to get services from the state because there's a.
Okay, so what about when you have secured bail, you put up your portion of the bail, and you don't show up for court? What happens then?
So in the case of them putting up, you're saying putting up like the money to the court, or are you talking about?
When you put up the money to the bail bondsman.
So you put money to the bail bondsman, they pay the 10% fee. Mm-hmm. If the person appears in court, everything's fine. If they fail to appear in court, the bondsman is the one that has to cut the check for the forfeiture.
Yeah,
our surety companies and that.
Yeah, but at the same token, don't you become kind of property of the bail bondsman? They have bounty hunters that can come get you?
So,
absolutely, sir.
Yes, I know. So he was explaining why you putting up your word to say that you'll come to court is worse than having a secured bail, and I disagree with that. So
you're not at, when you use a bail bondsman, we're the one on the hook. The bail company is the one on the hook.
I understand that.
There is no credit. If you fail to appear, I go get you.
Yeah, I understand that.
Yeah.
So if you
so it won't be on your credit report. It won't be on anything like that.
Great. So if you come and get me, do I get my 10% back?
Absolutely not.
If you don't come and get me and I show up in court, do I get my 10% back?
Absolutely not.
Thank you.
Thank you. Okay, that concludes the favorable testimony for this panel. We're going to move on to unfavorable. One person, Melissa Rothstein.
Good evening. Still Melissa Rothstein from the Office of the Public Defender. I asked this committee to issue an unfavorable report on House Bill 1356. The bill language actually gives no regard to whether the person complied with their prior bond, whether they were ever convicted, or the seriousness of the current charge. It ignores all standards for release consideration and the concerns with money bail that were detailed in my written testimony and resulted in a court rule change in 2017 are completely ignored. By requiring that anyone who had previously received an unsecured bond be precluded from release on recognizance or an unsecured bond, the bill reduces an already limited toolbox for pretrial options, ignores the data, research, and law on money bond and pretrial determinations, and removes the individualized determination required to infringe on someone's liberty. A person charged with a crime is presumed innocent and retains a fundamental liberty interest that cannot be impeded based solely on their history with an unsecured bond. The constitutional standard for assessing pretrial status is whether the person poses a risk to public safety or are unlikely to return to court. The mere fact that they were previously arrested and provided with an unsecured bond does not meet this standard. For that reason, I ask you to issue an unfavorable report.
Thank you. Seeing no questions, that concludes our hearing on House Bill 1356. Now we'll have House Bill 1358. Delegate Riley. And it looks like it's going to just be you. Okay, whenever you're ready.
Good evening again, Madam Chair, Bartlett, and members of the Judiciary. For the record, Delegate Teresa Riley, District 35A, here to introduce 1358, Criminal Procedure Home Detention Time Served Credits. When this bill proposal was first brought to me, it was suggested to actually repeal the whole home detention ankle monitor program completely, for it poses a safety concern for the public. However, I believe that was the repeal of the program would be a very drastic change. So in the attempts to try to make some improvements to the program, HB 1358 is attempting to move us one step in the right direction to address and improve the program. This bill prohibits the Division of Corrections, which is DOC, from applying credit for time served to an incarcerated individual on home detention program who willfully violates the conditions of the program, and the courts are required to consider any pending cases of the defendant in determining appropriate conditions on pretrial release. Unfortunately, just recently, we had an individual that was on home detention and violated that home detention and wound up killing 2 of our teens in the state of Maryland. Not only was that the first violation that this particular individual did, but we find out there was a violation before that, and he was on home detention, which went undetected. During that violation, he actually did have a gun and was shooting up and doing everything. Fortunately, there were no fatals in that particular situation, unlike the second. So basically being offered a home detention program is a privilege that one should respect and honor its agreement and keep the public safe. If those conditions are violated, one should not be eligible for the application of credit against the sentence for time spent in custody once he goes into custody. Now, we're fortunate, this gentleman was caught and now he is in custody. But the question is, what this bill would address, should he have good behavior and time credit served on that incarceration after violating his home detention twice and one time fatally. So, thank you, Madam Chair, and the members of this committee, and I respectfully ask for a favorable report, and be happy to take any questions at any time. Thank you.
Thank you, Delegate. Do we have any questions? Seeing none, that concludes this panel. We're going to move on to unfavorable. We have one person testifying, Vanita Taylor.
Good evening, Vanita Taylor, once again from the Public Defender's Office. We're in opposition to House Bill 1358. 1358, in fact, may in of itself be unconstitutional. If you're on home detention, that is detention. You have your liberty at risk. You are not allowed to go anywhere unless the court has ordered it. In fact, the home detention rules, they address where the defendant will reside. It is vetted by the county. They tell when they can have random visits by home detention. They have restrictions that the court will order, such as you can only allow to pick up a child. They may also in home detention put you on urine analysis or breathalyzers or return any and everything that you may have in regards to this to the individual. The court sets the conditions of home detention. But the primary issue of home detention is, which is actually stated in the fiscal and policy note on page 2, is that you must remain in the approved dwelling except to go with the program of administrator's approval to the offender's approved place of employment or medical or mental health, office of public safety, public detention, talk to a lawyer, talk to a medical person. But you are restricted. And in fact, it does save us money because your time on home detention, you must pay for it. Home detention is not paid for by the state. Home detention is paid by the individual on home detention. What this bill does is takes away the discretion of the commissioner in the court to set the terms of home detention and to decide the penalty of home detention if there should be a violation. We heard in the previous testimony from Mr., I wrote his name down, individual who said he had a minor infraction where he arrived in court late, but because of that violation, he was found guilty. This person would not be able to get any good time received because of that one infraction. This creates a double-tier system, and we believe that it's unfavorable.
Thank you. Are there any questions? Delegate Conaway.
Witness for coming in to testify. I don't understand what your argument is about the person that came to court late. I don't understand it. Can you explain that a little bit more?
Sure. The previous gentleman who testified in the previous bill talked about an infraction that he received because he came to court late.
Yes.
And that infraction, he was convicted because he was late.
Sure.
That infraction would make him ineligible to get any good time credit for the time that he served in home detention and afterwards because there was a violation.
Yes. And you're in disagreement with that?
Yes, I'm in disagreement with that. He should get time, he should be able to get his time served credit. Because what you're doing is you're saying that someone who is on home detention cannot get any credit. But someone who is behind the walls can get time credit.
Okay, so if the judge
even if they have an
issued,
infraction.
if the judge would have issued a bench warrant, then that person would have technically, if they were behind the walls, would have been equal to a violation, right?
Yes.
And that would have voided some of the credits?
No, the voiding of the credits is up to the court. There's a determination of the credits and the voiding of the credits, how many credits, what is it for, depends upon the infraction.
Right. So
this bill doesn't do that. It doesn't consider the infraction.
If a person is behind the walls and they have an infraction, does the court determine whether or not the credits will be voided or not?
Yes, there's a calculation done about credits received, how they can be voided, how can you lose credit. There's a whole calculation in the system to credits.
Sure, we worked on the diminution credits for years, so thank you very much.
Thank you. All righty, that concludes the testimony and the hearing on House Bill 1358. We're going to move on to Delegate Moon. House Bill 545. And I am going to start calling up some people. Meredith Gerard. Could you give me your name, sir?
Omani Placid.
Okay. Okay. So Meredith Gerard, Eric Galley, are you me? Oh, you, okay. Let's see, who else do we, and Christopher Dews, yep. Thank you. And that's good. And do we have any of our folks who are testifying virtually around? Sarah Anderson, maybe? Okay, and Christopher Sweeney. Can you have them at the ready, and we'll go ahead and start with the delegate and everyone who's seated, and then we'll go to virtual. Sarah.
Ready? All right. Good evening, colleagues. House Bill 545 is the clean slate bill, or other shorthand would be an automatic expungement bill. And what we attempted to do this year, and you should have an amendment that we sent out, is really try to distill this effort into what is achievable today with minimal cost and actually could be implemented. We are really trying to stand up a process to get automatic expungement moving in Maryland, but one that can actually be done with minimal human interaction. So we do have an amendment, and having spoken to corrections and the judiciary and stakeholders about this, I think we are very close to having something that could be implemented today. So I want to tell you what that entails. So one, it would be only removing records from case search and CGIS, the repository, the criminal record repository. And the judiciary is telling us they can only, at the moment, they believe, easily do this for offenses that are in 10105 of the criminal procedure article, which is those offenses that have a 3-year expungement timeline, waiting period. So it's not it's not a lot of the convictions. It's a lot of non-convictions and crimes that are no longer crimes, some of the easier lift stuff. But the judiciary thinks that today they're able to handle this more or less. Corrections, now that the judiciary has MDEC, corrections can produce a list of the cases judiciary can produce a list of the cases that we asked to be expunged, provide it to corrections, and corrections can then handle those expungements. Only if it's a single charge that is eligible for expungement, or if every charge in the case is eligible for expungement. And with these parameters, it seems plausible that we can stand up an automatic expungement program without having to wait for the new procurement and things of that nature. You will hear in the testimony, there is potentially still some human, someone is getting the list from one of the agencies over to the other and running these queries to get the data out. So I don't want to say there's zero human involvement. And I'm sure if you talk to corrections, they will tell you they are overburdened and have questions about whether they can handle this. But I want to tell you, I think we're pretty close.
Great. So let's start from you, ma'am, and then we'll just keep going on down. Thank you.
Good evening. I'm Meredith Gerard, Executive Director at Shore Legal Access. We are a provider of free civil legal services for people on the Eastern Shore, and we are a proud member of the Clean Slate Coalition. This bill would lift a burden off of people who are already carrying around the stigma of having a record. And what we hear over and over again from our clients is that once something is on their record, it goes with them everywhere. It goes with them into the housing office to get an apartment, into every employment application, to just being a volunteer for the community. You have to get a background check to volunteer for the Girl Scouts. Our clients have shared with us the tremendous relief and lift that they feel from having that record expunged and that they've experienced. For example, a recent client was a mother of 3, and she had charges on her record, not even a conviction, and she needed to get her nursing certification. And so she needed to get that record expunged and had to go through the petition process. We had a recent gentleman who had made a mistake of writing a bad check of less than $300 20 years ago, and he wanted to improve his employment prospects. And we were able to get that done for him through that petition process. I've done many of these petitions myself. They're complicated, it's burdensome, and unnecessarily so. And the truth is, most people don't even take it on. And honestly, as a provider of civil legal services with very limited resources, we would like to spend our time and money on complex litigation that really protects people's rights. So even if this bill were amended to only cover the non-convictions, as Delegate Moon discussed, it would make a huge difference for people in our community. The Eastern Shore communities especially would benefit because there are a high number of people who are involved with the criminal justice system there. Most of our counties have twice the rate of incarceration than the state average. We ask for your support for this bill, and let's not wait to get this done. Thank you for your time.
Good evening. Remember hours ago when I Me Too'd? Does that get me extra time? Madam Chair, members of the committee, my name is Eric Galley, and I'm here today representing Eastern Shore Legal Access and the Clean Slate Initiative, seeking a favorable report on HB 545. Just a few little facts from around the country. This bill has been done in 12 other states now, including blue states like California and New York, red states like Oklahoma and Utah, and purple states like Pennsylvania and Michigan. And all our surrounding states, Pennsylvania, Delaware, and Virginia, have all passed clean slate legislation. You've heard from the sponsor. We've worked diligently with him. We've had meetings with the department. We've had meetings with the judiciary. We've addressed everybody's concerns. And if there are more concerns that come up, we pledge to you that we will work with anybody to fix any problem that they have implementing this bill. And with the amendments, and you've heard about how it would cover all the non-convictions, we think that the bill that's being discussed with the amendments would impact more than 200,000 Marylanders. Perhaps as many as 290,000 Marylanders would suddenly have record clearance. It's a lot of people. And you're going to hear from employers in the next panel that they're waiting to hire these folks. They have jobs. These folks are qualified for them. They're eligible. And they just get dinged at the last moment when they get run through the system. So we think there's a lot of opportunity there. We can fill a lot of jobs, and all of these people would become taxpayers, and we'd have more revenue. So we would also like to stress that the bill doesn't create a new right to expungement for anybody. The goal is simply to automate the process for those who are already eligible. And with that, thank you for your time and attention, and we request a favorable report. Thank you.
Great, Mr. Plessy.
Good afternoon, Madam Chair and committee. Thanks for having me. My name is Omani Placid. I'm a program coordinator at the Baltimore City Health Department at YO Baltimore, a youth workforce development center, and I'm a resident of the 7th Congressional District. I stand before you today to testify in strong support of House Bill 545, a bill that will automate the expungement process for eligible misdemeanors in Maryland. I know firsthand how having a criminal record, even for a minor offense, can derail a person's future. My conviction wasn't for a serious charge, yet it shut doors that should have been open to me. I lost access to gig economy work and was blocked from becoming a correctional officer, not because of who I am, but because of what was on paper. I was lucky, right? Someone who knew me by the name of Tavon Thomas saw me for more than what my past mistakes said and gave me an opportunity to be a youth organizer. Now my job, rather my duty, is to help young people, many who, like me, made a mistake but are trying to build a better future for themselves. But here's the truth. Most of them don't even know that expungement is possible. They don't know that their records could be cleared. They don't have the resources to navigate the process. And even if they do, the cost alone can be the barrier for them. How can we expect someone to afford an expungement when that record keeps them from getting a decent paying job in the first place? A single mistake made at 18 shouldn't determine your entire life. It shouldn't be the reason someone is stuck in a cycle of low-wage jobs with no room to grow. I know my life could have been way different if I didn't have the support that I had at the right time, and that's why I'm here, for the thousands of people who are like me but weren't as lucky. HB 545 is a chance to right a wrong in our system, to remove unnecessary barriers and give people a real shot of redemption. I urge you to support this bill. A favorable report doesn't just change the policies, it changes lives. Thank you.
Christopher Dews, Cornerstone, representing Out for Justice, also member of the Clean Slate Coalition. And we want to thank Delegate Moon for his diligence on this. And after my gentleman to my left's wonderful words, all I have to say is me too.
Okay, we're going to call Sarah Anderson and Christopher Sweeney on, who are testifying virtually. Ms. Anderson, you can begin.
Good evening. My name is Sarah Anderson, and I'm the Associate Director of Criminal Justice and Civil Liberties at the R Street Institute. We promote free markets and limited government with a strong focus on criminal justice and the ways that the current system hampers individuals' ability to live free and prosperous lives. Today, we're supporting the Maryland Clean Slate Act, which would automatically expunge certain criminal records after a set time. The carefully constructed parameters of the legislation and the demonstrated positive impacts that record sealing can have make this bill worthy of a favorable report. Importantly, this bill does not destroy records, but instead shields them from public view while still allowing access when necessary. It would also create a perpetual automatic process for identifying and sealing eligible records. Automation is important, as we know that while 40% of those with criminal records in Maryland are eligible for petition-based sealing, less than 2% of those have obtained one due to the onerous process. The burdens of a criminal record are also significant. For example, an arrest or conviction record reduces the chances of a callback or job offer by nearly 50%, and 94% of employers use background checks when hiring. This makes record sealing, where practical, a smart and necessary policy, especially considering that nearly 1/4 of Maryland's adult population has a criminal record. Research shows that individuals who stay crime-free for 5 to 7 years are no more likely to reoffend than those without a record. Similar laws recognizing this reality in other states have shown positive results, with notable improvements in employment, housing, education, and overall well-being. House Bill 545 offers a real opportunity to improve government efficiency, public safety, and maybe most importantly, lives in Maryland. We strongly support it and encourage the members of this committee to do the same. Thank you.
Thank you. Mr. Sweeney?
Thank you very much, Madam Vice Chair. I appreciate the opportunity to be here this evening. I'm Chris Sweeney with Maryland Volunteer Lawyer Service. And for the past 9 years or so, I've been working there in re-entry with folks who were previously incarcerated and are enrolled in job training programs. And we help them remove barriers to employment. I've represented close to 1,000 people who are seeking criminal record expungement. And there's a conversation that I repeatedly have with my clients where we're sitting down and reviewing their records, and they ask me, what is this doing on my record? I didn't know that this was going to show up. This is something that happened 20 years ago, or I thought this was already expunged. Doesn't this disappear after a certain amount of time? I wasn't convicted of any of these charges. I'm surprised why this is on my record still. I've never been able to really provide a good reason or an answer to my clients when I'm confronted with this question, other than that's simply the way the law is written. But why should it be? We're talking about people who were never found guilty in a court of law, so why should it stay on their record indefinitely? A clean slate bill would eliminate this massive backlog of eligible cases, and note that these are all now going to be cases where the charges were dropped or dismissed by the court. And in the long run, this would free up so many court resources that are currently being devoted to processing these expungement petitions. So at this point in time, the technology is out there. It's certainly possible to do this to the electronic court records. It's time to start automating the expungement of non-convictions. So I thank you for your time.
Thank you. Thank you, everyone on this panel. Are there any questions for the panel? Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. To the last person to testify, did you ask your clients why they didn't get their records expunged as they were charged and dismissed?
Well, to answer that question directly, no, I don't think I've asked them that, but what I have gathered over the years, like many of my colleagues on the previous panel shared, I think legal procedures are intimidating to people. They're confusing. They can be costly if someone has to hire a private attorney to go through the process. It's relatively simple enough for me to do as an attorney, but it's something that...
Are you implying that it's not simple enough for the average person to go down to the court and fill out the application to petition the court to have their null pros expunged? Is that what you're saying?
Not exactly. I think it is probably one of the easiest legal proceedings that one could go about doing.
Okay, thank you very much. Thank you so very much.
Sure.
Thank you. All righty. I see no further questions, so that concludes the testimony for this panel. We have another favorable panel, Nan Gibson, Zachary Alberts, Melissa Rothstein, Mark Woodard, Karen Clark.
Madam Chair, Zachary Alberts is a Me Too. He just wanted you to know
Okay,
that.
thank
Senator
you.
McCombs, thank you.
All righty. So everybody else is a Me Too? All right, next, moving on. No, I'm just joking. Okay. So we got Nan Gibson?
Yes,
Yes,
thank you.
hi.
Yes, Madam Chair, lovely to see you again.
You can, well, we can get somebody else up there. Hold on. Melissa, Mark Woodard?
Yes, ma'am.
Oh, there you are. Okay. Karen Clark, she's not here anymore, is she? Karen? I don't see her. And Trina Selden? Okay. All righty. Heather Warnken? Okay. All right. So, Mr. Woodard, whenever you're ready, you can begin and we'll just continue down. Thank you.
Good evening, Madam Vice Chair and members of the committee. Mark Woodard on behalf of the Job Opportunities Task Force in support of House Bill 545. You've heard testimony today from individuals who have been affected by having a criminal record that's affected their ability to get employment, housing, education. We've also heard testimony today that there's up to 1 million people in the state of Maryland who have a criminal record, and we've heard testimony from Mr. Galley that over 200,000 people would be affected having an arrest record and being able to have that arrest record expunged by this bill. That is not only important to those 200,000 plus people, it's also important to them and to the workforce that they could become part of and to the tax base, which we could all use. So it's not only good for them as individuals, it's good for the workforce and it's good for the tax base, and we urge a favorable report. Thank you very much.
Thank you, Madam Chair, members of the committee. My name is Nan Gibson. I'm the Executive Director of the JP Chase Policy Center, and we appreciate the opportunity to provide a statement in support of Maryland Clean Slate Automatic Record Clearing, HB 545. 1 in 3 working adults in the U.S., roughly 80 million Americans, face barriers to employment due to an arrest or conviction record. They represent a waiting workforce. These are individuals who have fulfilled their justice system obligations but continue to face barriers to opportunity that a record can carry, whether it's access to a better job, education, or housing. JP Chase is committed to giving people across the country a second chance, and we believe business has a role to play in helping more people share in the benefits of economic growth. We're a skills-first employer. In 2023, JP Chase hired more than 3,000 people with records, nearly 10% of our new hires in the U.S., whose history had no bearing on the requirements of the job they were seeking. To achieve this type of impact, we've made changes in our own hiring and recruitment practices, and we are actively encouraging other companies to do the same. We're a founding member of the Second Chance Business Coalition. We work with more than 50 large companies across multiple industries committed to best practices for second chance hiring. You should also have a statement from the Maryland Chamber also supporting this bill. And to achieve, the systemic change that we need improved public policy, including common sense measures like clean slate record clearing. In Maryland, as has been noted, there are over 400,000 people who are eligible. And one estimate shows that across the country, this cost the economy $87 billion. Here in Maryland, we have 575 employees and growing. We serve more than 1.3 million consumer businesses and customers across the state. And we appreciate the committee's consideration of clean slate and urge a favorable report. Thank you.
Thank you. Ms. Rothstein?
I'll just say me too. Okay.
Any questions for this panel? Seeing none, that concludes this particular panel. We're going to move to unfavorable,
I'm John Cox, Deputy State's Attorney for Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association. And I'm very sad that Delegate Cardin's not in the room right now because I looked up the definition of expunge, and it is removing from public information or inspection. But regardless, and I just checked with Delegate Moon. I haven't seen the amendment. There was so much I was going to say about its impact on 10-110, and I'm gathering that that's no longer in the bill, and so I won't address that particular piece. I would also be delighted if he could change the use of the word expunge in the bill, because I'm being told at least that it's a shielding type of thing, other than removing from the central repository, which is more than just shielding. But it's otherwise apparently directed at removing from the public view, and I have absolutely no problem with that. In the pieces of 10-0105, when you're dealing with a null process or dismissal or a not guilty, the part that is not accounted for is probation before judgment, because the bill basically says that it's automatically removed after 3 years, and that in that circumstance, it's gone, but there's no provision in there. It just as an eligible offense, but it may not be entitled to expungement. There is a prohibition on expunging a PBJ if the person is pending a criminal charge or if they've been convicted of something in that time period. I don't envision that the judiciary is going to be doing that research. So here, and as it exists right now, if a petition for expungement is filed, our office looks at it and sees if they're pending any criminal charges or if they're been convicted of an offense, and then they're not entitled, and we have the ability to respond to that. The judiciary can't do that. So I don't know how this is physically able of being accomplished in the form that it's in, unless you remove the PBJ part of it. I'm fine with the dismissals, the null process, and the not guilties. I have no problem with that.
Thank you very much. Delegate Kaufman, question.
Yes, my question is, Mr. Cox, thank you for staying with us all day, first of all. You have testified against a bunch of expungement bills today. But I'm wondering if you can recall the testimony of Mr. Harold Coleman earlier in the day. I think he was one of the first witnesses, where he said he made a poor decision in 1988, and I was only 1 year old in 1988, and I'm no spring chicken. But he said it's still haunting him to this day, so it's kind of like a scarlet letter. So if you don't like David Moon's bill and a bunch of the other bills today, what's your alternative? Because I think, it shouldn't be committing a crime 36 years ago, in many instances, shouldn't be a life sentence. But for Mr. Coleman and other people, it seems like they're still living with the consequences 37 years later. So what's your alternative?
Well, thank you. Let me first say that tragically, I was in my current job in 1988. But regardless of that, and actually, Mr. Coleman and I hope he doesn't take offense to this. We've become friends. We see each other down here every year, and I respect him a lot. And Mr. Coleman's last piece to this is going to be solved by HB 499 with the satisfactory completion of his probation. And so thankfully, he will finally get to a just resolution. I don't know if you were here earlier, Delegate Kaufman, when I made the joking reference, but it's true. I came in here and supported HB 499.
Yeah, I remember.
Okay. And so, and we support the principle as in the statutes as they exist right now. I'm just here to point out the problems that these efforts to change all of that will bring upon the process. And I mean, this one's a very clear one. I mean, the person should not get their PBJ expunged automatically without anybody checking to see if they're even entitled to it.
Thank you. You know, I appreciate your perspective, and thank you again for staying with us all day.
Of course.
Thank you. That concludes the testimony for House Bill 545. We're going to move on to House Bill 621. Delegate Moon, we have you, Melissa Rothstein, and Christopher Dews.
Good evening, colleagues. House Bill 621 is a bit of a technical bill, and it has two aspects of it, but the first one I want to flag is simply updating language on what can and can't be done with expunged records. And the reason why I flagged this is there's just a bit of an inconsistency in state law. When we created the shielding process, and shielding, as was just noted by the opponents, is a lesser process than expungement. Expungement means supposed to be essentially record obliteration, but shielding is still supposed to be kept somewhere and accessible to some people. So it's a lesser process. But when we created the shielding law, we created this list of things you couldn't do with shielded cases. You can't deny, you can't make it the sole reason for denying education, government benefits, and certain other applications. But the expungement restrictions are actually weaker than the shielding restrictions, which doesn't make any sense. We say you can't deny education, for example, for a shielded record, but we didn't move that language over to an expunged record, and that doesn't make any sense. Expungement is supposed to be even stronger obliteration than shielding. So I took the language from the shielding law and tried to move as many of the items over into the expungement law to make the restrictions the same. So that is a technical aspect of the bill. The next aspect of the bill is a substantive aspect, and it's actually one that Claire Rossmark flagged in a question. But when we set about creating the framework for automatic expungement, the test case was cannabis expungement. And so when we did the cannabis legalization law, we said automatic expungement is going to be removal from CGIS, the criminal case repository, and from case search. And the reason we did this was because these are, we were going for all electronic records that we could easily just pull them out, looking for the one marijuana possession charge. What we did not contemplate at the time was that the courts were in the process of building the MDEC system. And so for cannabis expungement, we've pulled those records out of CGIS, we've pulled them out of case search, but I believe they live on in MDEC. And so this is actually, it's a policy question. Going forward with automatic expungements, do we or do we not want these records to exist in MDEC? In the bill that's before you, I suggest we should take them out, but we could also make a policy call to leave them in going forward, but I think we need to make a decision there. So that's the bill.
Thank you. Melissa Rothstein from the Office of the Public Defender. I think much of the reasons why we like this bill is similar to some of what I talked about on HB 777, that in terms of the inconsistencies and the gaps within what it means when something is expunged. And so we're very happy that Delegate Moon brought this bill, and we strongly support it.
Christopher Dews, Cornerstone, Out for Justice. Me too.
Delegate Cardin, you too? No, go ahead.
I just want to, so did you get any information, and we can talk about this later, about how the information's accessed with MDEC? Is it only be able to be accessed by the judiciary? Like, who can access it? I mean, I guess we can go in and look at files
I think
on
it can be
MDEC.
viewed in the courthouse, right? I'm not sure, I'm not a practitioner, so you're asking the wrong guy.
I can go into AIS and I can review, I don't know if that's MDEC, but I don't know what, does the rest of the world besides the judiciary have access to, when you say MDEC? I'm just curious, do we know that?
And honestly, I'm not sure how it specifically applies with expungements, but there's two different aspects of MDEC. There's the attorney file and serve MDEC, and then there's the MDEC public records that anybody can go to and find general information about a case. I think it's, at this point, I think that part of it is more robust in places that have had MDEC longer. You know, honestly, I've never checked there to see what happens with an expunged case. I would assume it doesn't show up because it's a public-facing system, but it is technically MDEC.
Yeah, everything agreed.
Yeah. Okay, we'll talk.
All righty, well, seeing no, Delegate Tomlinson.
I mean, just to kind of follow up. Thank you, Madam Chair. Just going to follow up on Delegate Cardin's question. I mean, at the end of the day, what is the purpose of an expungement? Isn't it to kind of erase all record?
I mean, this is the question, I guess, because again, we were trying to just grab the easily accessible electronic records at the time we did cannabis expungement and say, these are the ones that are getting deleted. And we thought we hit the two that most people are going to care about, their criminal background check and the public website. But again, it just turns out MDEC is the vehicle that a lot of this whole process is being fueled by the existence of MDEC. And so MDEC itself may have trace records, and it's just, you're right. I mean, I put it in this bill because my expectation is we obliterate the easily accessible records that we can and call it a day. But if MDEC is now in that pile, and it is my understanding that the records do live on there, accessible to someone, and we can certainly clarify to whom and under what circumstances they're available. But I do think you're right that we ought to treat it as obliterate when possible.
Yeah, I mean, regardless of the debate on what should be expunged or what should not be expunged, I mean, if the idea is that we're supposed to expunge this, then there shouldn't be any program that still has it.
Fair enough.
Thank you.
All righty. Well, Delegate Moon, thank you very much. That concludes the testimony for House Bill 621.
Thank you.
Thank you. We're going to move on to Delegate Crutchfield, House Bill 1198. And so I saw Monica Cooper. Yes, come on down.
Yep, Monica's here.
Matan Zamer.
Yep.
And Muse Igyor.
Good to see you. Same.
Muse Igyor. I might be mispronouncing your name. I'm sorry. Beth Tomasello.
Yep.
Benita, I saw you, and Shanice. Okay, so can you, we're gonna pull in Catherine O'Malley if she's there. All righty, Delegate Crutchfield, whenever you're ready.
Okay. Important stuff. All right, good evening. Close to the last bill, right? All right. I know you got the last one, right? So for the record, I'm Delegate Charlotte Crutchfield. I represent Montgomery County's District 19, and I'm here to testify in support of HB 1198, which is also the Monica Cooper Act. Act. Monica Cooper's right here. So, you know, colleagues, back in 2021, we made a promise because we actually passed some legislation to try to, build a pre-release unit for women in the state of Maryland, remembering that men had pre-release units separate and distinct from their facilities. We tried to do that with our women as well. We, in fact, had a description where it should be. Zip code-wise, it was to be in Baltimore City. We had details about the programming. But here we sit, 2025, and it's still not built. In that original act, it was supposed to be completed and operational by June of 2023. But again, here we sit, and it is not. That is my problem, and I hope you guys will help to resolve that problem, because once again, that is why I'm here, because we need to do something about that, okay? The Department of Department of Public Safety and Correctional Services has dragged its feet for these last couple of years, in particular, because by now they should have at least had the design of the pre-release unit. They should have at least had the location that we could seriously consider for the pre-release unit. But that is not what is going on right now. What they have right now is a location in Baltimore City that is adjacent to the Baltimore Detention Complex, which we know is where there is a lot of drug trafficking, sex trafficking, all kinds of things that are there that would be hindrance to any person to be successful when they are coming out of being behind the walls. And that is a problem. So what I want to do and what I want to say here is that this bill is to try to put people straight, on what the pre-release unit should look like. Put people straight on what it should look like as far as the programming there. Making sure that it is done correctly, because that is what we need right now. Again, like I said, just let it resonate with you. This is pre-release. Pre-release is all about helping people come out of I want to say almost a situation where they have been in lockup for long periods of time, and they now need success. They need to have the tools to be successful, and that is what the pre-release unit is supposed to be about. And that is why I am attempting through this legislation to set the record straight on where it should be, what it should look like, and I need your help on this. So I hope you will provide a favorable report on HB 1198, and I have tons of folks to help me to convince you of that. Thank you.
Thank you. So the young lady on the end.
We're going to go with
Can you tell me
Monica
your name? I just need to get her name.
Okay.
Shanice Anderson.
Oh, who's Shanice? Could you just raise your hand for me? You're Shanice Anderson. Okay, thank you. So you said you want to go with Mateo first?
No, with Monica. So we're going to go kind of down this way and then come back.
All righty. Thank you so much. Monica, whenever you're ready.
Thank you, Vice Chair, and thank you, committee members. I'm tired. I am tired here today, and I'm tired of just keep fighting for what we know is the right thing to do. I know that everybody knows this. That's why it passed with a consensus that it's right. And I'm just tired that nobody, well, I won't say nobody, but there are some folks who obviously don't have the will to see this done. But you guys can do that. You guys can say, hey, guess what? We might be tight on money, but we have to get this done. To have us keep coming back and do this year after year after year is senseless. I am an impacted young lady. I know what it is like to have a mother that I wanted home with me, helping me with my homework. I know the juvenile delinquent decisions that I made because she wasn't there. This is an opportunity for us to send those mothers back into the home. There's such a correlation between juvenile violence and the missing mother. I know kids need their fathers, but that maternal hand is unmistakably missing. I feel that. I can share that pain with you guys. I'm always opening up to you guys. I might charge you guys, be my therapist. But I am willing to open myself up to the vulnerability of an impacted child that needed my mother. My mother needed resources. We have an opportunity to give the women resources, and I promise you, you will save on the back end. You won't have to worry about the juvenile violence because that mother will be in the home, healthy, recovering from her addiction. Family reunification, those things we need. We can't, this stuff, there's no price tag for this. Think about your niece, your cousin, your sister, and all of the people that you know that made a mistake and that have lived a life that's contrary to what you think they should have done. But everybody deserves a chance. Our children, our communities, I promise you, if you pass this in 20 years, you're gonna say, Monica, you were right. And thank you.
Pass it down.
All right. Good evening, Vice Chair, members of the committee. My name is Matan Zemmer. I'm the Maryland Policy Director at Jews United for Justice. Honored to be here alongside our partners in the Women's Pre-Release Coalition and our champion, Delegate Crutchfield. Thank you for continuing to follow this forward and ensure that we move this thing forward. Honestly, I'm mostly just sorry that we're here. I'm sorry for you all, I'm sorry for us, but most of all, I'm sorry for the incarcerated women in Maryland who continue to be denied essential services that we know for a fact will help them return to their communities, will help their families, their friends, will secure jobs, education. These are all evidence-based things that are unrefutable, and they continue to go completely denied of these services and are not being treated with dignity, being held in a maximum security facility where claimed pre-release services are being provided, of which, if you look at recent reports from the department itself, women are not participating in because these programs are failing, are not sufficient. Women aren't able to access job opportunities outside of the facility, which we know is one of the many essential components of pre-release, effective pre-release, is the ability to leave the facility, go find employment, and have that employment once their time is done and they are released. I could go on and on here. I think that, I want to just highlight, I first got to know the women who have been leading this effort for many years, actually when I was a staffer for Senator Mary Washington, and got to work on the original legislation. It has now been many years since then, unfortunately. But I just have to say that the continued dedication to see this through. We've been, as a coalition, testifying before the budget committees year after year after year, trying to use that tool to hold the department accountable to actually move this thing forward. And we are back again with this legislation to say there are things that we can fix that will ensure this gets back on track, and really appreciate your attention to this. Thank you.
Good evening, Madam Chair and members of the committee. I'm Beth Tomasello, past president of the Montgomery County Women's Democratic Club, and we have been a proud supporter of the Women's Pre-Release Equity Coalition since 2019. WDC strongly supports HB 1198, the aptly named Monica Cooper Pre-Release Act, and we thank our own Delegate Crutchfield for her leadership on this bill. The coalition has provided detailed written testimony, but I'd like to highlight some important ways in which HB 1198 will produce better outcomes at lower costs than DPSCS's plans for the Women's Pre-Release Facility, because we know money is tight, and so we need to look for the best outcomes for the money to be spent. So first, the Department of Legislative Services capital budget analysis confirms that the 64 beds that the department has planned for are not enough. And if the women cannot move to the pre-release center, they will stay at MCIW, deprived of services at an annual cost of $48,700 per woman, nearly double the cost of pre-release. Second, because the site is too small, DPSCS is now planning to build a 3-story building, which is increasing the cost by over $8 million. And DLS has also questioned the cost estimates, given that the additional delay will likely bring even higher construction costs. But more importantly, women who remain at MCIW, whether because the facility is delayed or because the bed capacity is too small, they're deprived of the opportunity for outside employment. And studies show that when individuals are placed in outside employment, during their pre-release period and then gain full-time employment after they're finished, the one-year recidivism rate drops to 9% and the three-year rate is 16%. And this stands in stark contrast to Maryland's abysmal and costly 41% recidivism rate. Furthermore, studies have shown that for every 100 formerly incarcerated individuals who are working full-time, nearly 2.7 million in income and sales tax revenue are generated. And I think I'd just like to say, I don't think we can even quantify the downstream costs that Monica was talking about for women who are going to be getting programming at the Baltimore Therapeutic and Treatment Center, which is not geared toward their needs. So we just thank you for your time and hope for a favorable report on this important bill.
Thank you.
Good evening. Vanita Taylor from the Public Defender's Office. It seems like I was here about 15 years ago when we first started talking about gender equity with the Department of Corrections. We started with young girls at the juvenile centers, at Waxters in particular. We started talking about the fact that women received the facilities once men got new ones, and all they did was paint it pink. I'm here again now in 2025, and I'd like to say justice delayed is justice denied. Women in Maryland have been denied equal justice and equal services who are involved in the Department of Corrections. I looked at the fiscal bill and I saw that it says that they've spent $9.9 million, $2 million in general funds and $7.0 million in general obligation funds for the project. I'll have to say, I've asked all the women involved in the coalition, have we seen anything from that money? Where is that $9 million? I haven't seen a brick, haven't seen an architectural design, haven't seen property purchased, haven't seen real services put in place for women. We haven't seen anything tangible. This is a direct violation of what this committee and what this legislature has said should be done for gender equity in Maryland. Nothing has been done. And every day we delay it, every year we put it off, the cost is going to go up. It is not going to go down. It is going to go up. We strongly say that we believe that this bill should be implemented, that there is no reason why we should have 9 pre-release centers for men in the state of Maryland and none for women. That is abysmal. And we should be ashamed that we are not holding the Department of Corrections feet to the fire and saying, 1, what happened to the money? And 2, why has this not been built?
Thank you. Next.
Good evening. My name is Mwese Igor. I'm a social work supervisor at the Office of the Public Defender. I supervise social workers that work in every jurisdiction in the state of Maryland, whether it's in juvenile court, district, circuit, or center court. Women who return to their communities, our communities, your districts, essentially need gender-responsive care. They need trauma-informed services. They need services that can go on once they actually leave a facility. They need services that will be able to connect them to health care, that will connect them to whether it's expungement services, education, and reunifying with children. These women are not just women. They are our sisters, our mothers, our aunties, our cousins. They are our friends and our daughters, and they need services that speak specifically to them. In my social work career, I have done much research on women's barriers to reentry, so it is very important that women have gender-responsive services. There are social workers that are working around the state, not just in the Office of the Public Defender, but we're literally piecing together services, trying to make it work, attempting to make reentry plans that just aren't sufficient enough because the services, because the facility doesn't exist, and because the services are so far that it literally impacts them actually reentering. These women want to participate in their lives, in their families, in their communities, and we're just simply asking you to assist us in having that happen for them by giving a favorable report. Thank you.
Thank you. And Shanice, I hate to use your first name. Is it Johnson? What's your?
Anderson.
Ms. Anderson, we're going to have to move in because we usually 5 is usually our maximum. Or either you all can switch places. If you could do that, please. Okay. Yeah. Perfect. Thank you. It's just for the camera so they can see you.
Thank you and good evening. There are multiple pre-release centers across Maryland that provide job placement, life skills training, health care, and mentoring, as well as case management to incarcerated men currently. There are absolutely none for the women. I established and oversee the Community Engagement Reentry Project with the Public Defender's Office, where we connect with the pre-release centers for men and work collaboratively with institutions' case management teams to provide linkages to additional resources for incarcerated men within the community. This helps to foster sustainable reentry and gives hope and promotes independence. We would like to assist women in the same way. The provision of a women's pre-release center is long overdue. Incarcerated women desire preparation, and it should be accessible. Connection to family pre-release, connection to employment pre-release, connection to opportunities pre-release, and community pre-release are actual implementations that will reduce recidivism. Finally, previously incarcerated persons are taxpayers. Some work for nonprofits, raise children, or city and state employees. Successful reintegration is possible and can be accessible for women with the passage of House Bill 1198. Funding should be reappropriated. For these reasons, we are in support and ask for your support for House Bill 1198.
Thank you. So we're going to move to Catherine O'Malley, and then we're going to come back to you, Ms. Shelley, because you're listed as favorable with amendment. Okay? So Catherine O'Malley.
Good evening. I hope everyone can hear me. I'm at the hospital, at my dad's hospital, where he's getting care now, and I'm on a hotspot, so I'm hoping I get through to you all.
Yes.
I am Katie O'Malley from the Women's Law Center. I'm the executive director, and Vice Chair Bartlett, thank you so much for hearing from me, and I commend Delegate Crutchfield for sponsoring this super important bill. I will meet to all of the things that this great group of people have talked about and why it is imperative that we have women's pre-release. Most importantly, incarcerated women in Maryland who have earned pre-release status deserve equal facilities and programs as men, which is required by our U.S. Constitution and the Maryland Equal Rights Amendment. The Women's Law Center strongly supports the advocacy of the Women's Pre-Release Equity Coalition and the original sponsor, Senator Mary Washington, and again, Delegate Crutchfield's efforts to reduce this crisis in a manner that is sensitive to both the unique trauma and also the risks faced by incarcerated women. You know, Monica Cooper said it most eloquently. She deserved to have that mother. All of us here in the state of Maryland, all the taxpayers deserve to have women get the same services as men when it comes to pre-release services. And it's just such an injustice that we have not had this service for our incarcerated women. So I urge a favorable report on House Bill 1198. And again, thank you all for hearing from me tonight.
Thank you. Is Melody Mitchell in the online? Is she available? No. Okay. So we're going to go ahead and if anyone has questions, I see Delegate Simmons. Do you have a question, or is that Delegate Schmidt? Okay, Delegate Schmidt.
Same thing, same person. My brother. Thank you, Madam Chair. And Ms. Cooper, thank you for your testimony. I really appreciate you being here. I talked to you in the hallway for a brief minute out there. You brought up some statistics that were alarming to me, and I did some research. Is it correct there's 5 pre-release centers for men? Is that correct? 9? Okay, I see 5 here. Okay.
Yes, it's 5.
Okay. Where would you build the center if you could build the center?
Wow, are you going to name it after me?
We have a bill named after you.
Put my name on a building. I would build it as someone who was once in the pre-release center that now works for Baltimore City State's Attorney and have had a wonderful journey thanks to those resources that I got while I was there. I would build it in a place that's accessible to Metro, because what happens is you have to have it in the place where people can get to and from their jobs. I would build it in a place where you have religious volunteers that are willing to come in, a place that's accessible, Bon Secours, University of Maryland, Johns Hopkins, where these people who volunteer and provide services and have programs already implemented would simply be 20 or 30 minutes away from providing this care. So I will build it in a place where you have accessibility to jobs, accessibility to transportation, accessibility to worship, and accessibility to non-governmental agencies that are willing to come in and do a phenomenal job like they did with me.
Thank you for that answer. You know, I wouldn't be here today if it weren't for my mother, so maybe we'll name it after a
Moms
mom,
are awesome.
a mom or two. There we go.
Moms are awesome.
That's
Yes.
right. Thank you for being here.
Yes, sir.
Thank you. Great. All right, so we're gonna conclude with this panel, but we're gonna move on now to, you don't have to go anywhere unless you're ready to move. Unless you're ready to move. Because I have a feeling that, I mean, it's just, anyway, you stay right there, stay put. Favorable with amendment. Dana Vickers-Shelley.
Thank you, Vice Chair Bartlett. I'm Dana Vickers-Shelley, Executive Director of the ACLU of Maryland, speaking in absolute support of the Monica Cooper Pre-Release Act to make sure that Maryland women receive equitable pre-release services at a facility dedicated solely to their success so they can return successfully from incarceration to home, to family, to community, and to the workforce. Every day, the Women's Pre-Release Center is neither built nor open nor in an appropriate place operating. The state of Maryland is at risk of violating both the Equal Protection Clause of the 14th Amendment to the Constitution and, as Ms. O'Malley said, the Maryland Equal Rights Amendment. Women incarcerated at the Maryland Correctional Institution for Women are still not receiving meaningful pre-release services equal to those provided to Maryland men who are incarcerated. And you heard that number correctly. There are 5 pre-release centers for men who are inside across the state. There were more prior to the pandemic, and women still have none. As Judiciary Committee members consider their support, we would ask, are any men required to obtain pre-release services in a co-ed environment? How is obtaining pre-release services with men gender responsive? And third, are men who are incarcerated required to obtain pre-release programming with people who are only in short-term detention and who are not being reacclimated into society after long incarcerations? The double standard is just wrong. We all know it, and it's not equitable. As you deliberate again, we hope you will make a fair and consider fair and equal treatment a priority so that Maryland women can return home successfully and return to community and success. Thank you so much.
Thank you. Do we have any questions for Ms. Shelley? Seeing none, that concludes our hearing for House Bill 1198. Thank you very much for coming down and testifying.
Thank you. Thank you. Thank you. I just want to say it was all worth it. To see J.P. Morgan Chase sit here and advocate for reentry, it was worth it.
That's right.
Thank you. Never thought I'd see the day.
All right, Delegate Taylor, come on down. No time for hugs. No time for hugs, Delegate Taylor. You got daylight hours.
That's right.
Or whatever the expression is. All righty, so Delegate Taylor.
Yes.
How are you?
I'm perfect, thank
Great.
you.
Well, it's good to see you.
Yes, thank you. All
So
right.
I'm assuming we've got Megan McDermott, I see Melissa, I see Christopher Dews, I see, do we have Martin Mitchell virtually available? Okay, so let's begin. Delegate Taylor.
Thank you, Madam Chair. And for the record, I am Delegate Kim Taylor, representing Prince George's County's District 23. House Bill 610 seeks to correct a problem faced by Maryland legal aid and pro bono attorneys who work or volunteer their time during expungement clinics. I decided to pursue this legislation while attending an expungement fair in my district. During the fair, I sat down with a couple of the attorneys and asked if there were any particular expungement challenges that I could potentially address through legislation. The attorneys shared with me that occasionally a client will show up to an expungement fair in Prince George's County with qualified expungible offenses, but his or her record reflects a case terminated with no finding or a no finding disposition, neither of which are in statute. So, in these cases, because Maryland's current expungement law outlines specific criteria for removing court records from public access, the attorneys are unable to expunge the client's charges. House Bill 610 makes a technical fix, eliminates a barrier, and allows Maryland's expungement system to work as intended. With that, I urge a favorable report and look forward to questions.
Christopher Dews, Cornerstone Government Affairs, representing Alfred Justice. We strongly support House Bill 610. As the delegate already mentioned, it is a technical fix. We thank Delegate Taylor for her work on this, for discovering this issue, and also turning it into legislation. It's not a very small thing. This is an interesting bill as it involves a designation that simply does not exist. I have the pleasure of currently leading the Maryland Expungement Coalition, and when this issue came to me, I looked it up and there was nothing because it doesn't exist. Doubling down on that, if you read the fiscal note and the policy note, you'll see that it's just an explanation of expungements and no interesting information about no finding because it doesn't exist. So I just think that that's an interesting thing. This was done because the no finding dispositions were doled out before the passage of the Justice Reinvestment Act, primarily before expungements were made widely available from our understanding. So that being said, this piece of legislation simply codifies this disposition, puts it into statute in a way that it will now allow individuals with these charges to be expunged, but our two technical experts on the side will dive into the rest. Urge a favorable report. Thank you.
Thank you. Good evening to the committee. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid, where I supervise the bulk of our expungement practice. House Bill 610 would allow no finding and case terminated without finding dispositions to be expunged. These dispositions function as convictions, but because they're not typically used in Maryland, they were never incorporated into the expungement statute. So why do we care? Why are we talking about these dispositions that are not part of Maryland law? It's because thousands of Prince George's County residents are faced with the bizarre roadblock to expungement. For decades, these individuals were asked to plead nolo contendere or no contest in criminal proceedings. Usually in Maryland, such a plea would result in a guilty disposition, but in these cases, a no finding or a case terminated without finding disposition was entered instead. This practice went on for about 30 years, likely in an attempt to give folks some relief from being associated with a guilty disposition. However, as Mr. Dew said, since that time, Maryland's expanded its expungement statute to include convictions, and the tangible impact of expungement greatly surpasses any positive gain from receiving an obscure disposition. And so Prince George's County individuals who in effect received a guilty, served sentences, and are otherwise eligible for expungement have been left behind without access to expungement. It's clear that this is unfair. People should not be penalized because of a rogue legal practice, no matter how well-meaning it was. House Bill 610 would allow cases with these specialized dispositions to be expunged using the same standards as convictions in the expungement statute. Please report favorably on House Bill 610, so all Marylanders have equal access to expungement. Thank you.
Thanks. I'm still Melissa Rothstein from the Office of the Public Defender. I'm not going to reiterate some of what Mr. Dews and Ms. McDermott said, but I will add that that at OPD we estimate that there were more than 600 of these no finding dispositions a year, totaling more than 15,000 cases that should be available for expungement but are currently denied because of this non-existing disposition. This bill does not expand the type of cases available for expungement, nor does it alter the timeframe from when a conviction can be expunged. Rather, it allows Prince George's County residents to have the same eligibility for expungement as other Marylanders, regardless of how the judge accepted their guilty plea. We urge the committee to issue a favorable report and thank Delegate Taylor for bringing this bill.
Thank you. Ms. Rothstein, you said 6. I couldn't hear the rest of the number. 6.
Right. I mean, honestly, a low estimate. I spoke with folks in our Prince George's County office who had been there since the early 90s. This is an issue that came up between the early 90s through 2019, and thought there were about 600 per year.
600. Okay. All I heard was 6, and I couldn't hear the rest because something happened. Okay. We're going to go to Delegate Williams.
Thank you, Madam Chair. And thank you, delegates, so much for bringing this bill to really fix this technical thing. And you kind of touched on kind of my question that I had, Ms. Rothstein, about kind of the time frame of these cases, and that these are much older cases where these individuals have been out for a while. You know, they have been productive members of society since they were convicted of these charges going all the way back to like the early 90s, 91, 92, 93. And therefore, granting these individuals these expungements would basically be more of a benefit to society than a harm to society. Isn't that so?
Yes. I mean, I will say this went from the 1990s through 2019. However, I would also add that this was something, I mean, that quite candidly came from, it was done by an individual judge who is in doing it with the intention of providing something that was going to be less onerous than a conviction.
Right.
So the intent was for this to have less of the consequences than a conviction. At that time, a conviction could not be expunged. Now it can be expunged, and so something that was supposed to be a benefit is actually more of a hardship.
Thank you.
Delegate Kaufman.
Yes, Delegate Taylor, I noticed that MCASA, Ms. Lisa Jordan, is listed as unfavorable, and I was wondering if you had to, if you've talked to her or plan to.
I can certainly talk to her. I'm not sure why she's opposed. Maybe you know better, but I think, like we heard back from some informational testimony, I think from the Judiciary, is that this is a little confusing unless you hear the whole story, right? So I believe if I had a chance to talk to her, that she would understand what the impetus is for this bill and why we're bringing it. And a lot of it has to do with they can't find no finding. Well, that's the very purpose of the bill, is because it doesn't exist in the statute. And that could be the bottom line to her objection.
No, I get it. I would just recommend talking to her.
I will. Thank you.
Delegate Embry.
Thank you. Thank you for bringing this bill. I'd never heard of it. I've not practiced in Prince George's County, so. I just wanted to clarify the second part 2, which says included in a case that was designated by the court as having been terminated without finding. That means you could expunge just the charge that qualifies in the section above. Is that correct? But not charges that don't fall within. I was just curious for the reasoning for that. Included in a case that was designated by the court.
I can hardly hear you.
Oh, I'm so sorry.
I'm sorry. I don't.
The last section of the bill, it says included in a case that was designated by the court. Is that getting at a expungible charge, even if the entire case is not expungible? Or what is the purpose of that?
Yeah, I think there were those 2 designations. One was no finding, and the other one was case terminated without finding.
Oh, I'm sorry. I understand it's late.
Yeah.
I apologize.
No worries. Great question. Thank you.
No.
Okay, we're gonna, Martin Mitchell is online now. He is favorable. Let's go ahead, Mr. Mitchell, go ahead and testify for 2 minutes, and if anybody has any questions, we'll ask you as well. Thank you.
Appreciate it. Greetings, Chair and members of the committee. I appreciate you guys for taking up this issue. My name is Martin Mitchell. I'm the former at-large councilman for the city of Laurel and an active NAACP member. But today I'm here as a dedicated advocate for criminal justice reform and a community organizer with Life After Release. Life After Release is a community-based reentry organization in Prince George's County, helping our brothers and sisters who are returning home and some while still in a carceral state. LAR is an organization that helps with court support, mutual aid, and providing a community of support and resources for our clients. Over the past 3 years, I've hosted about a dozen pre-expungement clinics to help individuals clear their criminal record and or traffic record. I have heard firsthand seen that expungements can help people go from retail jobs to the medical field because of an expungement. In my work with Life After Release, I have seen the impact that an arrest record without a conviction can have on individuals seeking to rebuild their lives. Many residents, especially in Prince George's County, are caught in a legal limbo due to the no findings designation, a status that is not explicitly defined in statute but still appears in background check forcing individuals to disclose it to employers, landlords, institutions of higher education, and others. SB 649 is a necessary and overdue fix to our expungement laws that would allow charges labeled as no finding and will be treated in alignment with dismissals, acquittals, and ensuring those who were never convicted are not unfairly punished. Research indicates that expungements can help reduce the likelihood of reoffending as individuals with cleared records have better access to employment and other stabilizing resources. This bill would therefore not only benefit individuals directly affected, but also enhance public safety by supporting the successful reintegration of individuals into the community. I urge a favorable support of SB 649. Thank you.
Are there questions for the panel? All right. Seeing none, thank you all very much.
Thank you.
That concludes the testimony on House Bill 610. Now for the last bill of the evening, I'm going to begin with the first chapter of War and Peace. Brian Frank is on, okay. Mr. Plout, Mr. Boston, come on up. Christina Marquez?
I'm here.
Oh, you're there too, correct. All right, good. All right, so I will present the bill. It's House Bill 1125. I'm going to be relatively brief. It seeks to alter the charge of the work group that we passed last year related to private home or home detention monitoring. And the bill seeks to add a data collection requirement, including gathering the policies and practices that apply when a person violates a condition of home monitoring, such as absconding from monitoring. It also asks for specific data about the number of people who are placed on home monitoring, disaggregated by race, gender, jurisdiction, and the company that they're using or the agency that they're using, and the number of times a person on home detention monitoring violated a condition of home detention monitoring. The idea largely being that we should begin to gather more data and get more information regarding home monitoring, particularly as there's been greater interest to find ways to fund electronic home monitoring. And with that, there are several people who are here who are favorable with amendments, and we will hear from them. And I'll start with Christina Marquez, who's in her car, not operating her vehicle. We'll start with her. You're muted. There we go.
Okay, can you guys hear me? Okay, I am not operating my vehicle, and I will start by saying good evening, Mr. Chairman and committee. I know it has been a very long day, so I will make this as brief as possible and then take any questions that you have. As Mr. Chairman, we had talked a little bit earlier today, and there really is no pushback to the bill. I support HB 1125, but I do believe that an amendment in terms of the notification of law enforcement is needed. We have several notifications that we have to give to both the court and law enforcement as the current bill stands, and I'll briefly explain them in case Those aren't really aware of what they are. There's an immediate notification, which happens to be an exclusion zone. So if somebody cannot go into a zone or has a protective order, a stay away order, we must immediately notify law enforcement and the court that they have entered that zone. There's then a 1 hour alert, which is a tamper. If they let their battery die, or if they have tampered with their device in any way, cut it off, strap the band, things like that. Everything else falls under a 24-hour notification. And right now that has to go to the court and it has to go to law enforcement. But 24-hour notifications could be schedule changes, missed payments to their home detention, not checking in 3 days after their scheduled check-in, going to the hospital and not supplying a timely hospital slip. There are all types of ways that they can violate home detention, and we do notify the court of these, but law enforcement is getting flooded with these daily, and it really, there's this fear in me that we risk them missing something that is more immediate, that they can actually act on. Go ahead.
No, that's fine. If you want to wrap up quickly, we'll go then to Mr. Frank.
I agree with the immediate and the 1 hour notifications. I think they're needed. The police can actually go out and respond to those things. Anything else under the 24, they need a court order from a judge, so they're not able to act on it. And if they're not able to act on it, I'm fearful that it's going to flood their system for the ones that they really should be acting on that do pose an immediate threat.
So committee, just very quickly, the bill itself talks specifically about the work group. What Ms. Marquez is asking for is an amendment that addresses the issue that was an issue that is in what was Senator McCrae's bill last year that requires notification of law enforcement and the courts depending on the kind of call it is. And so they have a specific amendment they'd like the committee to consider, and they're going to provide that to committee staff. So just putting that into context a little bit. Mr. Frank, for 2 minutes.
Good evening, Mr. Chairman and Judiciary Committee. Thank you for the time. We are in support of the bill offered by the chair. We believe with the work group that the best practices can be developed. What we have found is in practice, there's a whole lot of different ideas as to how things should be done in each jurisdiction. The work group is a great idea to bring together stakeholders to deal with it. As Ms. Marquis said, one of the practical issues that we encountered was notification for situations that were what I've defined as garden variety, where law enforcement is burdened by any such notices. They can't do anything about it. There's a cost to collecting, collating, retaining, processing, and keeping any of those notifications. There's other situations that arise, but just by way of example, Baltimore City has proposed a 22-question email be submitted in each violation situation. We believe that that would not only be unproductive for them, costly, but it also will perhaps cause an oversight on the part of the most critical of the violation notices, which are the exclusion violations and instances where there are tampering or efforts to no longer be monitored by not charging your battery or trying to camouflage the signal. So again, we're very supportive of the work group. I have sat in on both of the meetings and we look forward. Thank you.
Good evening, Mr. Chairman, Madam Vice Chair, members of the committee. A lot of the points I wanted to make have already been made. So basically, Senate Bill 468 was the home detention monitoring notification bill that passed last year. There's an amendment that we wanted to, and I did submit this as written testimony, It would essentially address what Ms. Marquez was speaking to. The requirement, so it breaks it down into 3 different categories: the immediate, the within an hour, within 24 hours, and the 24 hours pretty much encompassed any, as Brian said, garden variety violation, and the amendment will just strike, put brackets around having to require the notification to law enforcement. That's pretty much what the amendment would be. And then Mr. Chairman, in your bill in 1125, on line 26 to 27 on page 3, we feel that isn't necessary, because this would, in conjunction with what our amendment is, that you wouldn't have to report the number of times that there's a violation to law enforcement, perhaps for inclusionary and tampering violations, but not for this specific. And with that, I'll ask for a favorable report with our amendments. Thank you.
Mr. Chair, members of the committee, I'm Frank Boston III. We're here on behalf of your bill. We support with amendments. And my client is A1 and ASAP. Testimony's all been said. How do you all feel about a steak dinner tonight? Every person.
On the bill.
That said.
Are there questions?
That said, we will work with the committee on the amendment. It really makes sense. Ms. Marquis and Mr. Frank articulated the points very well. I mean, the minor violations, late from work because, the accident or the bus, or you had to rush to the hospital. The police officers don't even want to hear from that. They're giving us the non-emergency numbers. And in your bill, the actual bill we're here to talk about, the section that I already highlighted could be limited to the exclusionary zone, which is immediate reporting, and the tampering, which, you cut off your bracelet or you let it run dead, which is within 1 hour. That reporting to the police should be the exact same time of reporting to the court in those sections, because it should be congruent. So with that, we stand for questions. I know you have a whole bunch.
Any questions? The Vice Chair.
Come on, y'all, push the buttons.
A little late. No, you're all done now. You all, no. No. You're really out of practice.
We'll talk about it later, right?
Great. Thank you all. Unless you actually have a question, Delegate Grammer's not even here and he has a question. Seeing no further questions, that concludes the testimony on House Bill 1125. Thank you very much. That concludes the business of the committee for the evening. We will be voting tomorrow. We will be voting prior to bill hearings tomorrow. There are 88 witnesses on Wednesday. There are only 28, however, on Thursday. So you can count on a voting session early in the afternoon that day too. All right. Thank you very much.
Thank you.